Ladies and gentlemen, welcome to a conference of Shaping the Future or Being Shaped by It, Competition and Industrial Policy and Innovation. Now we would like to invite Mr. Jeffrey A. Mann, President and Founder of International Center for Law and Economy, to give us an introduction remark. Please.
Thank you. Is this mic working? It is. Great. Well, good morning, everyone. Welcome to our conference on Shaping the Future or Being Shaped by It, Competition, Industrial Policy, and Innovation. I want to begin with a very sincere and heartfelt thank you to our esteemed co-host, the Taiwan Fair Trade Commission. Their commitment to fostering rigorous, open-minded dialogue is precisely what we need to advance our collective understanding of these complex areas. We're particularly honored to have Vice Chairperson and Acting Chairperson Andy Chen with us, along with Commissioner Yalun Yen. We eagerly await hearing from you. So now we gather at what is inevitably described as a pivotal moment. To be fair, in technology policy, pretty much every moment is deemed pivotal. Nevertheless, it's certainly true that we're witnessing a veritable explosion of technology regulation across the globe. From the EU Digital Markets Act, the EU AI Act, the EU Digital Services Act, and on, to similar ex-ante enforcement regimes in the UK and Japan and elsewhere, and being considered elsewhere, to ongoing crusades in the United States to rein in the technology giants, to China's evolving competition frameworks. It's definitely a time of change and a time of regulatory explosion. And all of this has been accompanied by a renewed, almost romantic interest, a belief in the power of industrial policy, which promises to steer innovation from the top down. At ICLE, we believe in the framework of law and economics, and the analytical framework of law and economics suggests that such developments warrant careful scrutiny and maybe even a healthy dose of skepticism. Theorists, after all, can always find a market failure somewhere. The real world is, quite inconveniently, a bit messier. The translation from theoretical possibility to practical policy prescription requires careful consideration of real-world dynamics, institutional constraints, and an understanding of the comparative competence of markets versus regulators in addressing complex coordination problems. Good intentions are a notoriously poor guide for policy, and the unseen costs and unintended consequences of efforts to tame the market sometimes tell a very different story from the one that's promised. Which brings us to our central question: how do regulation, industrial policy, and antitrust shape technological change, and how are they in turn shaped by it? Our choice of Taiwan for this discussion is, of course, no accident. As home to the world's leading semiconductor manufacturer and a linchpin of the global technology supply chain, Taiwan embodies the complex interplay between innovation, competition, and geopolitical strategy that defines our current moment. Nowhere are the tensions between economic efficiency and national security, or between global markets and domestic policy, more palpable than right here. And over the course of the day, we'll tackle these issues head on. First, we'll explore whether today's industrial policies are truly sophisticated tools for correcting market failures, or if they risk becoming mechanisms for subsidizing politically favored firms at the expense of taxpayers and consumers. We'll also consider what are the economic costs of pursuing the sorts of domestic policies that industrial policy might advocate. It's not to say that the trade-off isn't worth it, but we should at least measure it. And next we'll dive into the concept of dynamic competition. Everyone agrees that innovation is what truly matters for long-term consumer welfare, but incorporating that reality into antitrust analysis remains a challenge. The goal is to avoid the timeless trap of favoring promoting the interests of competitors rather than the competitive process itself, which is particularly difficult when taking account of dynamic competition, which is so hard to measure and in some cases even to identify. And finally, we'll look at the future of global antitrust standards. The consumer welfare framework has, for decades, provided a pretty remarkable degree of international convergence, creating a predictable environment that has at least coincided with, if not helped to cause, lowered transaction costs and fueled growth. Now, as new goals and national priorities emerge, we have to ask whether this foundation is eroding, and if it is, whether what's replacing it is worth the candle. we're incredibly fortunate to host an exceptional group of speakers representing diverse jurisdictions and perspectives from across East and Southeast Asia to the US and Europe and beyond. Your presence here demonstrates the global significance of these issues and the importance of cross-border dialogue in addressing them. To our academic colleagues, industry practitioners, policy officials, and others in attendance, your engagement and questions will enrich our understanding of these critical issues, and we invite you to please join in the discussion where you can. So I propose that we approach today's discussions with intellectual humility, recognize the complexity of the challenges we face, remain committed to evidence-based analysis, and the pursuit of policies that truly serve the public interest. Thank you for joining us, and welcome. Now, I switch to being introducing Andy Chen, who will make some remarks as our first speaker. In this room, Andy probably needs no introduction. He is, of course, as I said, the Vice Chairperson and Acting Chairperson of the Taiwan Fair Trade Commission. It's a somewhat rare thing to find someone who has not only distinguished himself in the academic world, but also repeatedly answered the call of public service. After a successful term at the TFTC, Andy returned to serving as a law professor, and if Taiwanese law schools are anything like US law schools, even taking up the thankless job of being dean. One might have thought he had escaped for good, but fortunately for us, he was persuaded to return to the commission, where he now leads the agency. Andy has more degrees than a thermostat in Taipei in summer, including from National Taiwan University, Soochow University, Duke University, an SJD from Northwestern University. His body of scholarship rigorously applies economic analysis to competition law. I commend to everyone his influential article with Keith Hilton on vertical restraints, really a classic in the field. And his larger body of work comprises basically everything we'll talk about today on the intersection of antitrust and intellectual property, the economic underpinnings of Taiwan's competition regime, and the evolving challenges of digital markets. Mostly, Andy's work, like the man himself, is known for its clarity and intellectual honesty, and its insistence that sound competition policy must rest on a foundation of economic reasoning, not mere regulatory intuition. We're truly honored to have him with us. Please join me in welcoming Andy Chen.
Hi, Joe, and everybody. Thank you, Joe, for your very kind and generous introduction. And on behalf of the Taiwan Fair Trade Commission, I would like to welcome all of you to the conference. My name is Andy Chen. I currently serve as the Vice Chairperson and the Acting Chairperson of the TFTC. And it's an honor to co-host this conference with the ICLE and to kick off the program with a few remarks. And we are here to talk about how government policies and the innovation interests interact in the digital economy and what that means for competition. We have invited speakers who have been at the center of the debate. I'm hopeful that their insights will help us better understand the issues and whether competition in the long run might offer its own solutions. In my remarks today, I would like to first point out that the debate we have engaged in over the past several years appeared to be largely driven by a growing interest in using industrial policy or regulations to address disruptive market shifts that are beyond our expectation and comprehension. The industry policy are not inherently antithetical to innovation. Actually, many of them are innovation-driven and mutually reinforcing each other. Artificial intelligence is one of the most recent and prominent example. An increasing number of jurisdictions has adopted industrial policy to capitalize the benefits that the AI promises. Taiwanese government, for example, is investing billions of dollars in its new 10 big construction project for AI to promote the smart application, accelerate innovation technology, and build robust AI infrastructure. The goal is to industrialize AI and also AIize the industry. AI is not the only example. In a recent merger case, the TFTC has reviewed a joint venture involving leading companies across multiple industries here in Taiwan. The joint venture was established to serve as a platform for joint procurement of offshore windmill. The government is a key stakeholder in several of these firms and also the initiator of the venture. And the purpose of this collaboration is to advance the government's green power policy. The merging party proposed that joint procurement by major industry players would help meet the credit rating requirements set by financial institutions for financing infrastructure development by offshore wind power suppliers. And additionally, the arrangement guarantee a minimum amount of wind power purchased. It provides the incentive for supplier to invest and to introduce the cutting-edge power generating technology to Taiwan. And over time, the initiative is expected to enhance competition in the energy market by expanding access to green energy alternatives. However, industrial policy may not always align with innovation strategies. Even those designed to foster innovation may contain mechanisms that might constrain or hinder innovation. And one of the reasons for that to occur is that some unintended consequences may arise from the well-intentioned regulations. So for example, Taiwan's Department of Digital Affairs has recently released a draft law for public consultation on the innovative data application and the development. The law aims to promote data openness and sharing to support AI model training. Under the law, the government may advise the industries to properly disclose their data content, licensing terms, source, and adopt uniform data structures, format, standards, and the methods of management practices. In response to this draft, the TFTC cautioned that such a standardization may inadvertently incentivize collusion and may dampen innovation by reducing diversity in data practices. Additionally, the tension between industrial policy and the innovation policy actually are more structural than merely unintended consequences for two key reasons. The first, private sector business typically operate with a clearly defined goal. In contrast, government-led industry policy frequently pursue a wide array of policy objectives. Occasionally, those goals may conflict as they aim to reflect and accommodate the diverse interests of multiple stakeholders. To strike an economic and political balance, policymakers are often compelled to rely on a greatest common denominator approach rather than the bespoke approach to tailor the policy to specific context. Under this approach, innovation may be compromised sometimes to prioritize overarching public interest, such as privacy protection, labor rights, environmental sustainability, epidemic containment, regional developments, or response to global geopolitical dynamics. Competition agencies are keenly aware of this trade-off and have to regularly engage in competition advocacy to guide policy alignment. For example, in the joint venture case I outlined previously, the TFTC underscored the importance of adhering to the principles of competition neutrality. So we advised the government to implement its green energy policy transparently and without discrimination once the joint venture commences operation. Secondly, the absence of adequate information for policy trade-off often renders industrial policy, particularly those framed as ex-ante regulation, suboptimal. It leads to the persistent under or over regulation. Digital markets characterized by data-driven competition add an additional layer of complexity to this problem. The information required for sound policymaking may be obscure, unknowable, or even unavailable. When industrial policy are improperly applied in such environments, the cost from stifling competition could be greater than traditional non-digital markets. The pressing question then becomes, how can this challenge be addressed without undermining the objective of safeguarding market competition? To answer the question, we probably need to first ask another question. Is competition policy a viable alternative to industrial policy when the effectiveness of the industrial policy is in question? And some might argue that this is begging the question because from their perspective, industrial policy are typically designed to correct market failures, which by definition signal the breakdown of market competition. However, it's important to distinguish the existence of market failures and their relevance for policy making. And one of my favorite examples to illustrate this point is the regulatory policy for professional industry. Traditionally, professions such as law are regulated under the premises that their services are public good. Regulations such as the licensing requirements or practice restrictions by either the government or the bar associations are deemed essential for avoiding free riding and maintaining a viable market. However, we have increasingly seen free legal service and advice offered online. Providers of those information and services recognize that they cannot fully capitalize the value from their professional knowledge that is disseminated, but that is relevant for their decision to share. On the contrary, they embrace and even promote what would conventionally be labeled as market failure. It's truly a fascinating contradiction, probably a perfect imperfection described by John Legend in his song. Another justification for regulating professional service is the information asymmetry problem. Yet it is essential to remain mindful for the difference between the finding of an issue and the choice of regulatory remedies for that issue. Policymakers could seek to avoid the exploitation of information asymmetry by banning advertisement or standardizing their contents and formats. However, such an approach risks curbing the flow of information that could help the less informed to be much informed. A more balanced alternative lies in promoting information competition, encouraging word-of-mouth marketing, for example, or reputation-based signaling to help bridge the knowledge gap. But in advocating a market-driven approach for industrial policy in foster innovation, enforcement competition policy in digital economy present a parallel challenge in acquiring reliable policy information. The disruptive and the dynamic nature of innovation makes it difficult for us to assess the market effects of innovation with precision. As baseball legend Yogi Berra famously quipped, it's tough to make a prediction, especially about the future. This is notably true in markets where technological progress increasingly follows a pattern of leapfrogging rather than path dependence. Forecasting outcomes in such environments is no less challenging than predicting the score of a baseball game. Ideally, competition law should be capable of anticipating the likelihood, the timing, and the forms of dynamic competition and innovation, as well as their potential market impacts in the fast-evolving digital markets. However, this foresight is often constrained by the same information limitation that hinder the design of optimal industrial policy. If competition authority fail to recognize the transformative value of such innovation, they might statically link the emerging problems to inadequate competition arising from refusal of access to existing solutions, and they may be inclined to mandate open access to legacy solutions. For example, the essential facility doctrine. Paradoxically, this can entrench outdated infrastructures and business models, delaying or even deterring the emergence of novel and more effective alternatives. Both antitrust practitioners and academia have stepped forward to confront these challenges. Notably, there has been a renewed interest in the theory of potential competition and how it could serve as a proxy for assessing the presence and the intensity of innovation in antitrust law. Researchers have also advanced a range of theory of harm to help establish an analytical framework for innovation-driven markets. To address the measuring problem, some have proposed safe harbor or blacklist approach to delineate acceptable boundaries for innovation competition. I will leave the discussion of these very thoughtful and commendable contributions to our distinguished panelists of panel 2. For now, I would simply like to highlight 2 personal reflections on how antitrust law might evolve to meet the enforcement challenges posed by dynamic competition. First, in the face of market uncertainty and unpredictability, antitrust law and courts often adopt wait-and-see approach, intervening only when empirical evidence demonstrates convincingly that early action is necessary to prevent irreversible harm from delayed enforcement. This approach was notably articulated by the US Supreme Court in its 1963 decision in White Motor versus United States. The case addressed the issue of whether the per se rule, rather than the rule of reason, should be applied to non-price vertical restraint. And in declining to do so, the majority of the court emphasized, which I quote, "We do not know enough of the economic and business stuff out of which this arrangement emerged to be certain. They may be too dangerous to sanction, or they may be allowable protections against aggressive competitors, or the only practical means a small company has for breaking into or stay in the business and within the rule of reason. We need to know more than we do about the actual impact of these arrangements on competition to decide whether they have such a pernicious effect on competition and lack any redeeming virtue." I think the teaching still rings a bell today as it did more than 6 decades ago. Secondly, the growing interest in ecosystem competition within digital market calls for renewed attention from competition authority. In this context, revisiting the economic theory on competition for the market offer valuable insight for antitrust analysis. It can illuminate how to systematically review both the pro-competitive effects, such as the scope and scale economy inherent in ecosystem structure, and the anti-competitive risk as well, particularly when ecosystem function as an entry barriers to deter competition from potential entrants. Actually, antitrust law has already incorporated some of the key elements of this theory into established case analysis. So for example, the dichotomy between intra-brand and the inter-brand competition and the net competitive effects from their interplays remains an important basis for determining the legality of vertical restraint. I believe that factors traditionally used to assess marketing arrangement between suppliers and their brick and mortar distributors, such as the brand market power, the necessity of using pre-sale or post-sale services to support or signal product quality, and the risk of free riding are equally pertinent and applicable to evaluate a practice like mandatory in-app purchase requirement imposed by digital platforms. No serious talk about competition in digital market is complete without at least a gentle but deliberate touch on the issue of review standards. Much has been debated regarding the strengths and the limitations of the prevailing consumer welfare standard in the digital context. And several alternative standards have also been proposed to serve as benchmarks for assessing illegality. And among these, the competitive process standard has garnered the most attention. This standard critiques the consumer welfare standard for its narrow focus on the impacts to consumers' interest from review conduct, while overlooking other values essential to preserving the intensity of the competitive process, which remain the core objective of antitrust law. The frequently cited example is that the consumers may benefit from free products and services offered by a dominant digital platform, even as the underlying competitive process is significantly undermined. I believe no one in this room would dispute the protection competitive process is one of the central goals of antitrust legislation. But for reasons that I don't have time to delve into here, I remain skeptical about the practical utility of the competitive process standard. Overall, I continue to struggle with the notion that a process rather than an effect could serve as a meaningful benchmark for reaching a normative conclusion about the right and wrong of a conduct under competition law. I tend to align here with Professor Elhoch's view that a competitive process cannot serve as a standard. Neither is consumer welfare standard a substitute for it. Rather, the consumer welfare standard functions as a proxy, an indicator of whether the intensity of the competitive process and thereby market competition has been diminished or enhanced. I would like to use a simplified and a hypothetical example to illustrate my point. Imagine competition as a sports match. From start to finish, the game itself represents the competitive process. Now, suppose we are debating whether to allow more aggressive physical contact into the game. Under the competitive process standard, which emphasizes conduct's impact on the process rather than its effects, proponents may be preoccupied with enhanced risk enhanced risk of injury, fearing that such change could reduce the number of contestants or lower the incentive to participate, and thereby weaken competitive intensity. But the intensity of a game isn't determined solely by a structural review of the supply side dynamics. More aggressive kicking or grappling might heighten the intensity of taekwondo or wrestling, but would be entirely misplaced in the context of swimming or 100-meter dash. The nature of the game matters and is shaped in large part by audience preference and the expectation about what the game ought to be played. In some sports, spectators may willingly accept the risk of shortened careers and the fewer players in exchange for more intense, high-stake competition. So to me, the consumer welfare standard in antitrust is audience preference in sports. It helps ensure that the design of the game competition itself is not driven solely by the goal of preserving player numbers, but by the quality and the appeal of the contest. After all, a game designed to keep the field full, but leaving the stadium empty is no victory at all. I will wrap up here, hoping these brief remarks could add a tiny spark to ignite today's panel discussion. So stay tuned, there's much more to come. And thanks for being with us and enjoy the conversation. Thank you very much.
Thanks for Mr. Andy Chen's speech. Now let's move on to the panel one, Industry Policy and Innovation. We would like to invite the moderator of this session, Mr. Andy Chen, and the panelists Mr. Huang Li, Professor of Law, former Dean, Korea University School of Law, Ms. Payam Malik, lead ICRIER, Pokhang Center for Internet and Digital Economy, former Head Economic Division, Competition Commission of India, and Mr. Frank Kui, Senior Director of Qualcomm, and Mr. Ming-Li Wang, Associate Professor of Graduate Institution of Industrial Economy, National Chen, Zhongyang University, and Ms. Vanessa Yanhua Zhang, Executive Vice President of Compass Lexicon. Please come to the stage and have your seat. Please welcome them with a warm round of applause. And now we would like to give
Welcome to panel 1 on the industrial policy and the innovation. I think everyone in this room will know perfectly that innovation is basically at the center of the digital economy. And it is a vital driver for economic growth and prosperity in digital era. And industrial policy also sometimes are driven by innovation, as I have outlined in my remarks. But sometimes industrial policy may be in conflict with innovation or even competition policy. And for reasons that I have mentioned in my remark, most of the conflict arises from the inadequacy of the regulatory information. And with that, under that situation, sometimes the industrial policy may hinder or constrain innovation effort. And of course, competition policy might serve as a buffer zone, try to attenuate the impacts from this conflict. But competition policy also has its own problem, its conflict with innovation. You just imagine the policy or discussion in antitrust law regarding how we deal with the justification from the R&D investment or from the licensing practice of intellectual property. I think antitrust laws are still discussing and have different views regarding whether those kind of justification could be accepted on the antitrust analysis. So I remember there's a quote from former US Treasury Secretary Larry Summers. He used to say that the best generals are the ones who head war the most, but are willing to fight when needed. What I worry is that people who do industry policy love doing industry policy. I think they capture the message that I try to deliver to the audience. And today, we are fortunate enough to have a fabulous lineup to help us sort of to tackle and untangle this triangle love and hate among industrial policy, innovation, and competition policy. So allow me a minute to introduce each of them. Okay, I'll start from my left. Professor Huang Li, professor on the very left on my side. Huang Li is a professor and the former dean of Korea University School of Law. And his academic interests include competition law, digital platform, intellectual property right, telecommunication law, consumer protection, and economic regulation. Professor Li has played an active and a leading role in the Korean academic and the practical community of competition law. He was president of the Korea Competition Law Association from 2019 to 2021, and is currently president of the Korean Distribution Law Association. Professor Li often teaches at foreign institutions, including Washington University in St. Louis Law School, and Renmin University in China School of Law. He has also been recognized as one of the 25 most influential antitrust scholars worldwide at the inaugural Antitrust Academics 2022 announcement. So welcome, Huang, to this conference. And to the right of Huang is Vanessa. Vanessa Zhang. Dr. Manessa is the head of the Greater China practice and executive vice president of Compass Dexcom based in New York and Beijing. He's a senior research fellow at the Marketing and Regulation Law Center of Renmin University, and the vice chairs of the ABA Antitrust Law Center, Antitrust Law Section, Global Private Litigation Committee, and the International Section. She is an expert in applying economic analysis to competition, industrial organization, and intellectual property issues for clients across numerous industries in the US, the EU, and the Greater China. In China, Dr. Zhang has testified as an expert witness and submitted expert reports multiple times before the Supreme People's Court, provincial higher courts, and the State Administration for Market Regulation, the Anti-Monopoly Bureau of Ministry of Commerce. Dr. Zhang holds a PhD degree in economics from Toulouse School of Economics and a BA in economics from Beijing University. Welcome, Vanessa. And to the right is Payala Malik. She is a visiting professor at the ICRER Process Center for Internet and Digital Economy. She is an economist specializing in competition law, antitrust regulation, and public policy. She has advised the Commission on the economics of competition law across an expansive range of markets. And he also led the case team on competition assessment of M&A and antitrust enforcement matter, and advised the Commission, the CCI, on judicial review of cases before the Appellate Tribunal and the Supreme Court of India. Ms. Malik has considerable experience in the economics of digital and e-commerce market. She has published in peer-reviewed international and Indian journals in the area of competition law and policy. She is a regular columnist and writes on op-eds in the field of regulation and competition for reputed business and daily newspaper. So welcome, Payal. And to the right of Payal is Frank Shi. Frank is the Frank Shi is a senior director of legal counselor at Qualcomm. He is advising different business units on antitrust matters, handling M&A, as well as investigation and litigation across the world. Prior to joining Qualcomm, Frank practiced antitrust law in Washington, D.C. office of Roberts & Gray. He began his legal career through the U.S. Justice Department, DOJ, honor programs within the DOJ antitrust division. So welcome, Frank. The last but not least is Professor Mindy Wang, or Mindy. Mindy has been teaching at the Graduate Institute of Industrial Economics, National Central University, Taiwan, since 2025. You're trained and teaching in law. He enjoys following the progress of science and technology and shows particular interest in information technology, having found that tinkering with codes a common exercise since a teenager. A relative newcomer to the competition law, he also studied civil law, intellectual property law, and the constitutional law. So welcome, Mindy. Okay, so to kickstart the panel, I would like to first turn to Wang. If you go back to history and take a look at the recent global trend, it probably will give you a feeling that the history is repeating itself. The post-World War II Europe relied on industrial policy to rebuild strategic sectors such as coal, steel, and railways, and also to cultivate national champions. Neoliberal thinking in the 70s and 80s bring in deregulation and liberalization, which also at the same time laid the groundwork for R&D and innovation in Europe. Today, COVID-19, geopolitical tension, and the climate goals revive the interest in mission-oriented industrial policy. And I think Asia's economic development follow a similar pattern. So do you share the same deja vu feeling with me? And what is the experience from Korea? So Huang, you have the floor.
Okay, thank you, Andy. And I'm very happy and honored to be invited to this important conference. And many Koreans, including myself, we always respect and admire the achievements the Taiwanese people have made so far and the innovative and challenging spirit you have shown for the past years. I look forward to learn a lot from your experience at this chance. Taiwan is a leading and smart country navigating the dangers of the so-called new normal of today, which can be sometimes characterized by new conservatism and selfishness, national selfishness. As Andy correctly pointed out, it seems that history is repeating itself today. Today's global politics and economic politics remind me of the unpleasant scenes we have read about in history books. In the years of the late 19th century, Europe was a continent marked by intense industrialization and aggressive industrial policies aimed at growing the national economy. Germany was late to the Industrial Revolution, as we all know, and the international competition to secure colonies. And they first tried to overcome its handicap through technological innovation. In fact, the Bismarck, known as the Iron Chancellor, strongly advocated for technological innovation. And under Bismarck, Germany became a world innovator. Technological progress was made in physics, chemistry, among others, and 1/3 of all Nobel Prize winners at that time went to German inventors and researchers. The German cartel system efficiently supported technological innovation. However, ultimately, Germany found limitations in this strategy and resorted to militant tools. It led to World War I. Innovation was successfully made by strong industrial policy, but the years around World War I were characterized by imperial ambitions, rising nationalism, and selfish nationalism. Some economists diagnosed this period as the end of capitalism, as some of the Korean economists describe today. It seems to me that today's geopolitical landscape is very similar to that of the time of World War I. We are witnessing the emergence of industrial policy under the guise of convention policy. Industrial and trade policy is adopted sometimes not to develop, in a good sense, to develop local industries, but in order to make competing economies poor. We need to know that selfish and excessive industrial policies can lead to mutual destruction or even to war. Regarding the Korea, as was the case in Taiwan, we have been very successful until 2000 in terms of the industrial policy. However, in recent decades, we have been faced with slow and stagnant economy, and we are very much concerned about that. Now, we are trying to find breakthroughs in innovation. the government is willing to do everything to achieve this goal today. The international environment surrounding Asia, not only Korea, is completely different from that of several decades ago, in my view. The new administration that just started 2 months ago, they seem to favor stronger industrial policy, particularly those that protect SMEs, small, medium-sized firms, and develop sovereign artificial intelligence. I hope it works, but given such a complicated international environment, I cannot be sure about the future. From the history of perspective of history, industrial policy can wear the color of nationality, particularly in the context of international competition. Today, it became hard to me to find genuine differences between competition and industrial policies. And we see many cases of industrial policy in the guise of competition policy or vice versa. And when industrial policy retreats until 2000, as we experienced in Korea, we talked about convergence of a competition policy in international competition policy forum. Now, given the emergence of industrial policy in the trend of national self-decision or on the globe, we are forced to discuss divergence of competition policy in order to avoid one-side privatization. However, it does not necessarily mean that competition policy should give all the way to industrial policy. Rather, what we can do best is to harmonize the two potentially conflicting policies with the ultimate goal of consumer welfare and sound economic development. And we need to benefit from the brilliant experience of competition policy of the past decades to promote innovation, economic development on the globe all together. Thank you.
Thank you, Huang, for your very insightful observation of the historical perspective to lay the foundation of our discussion. Of course, I know the pattern of economic development in Asia appears to be, at the first look, appears to be very similar, but actually there are nuances among different jurisdictions. So for example, India. India is quite renowned for its leapfrogging innovation, which I have briefly described in my remark, particularly in areas like telecommunication and mobile payments. And recently, its vibrant startup ecosystem and also AI. So Payat, in your view, what spurs this economic transformation? Are there any industrial policy behind this evolution? And are they typically pro-innovation? So Payat, you have the floor.
Thank you so much. Thank you, Andy, and it is wonderful to be here and listening to such great views and insightful views. So this panel is, I think, very, very important because we are living in a very polarized world where there's a juxtaposition of, say, competition policy versus industrial policy, regulation versus innovation. But it is important for people who are thinking about these things on a daily basis to see that how to bring in a convergence to serve the goal, and in India, that's the goal of the government, of an economic transformation. In fact, India seemed to have lost the bus when the East Asian miracle was happening. India was not innovating enough to take advantage of the shifting geopolitics. So a modern industrial strategy in the tech sector across nations, including India, is emerging to complement markets and regulation. So in fact, the industrial policy, the way it is emerging in India in certain sectors, which have been mentioned by Andy, such as digital payments, AI, startups, is to complement the role of markets and competition and also the slowness of response to regulatory interventions so its industrial policy is far more market shaping than just being policy oriented towards promotion of national champions and subsidizing certain projects which are close to the heart of governments for populist reasons. So as in any modern industrial strategy, certain key sectors have been identified, strategic not only from the purpose of an economic development, but also from a national security perspective, where the private industry is not poised or is not just driven, because it is driven just by profit motives, is not poised to make sufficient investments needed to secure national ambitions. So the idea is, and a lot of economists who were against the old-fashioned industrial policy have started writing in favor of these industrial policies because it is about crowding in private investments as opposed to crowding out long-term investments in sectors vital to national well-being. So it is this kind of, and in India, an iterative collaboration between the government and the firms, where the industrial policy leads this collaboration. So it is not about creating either large central public sector entities or just creating national champions, but it is to bring in a collaborative public-private partnership. See, the industrial policy, well designed, and therein lies the rub, with clear conditionalities and wide scope can foster pro-competitive outcomes. So let's look at some of these sectors in India. For payments, for instance, digital public infrastructure is a distinct industrial policy response to increasingly concentrated market structures in the digital markets. So the idea is that the platforms which tend to be, because of their network effects, tend to be concentrated, need to, in a private proprietary ecosystem framework, need to be complemented or supplemented by the digital public infrastructure, which is based on building blocks, modular, interoperable, and institutionally governed, which allow various service providers to plug and play and innovate without dependencies on a private system orchestrator. So in the digital payments, the government created this UPI, that is Universal Payment Interface, through a consortium of banks, that is the NPCI, providing the rails or the building blocks on which private sector could participate and bring in some competition. So the idea was to reduce dependencies. The idea was that the state is reclaiming its role as a market shaper, and state can create an enabling environment where innovation flourishes within the boundaries of aligned public purpose. Of course, there are limitations to these policies because one of the questions is, are they pro-competitive? So it is not that these kinds of industrial policies do not require continuous monitoring, continuous governance issues arise. For instance, because it is a subsidy-led model where the digital public rails have been provided through a huge subsidization program of the government. What is the long-term monetization plan of the government? And this is now discussed by the Reserve Bank of India. How long can a zero merchant discount rate at the back of which digital payments exclusivity was attained in India be sustained? Because there are now issues of sustainability of the architecture. Then if we go beyond just all, so these are the questions. And then because India is trying to make digital first and digital default in the payments, how would now the government-led subsidy model be replaced through some kind of a monetization mechanism? AI is another field in which the government has clearly expressed its intention to jump in. It is no longer going beyond providing marginal incentives, but the industrial policy in AI is inspired, I guess, by the kind of geopolitical situation in this disruptive technology governed by achieving some kind of an AI sovereignty. Of course, the money which has been committed is very little if you look at the kind of money which these private sector entities are asking to build these large language models. But India's contribution is to the startup community to develop India-specific SLMs or small language models to solve Indian problems in vernacular languages rather than just be dependent on large foundational models which are based on languages which are not, do not have the Indian context or the Indian nuances. So government here too is trying to provide support or hand-holding for the core AI infrastructure, again to reduce dependencies on a handful of companies, so be it the cloud infrastructure, be it the foundational models, or be it the GPUs, compute infrastructure, to again support an innovative startup community. So India has innovative startup community backed on the fact that we have a huge amount of engineering talent, and so through these public-private partnerships in technology markets, through an overt industrial policy, India is trying to exploit this. The startup community itself started, though, at the back of the Y2K demands organically, but the Indian government has also now stepped in to provide a financial support, to provide specific policies and programs for the startup community. And India has now become the third largest startup ecosystem in the world, with 150,000 startups in the last number which we have. So the idea which is that innovation is not is endogenous and will not be a byproduct of a pure market-led industrial growth. Governments need to step in, and Indian government has adopted that view, and because it also cannot be just imported like capital. And India has taken some commendable steps, but there are limitations because of structural inertia, fiscal fragmentation, and institutional silos. Having said that, going forward, it does not mean that competition policy or, for that matter, regulation will not have a role to play in promotion of innovation.
Thank you, Pablo. I think most of people here will agree with me that each time when we talk about the situation in India, you can sense there is a very vibrant, bottom-up, innovative force that keep the economy moving forward. And from your presentation, we can also sense the Indian government still respond and interact with the private sectors quite prominently and to produce the welfare-enhancing outcome. So I think it's a perfect timing to compare India's experience with another huge economy, China. Vanessa, over the past decades, China has introduced a series of the industrial policy alongside rapid growth in sectors such as the digital economy, AI, and semiconductor, and has set the long-term goals. Had set the long-term goals, technology goals through the national strategies and also the funding program. But at the same time, in parallel, the private sector also investment a lot, and in the entrepreneurship have expanded across platforms. And can you share your understanding of the China's industry policy in facilitating this kind of collaboration between the public and the private sector? So Vanessa, you have the floor.
Thank you so much, Andy, and I'm very honored to be here to share my view as an economist and also as a practitioner practicing in United States and Greater China. I just want to echo what Andy just mentioned during the keynote speech, that industrial policy is to correct the market failure. And the market failure may include externality, the coordination problem, and the provision of public good. And the China's industrial policy is not designed to replace the market. I think this is very clear. And the goal is to provide the strategic guidance and also reduce the uncertainty of the investments in the innovation. And the priority of the industrial policy in China is to set the technical upgrades objectives and also designed to promote the market-led competitions and development and innovation. I just participate in the research for the World Bank for their World Bank Development Report 2025, and this year the topic is about standardization. When we are visiting or revisiting the standardization in China, we figured out that in the standardization process in China is not mainly led by the government. It's the government. There are two tiers. The government provides the priority list, but the industries, the associations, and also especially the companies, they took the lead in the whole process of standardization. I would say it's the mix of the top-down and bottom-up approach. There might be some misunderstandings that in China, the innovation is mainly led by the SOEs, state-owned enterprises, and governments may direct the innovation and pour a huge amount of capital in certain sectors. I just want to make clear that this is a misunderstanding, and I can show you a very good example. You probably heard about the internet companies in China, but probably you haven't heard about People's Net, the Renmin Wang. So the People's Net was initially assigned by the state-owned enterprise, and they assign athletes, the international champions of the ping pong, Miss Deng Yaping, to be the head of People's Net. But that company failed. But no one really remembered it. But people remembered Pony Ma of Tencent and Jack Ma of Alibaba. So neither of them played ping pong or become the champions of the tournament. But they succeed from the market. They succeed from the competition, against the other companies. So internet industry might be the very representative industry in China that government give the freedom to the markets and did the laissez-faire, but provide certain assistance of the regulation. So I want to put emphasis on the industry policy in China. It has three features. The first one is the private enterprises are the center of the innovation. The second is the capital is the supplement. And the third is the policies, industry policies, are the assistance. So government, the rule, it's to create the environment, to create the market ecosystem for the industry to innovate. In the Chinese old saying, instead of giving you the fish, we teach you how to fishing. But the government rule is not stopping there. They make the further step to offer you the fishing grounds or the fishery. So I think I can use the example of a semiconductor industry in China. That in the 14th 5-year plan, semiconductor industry has been set as the priority of the strategical industry in China for development, and it's even included in the Made in China 2025. And but the focus is the market-oriented industry policy, and there are a lot of innovations happen in China, but you probably also see that in Taiwan we have many representative companies participate in this global supply chain. So in China, the market-oriented policies include encouraging the social and capital-led investments and also diversified the fundings through the IPOs, the funds, and also the asset securitization. And also the policy supports the M&As under the market-driven principles. For example, the policies prevent the government, especially local government, from imposing the extra legal restrictions. Then also the policy encourages the development of the innovating financial tools and also provides the IP-backed loans and supply chain financing. See, all these policies have shown that there's a very strong guidance from the government, but they won't participate in the whole game of this competition. And especially for the standardization, it encourages the local companies and also the associations to participate and lead the standardization in various industries. And anti-monopoly law and IP laws have also strengthened the competition and antitrust overseeing to ensure the fair competition. So all these policies have shown that industrial policy is the goal to promote the competition, to promote the development and technology independence, but also to encourage the indigenous innovation and to let the local companies be independent of the foreign technology. So I just want to pause here and leave the floor to Andy.
Okay, thank you, Vanessa. It's great to know that we have some kind of misconception about the industrial policy in China, and thanks for clarifying it. And it's also great to know that it seems to be industrial policy goes hand in hand with the private sector in promoting economic prosperity in China. And I think I'm going to move on to another completely different jurisdiction. The jurisdiction who relies mostly on innovation rather than industrial policy to promote economic development, the United States, well, at least in the past. I'm not sure whether in the future that is going to continue to be the situation. So Frank, recently I read an article by the former UK CMA chair, Marcus Bokerink. He suggests that putting industrial policy under the business lens, much like private enterprises, he argued that government should define clear targets on the opportunities and value industry policy seeks to capture and generate. When shaping policy, he argued that government should start by asking strategic questions such as where and how are you going to compete with other jurisdictions via industry policy. So as a practitioner and expert who works for one of the world's most innovative and leading firms, do you agree with this approach? Is this suggestion plausible to be implemented by the government? I would be interested in knowing what is your take on this?
Sure. Thanks, Andy. I do agree as a general principle that there are lots of potential benefits for governments to learn from the private sector experience. But as the government start mimicking what private sectors do, it's important to recognize that there are actually already plenty of existing similarities between the two. And especially as between democratic governments and large public companies. Because both governments and companies, what do they want, right? For the short term and from the long term, they want the competitive viability and ultimate success for their constituents, right? Whether it's their shareholders or their voters. Okay. But both companies and governments face a challenge of how to allocate very scarce resources. Okay. So as they do that, they face both short-term and long-term pressures, right? Obviously, in the long term, we want to be not just successful tomorrow, but 5, 10, 20 years down the road. But in the short term, governments face elections from voters who are saying, why should I vote for you? I can vote for that person who promises lower taxes and the next great thing, right? I'm going to vote for that person instead, right? And public companies, our executive teams face the same thing every quarter, right? They have quarterly earnings. They have to respond to large institutional investors, the Vanguards, Fidelities, BlackRocks of the world. They come in and say, why should I invest in you? Why I can move my billions of dollars easily tomorrow to your competitor or to your customer or to your supplier, to wholly different industries, right? And if they move that, your stock price goes down, and the management team eventually leaves, right? So they face these intense pressures, much like, I think, governments and elected officials, right? And I want to talk about an experience, particularly from my company. So Qualcomm, many of you know, is well known for being a leading chip supplier for mobile phones, right? That's been our recipe for success for a very long time, since the founding of our company. We're in a period of transition right now, much like many other companies are. Think of it, the analog is in a jurisdiction transitioning from a brick and mortar world to a digital world. We're transitioning from where we were strong in mobile phones and wireless communications to we want to be a computing processing company in many different other sectors, okay? Automotive, IoT, which is Internet of Things, PCs, laptops, and increasingly data center, okay? So this is, the servers, the chips that run the, in the cloud AI, the chat GPTs of the world, right, that everyone talks about. And when we look into trying to enter into some of these spaces, and I'll use data center as a particular example, we see enormous challenges. We're trying to play catch up. Other people are much stronger. They were earlier. They have the IP that we need. They have strong adjacent products. The customers are huge hyperscaler customers, right, who have tremendous resources, bargaining power. They have their own internal solutions as well. We're trying to play catch up. And it's a challenge, and it's gonna have to be done organically and perhaps inorganically as well. But the potential for this space is so vast, right? Just like if you're a country like, let's say Germany transitioning from an automotive world to a digital world, right? You can't not try to compete in this space. We have to enter, right? This is critical, existential for our company or for our country to survive in the 21st century, okay? Why are we playing catch up? It didn't have to be this way. And the reason it didn't have to be this way for data center is that 7 or 8 years ago, Qualcomm actually had a team, a business unit, working on data center products. But why did we stop that? We actually exited that business. We divested the business, and lots of people left the company. It was because at that time, Qualcomm was under intense financial pressure. We had multiple regulatory cases around the world from some agencies that might be in this room. I won't point any fingers. We had large customers who weren't paying us money. We were the subject of an attempted hostile takeover by a competitor. And investors were saying to our management at the time, there is no way we can continue investing in your company until you get your expenses down. And so we had to make the very difficult trade-off of foregoing long-term investments, even then people could see that, data center, cloud computing was the wave of the future. Maybe not to the extent that, in a pre-ChatGPT world, right? But certainly this is an important area. We had to forego that and focus on reducing expenses, protecting our core businesses, investing in those, right? But that's the cost, right, when we make these trade-offs, when we're responding to short-term pressures, right, versus the long-term strategic thinking. And so if there's a lesson to be learned, which is, I think for governments as they're thinking about industrial policy, to the extent that investment is a pillar of industrial policy, being able to think in the long term is critical. And I'm trying to think of building off of Vanessa's kind of fishing example. Imagine, your country where you have people who are fishing in a fully stocked pond of little fishes. They're excellent at fishing these fish, right? But one day these fish are going to run out. And over there is the ocean, and there's big tuna out there, right? And somebody needs to put in the investments, the incentives to invest in the big fishing boat and the tools that are needed and the expertise that are needed to go out 50 miles off the coastline to get tuna, because that's the future, right? But it is so tempting to just get that little fish right there in front of you. So I think critical long-term thinking is important as jurisdictions are thinking about industrial policy when they're learning lessons from the private sector.
Thank you, Frank. Very insightful. I think it will comment sort of circling back to the point I made in my remark about the difference between private sector and the government, especially what you have just said, commented, is even though it's very complicated for a business to pursue his business goal, but at least I think the business still guided by the principle of profit maximization. Unlike the government, usually the government has a huge layer of objective to pursue that will make things much, much more complex in terms of learning from the business. I think it may not be that easy for the government, especially when enacting industrial policy. Okay, I would like to turn to Ming Li and to go back to home. I think industrial policy had played a pivotal role in transforming Taiwan's economy. I believe that there is still an enduring pride among many in Taiwan regarding the strategic use of industrial policy to drive innovation and to spur economic growth. This achievement has been earned Taiwan the praise of the economic miracle among the four little dragons of Asia. However, the picture may not always be that rosy. Especially, there are some industry in Taiwan often cited by critics to call into question the wisdom of efficacy of industry policy. So, can you share the information regarding what is the current state of industrial policy in Taiwan? Does industry policy still play a decisive role in fostering innovation in Taiwan? Ming, you have the floor.
Okay. Well, I come to that later, but I would like to make some clarifications first. I'm not an economist, so I'm not qualified to really go into detail about what went right and what went wrong. But I want to make some observations that first, that industrial policies are basically rooted in the vision of the ruler, and so the ruler's characters matters. If it's a democratic state, then it means at least more or less it reflects the vision or the desire of the people. But if you ever involved in any community management or things like that, you know that peoples will have many different ideas. So the picture, the vision is usually messy and blurry. And if it's an authoritarian regime, then usually the vision is much more clear and focused. And since the ruler in such a regime usually are mostly concerned about the stability of his regime, so mostly they leave the economic affairs to people he trusts in his close circles. So if there are good ones in this close circle and they can make a good judgment, then an authoritarian regime usually are more effective, more efficient, or even more forcefully implement industrial policies. So I think that's what happened in Taiwan in the earlier era, before Taiwan turned into a truly democratic state in the past 30 years. Many of the much praised industrial policies took place when the father, son, Chiang Kai-shek and his son were on the throne. And so basically we did have a few people with good economic sense, technology sense, and they may happen to make some pretty wise decisions, but not all of them that good. And later, when Taiwan gradually went to turn into a democratic state, then things changed. Many things were incoherent and short-sighted and self-conflicting. I would say the best industrial policies that took place during the last 25 years would be to turn what used to be state-owned telecommunication industry into a market-oriented, competitive industry. So that's the best industrial policy, and that's the policy to rely on competition to foster growth in the industry. A similar one, though probably less successful, will be the financial sector. We liberalize and make it possible to create new banks, new financial institutions, and so that the financial market is the industry is indeed more vibrant than in the past when we had only had some state-owned banks, and they become a real helper to capital accumulation and to help business startup, etc. But the financial industry is still heavily regulated, and we have government agencies keeping them on very short leash, and so they are really not that flexible, or they cannot always do what they want to do. But of course, the government had pretty good reason, or you can say some excuse for that, because to protect consumers, to prevent financial frauds, etc. But the gist is that because they are heavily regulated, so they are not really that innovative compared to, for example, the telecommunication industry. And so I think the best industrial policy that took place after Taiwan turned democratic would be those that lean heavily on competition. So for others, well, that would be a pretty mixed score. And so I think that's basically what I want to share. And that's a second point is that for industrial policy, it usually means that we are trying to marshal the truth in the same direction. The government see that this is good, this is what the direction we should go, and we ask the industry, we make rules or incentives or punishments and try to steer one or several industry toward a certain directions. But market-oriented approach or competition law would stay more relaxed and let the market or let the industry to steer themselves. And I think that sometimes makes a difference. Well, yesterday when I went through the notes for today's conference, I see that this dress code business, right? And I do have my ties in the hotel, but I haven't wear a tie for more than 30 years since I met. The last time I wore a tie was at my wedding. And I thought that between choosing to conform with a rule and to be choked before I get to speak, I think I will choose not to wear the tie, and I find an excuse that, well, I was educated in California, and in California, business means jeans and t-shirt. And so, well, that's for antitrust authorities. That means rule of reason would suggest that, well, they listen to what you have to say, and they don't necessarily ask you to follow the order to the T. Okay, industrial policy, well, we can still make industrial policy has all kinds. Okay, we can still build flexibility into industrial policy, but usually, and especially for government trying to show that they're very capable, they are taking the lead, then usually they like to marshal everybody toward a certain direction. And well, again, I'm not an economist, but experience seems to tell us that may not be the best approach. Okay, and one last point I think that Frank mentioned just now, and I would like to echo, is that for business to be successful, you need long-term visions. Okay, you need to see far ahead. One of the most celebrated industrial policies in Taiwan is that in the 70s, again, in the authoritarian era, in the 70s, they found that semiconductor is a promising industry, and they managed to gather the resources to start a couple of, actually one company, and that's before TSMC. TSMC came 10 years later. Okay, but government did had a hand in making that happen, and that took long-term vision, because at that time they didn't really know how big the industry is going to be. So you can say it's luck, but you can say it's long-term vision. But again, for democratic government, long-term vision is something, well, I can say it's a rare commodity. It's difficult for a democratically elected government to have long-term visions. Okay, and so I think that's another part that we should bear in mind. Thank you.
Thank you, Ming-Li, for introducing the political dimension into our discussion, and also point out that the government is frequently tunnel visioned instead of using the long-term vision to predict the effect of the future development of the industrial policy. I think we have a pretty good first round discussion, and I've heard the discussion about how this trilemma among industrial policy, innovation, and also competition policy could go hand in hand in advancing the economics moving forward. I would just like to move things further forward by discussing a little bit in depth regarding the role competition policy and law could play among these interplays. And I think this topic could be further divided into two sub-issues. The first one is, suppose, we have heard about all the panels mentioned about how this conflict could be reconciled by very careful design industry policy, or maybe by the harmonization mechanism to reduce the negative impacts from this trilemma. But suppose we have a very strong form divergence between competition, market competition, and the industrial policy. So in that case, which policy should prevail? I know it's not common for this to happen, but suppose it happened. What can we do about it? Should competition prevail over the industrial policy, or the vice versa, or the other way around, sorry. And the second sub-issue is that what kind of mechanism or enforcement efforts the competition agents could undertake to avoid this kind of conflict? Can we avoid that by introducing guidelines, enforcement policies, or even enact some administrative regulation, or engage in interagency competition advocacy? I think this is the second very interesting question. So on that note, I think I will first go to Frank. Again, recently I read a newspaper, a report in Wall Street Journal, and he mentioned that the US Vice President, J.D. Vance, recently commented in an interview by a podcast, and he mentioned that the market is a tool, but it is not the purpose of American politics. And it seems to me that he is implying that he will not shy away from putting market and competition in the backseat and letting the government-led initiatives to take the wheel if necessary. So what is the view on the sort of the comparative advantage or disadvantage between industrial and the competition policy in this context, especially the comment made by the VP Vance?
Yeah.
Okay, thank you.
Thank you, Andy. So I went back and looked at the context of J.D. Vance's quote there, and I think his comment was more reflecting the political reality in the United States, and especially from the right now, that there is a strain of populism and a reflection that there is a large voter base that is feeling the disconnects of globalization, to quote a famous book title. And, you know, efficiency, capitalism, laissez-faire, et cetera, while they're nice, in J.D. Vance's words, tools, right, to achieve an end, but they're not the end. The end is to ensure that, you know, enough people have jobs, people can put dinner on the table, et cetera. And I think, you know, there's a lot of commonalities from the J.D. Vance school of thought, political thought, and some of the folks from the left that were outgoing, right? So there's a you know, a lot of overlap between some people called, you know, the Lincoln administration and what J.D. Vance articulates for antitrust. It remains to be seen, I think, overall, the Trump administration, especially right now, what their views on antitrust policy is. But I want to go back to your broader question about when there is strong divergence or tension between competition and industrial policy, how is that reconciled? I don't have the slightest clue of how to answer that question. I do want to say from, you know, Qualcomm and from, I suspect, other companies' perspectives, you know, companies are always seeking transparency and clarity and predictability when it comes to any kind of regulatory process, right? And we recognize that it's the sovereign right of countries to have their own industrial policy, you know, and they're going to have policies that go into different directions, right? Is it to advance the European common market? Is it to advance the Chinese socialist economy? Whatever it is, that's their right to do so, right? What we do want, though, is more explicit and clear separation of competition, substantive competition analysis, as distinct from, you know, FDI or CFIUS, national security review. I think when industrial policy desires seep into competition analysis and it's not announced and it's not made clear, that's ripe for improprieties. And, you know, antitrust law, competition law, there's a wide body of existing case law, economic literature, it's quantifiable in many cases, and engaging on those grounds, I think there's a lot of value for both the reviewing agency and for private companies who are in front of them. And I think industrial policy should be separate from that. It makes it a lot more predictable, and to the extent that competition agencies want to be respected as kind of honestly intellectual, engaging on the substance of competition, et cetera, it's better to keep the processes separate. And it's not to demean, I think, the value and the importance of industrial policy, right? I think just having that dual track is important for companies to plan.
Okay, thank you, Frank, for giving us this very general, high-level discussion about how the competition policy might interact to industry policy, especially when they are in a very strong divergence with each other. I think I would like to move from theoretical or high level into more practical question. And I would like to turn to Vanessa. So Vanessa, I know you have frequently served as an expert witness in competition cases in China, and also as a consultant to Chinese business. I would like to pose to you the same question that I asked Frank, and invite you to share your insight into helping your clients navigating through China's litigation and regulatory landscape. I believe that the audience will particularly interested in learning how you advise companies on complying with the recent reforms targeting on, for example, digital platform, and the various guidelines issued by the administrative agency. So, Vanessa, you have the floor.
Thank you, Andy. So in China, I think the competition enforcement has made specific emphasis on the strategically important sectors. For example, as Andy mentioned, the digital economy as well as the semiconductor industries. The goal is to achieve the balance between addressing the competition concerns and fostering the industrial progress. So, for example, in the semiconductor industry, the Chinese agency SEMR has introduced and explored the application of the novel theory harm, for example, the supply chain security. And also, they have the goal of enhancing the protection of the market competition, the consumer welfare, but also support indigenous innovation and self-resilience in the complex geopolitical environment as of now. So the agency has gone through a significant rule-making process. For example, SEMR has revised horizontal merger guidelines and revising the non-horizontal guidelines. And it has specifically mentioned about the theory harm related to the two-sided markets. That's the feature of the digital platforms. And they recognize the indirect network effects and also the technical tools, the algorithm, big data, platform rules, and those are the very important features that the agency would look through. For the digital economy, we've probably seen that there is a significant enforcement in the year of 2021 and during the very difficult time of the pandemic. The agency issued the anti-monopoly guidelines for the platform economy and also confirmed the jurisdiction of the official investigations against the gun jumping and below threshold mergers. And also specified the emphasis on the killer acquisitions. For example, we have seen in the year of 2021, Huya Douyu merger, the two game streaming platforms were blocked. This was the third blocked mergers. And Tencent Music and China Music Corp has received the remedies regarding their exclusive dealing conduct. And the Meituan Dianping, the local food delivery apps, and they have received the exposed merger review as well as the Didi Uber China merger. So Alibaba also received the huge fund of $2.8 billion for the exclusive dealing, 2选一, choose one from the two. So those are the very important enforcement actions that the agency has taken. In the private litigation, we have seen the JD Alibaba litigation. We have seen the recent news about the Tencent Music and NetEase. So there are many private litigations going on in China, and that has been very active. And I have asked, and I had the conversation with Professor Huang of UIBE, University of International Business and Economics. The principle of regulating or like enforcing the antitrust or the anti-monopoly regulation in China is that we won't follow EU, we won't follow the rule setting of EU, but we probably will be closer to the United States. I mean, we probably will promote the market competition and also leave the companies play their role in the whole industry. And if we visit the semiconductor industry in China, this industry has received a significant scrutiny, antitrust scrutiny recently, and especially because China heavily rely on the foreign technology as well as Taiwanese companies as the upstream player. So the agency has imposed the very strict rules in the merger reviews. I helped the agency review the global mergers a couple of years ago, and the supply chain security becomes very important concerns from the agency and has been mixed with the competition theory harm. And this is something that people and also practitioners want to pay more attention. And also friend remedies, it's often used for the telecommunication. I think Frank, you probably you're very familiar with this term, but it has been heavily used in the merger remedies recently. And I just count down during the time of 2018 to 2024, 21 out of 28 constitutionally approved mergers received friend remedies in China. It's about 75%. And during the same time period, 10 out of 11 conditionally approved semiconductor transactions have received friend remedies. So carefully designed friend pricing terms becomes very important for the compliance. So in China, semiconductor industries is very important, but also may probably experience very significant antitrust investigations as well. So I just pause here.
Thank you very much, Vanessa. Just a quick follow-up for personal interest. You mentioned about the remedies imposed by probably the government. I'm just wondering, in your experience, before the remedy comes up, is there any dialogue, negotiation between the company and the government, or even the business? Is the business have the opportunity to make some kind of suggestion, advice to the types of remedy they consider might be doable or applicable to the industry as a whole, in your experience?
Yeah, that's a very good question and a very interesting question. So I think the companies has the opportunity to negotiate, propose voluntarily their remedies before the agency, and take advantage of that moment, because that can gain you the opportunity to get the deal cleared within the very pressing time limit. And in the meantime, I think you probably know that in China, there's no litigation after you get the decision from the agency. You have the opportunity to appeal, but oftentimes the companies, the fighting parties decide not to do that, because that kind of the negotiation has to happen before the decision. So I think this is a kind of like a concession between the fighting parties and also the agency, that we agree on certain rules and the remedies that you get some deal from the easier clearance. And I have seen several deals that the companies voluntarily propose the remedies, or like a commitment. I won't say like the remedy, commitment. It has the clearance, the smooth clearance, and the agency won't impose any remedy. And this is another form of ex-ante negotiation with the agency.
Thank you very much, Vanessa. I think no competition, no conference on digital competition will be satisfying without a gentle touch on the white paper on competition policy we just reissued in 2022. So on that note, I would like to turn to Mingli. As you may know, that the TFTC has just released the white paper on competition policy in digital economy in 2022. And actually in the white paper, we didn't catch the coattail of the Brussels effect. We insist on following the conventional evidence-based, issue-driven, and based on rule of reason. So I just want to know, probably you can use this white paper as an example to commentate whether that is a good approach or not. Well, is that outdated? And also, I would like to know your personal reflection or perspectives on using competition policy to advance industrial policy, if possible. So I also want to remind you, you don't need to be polite just because I happen to be the acting chairperson of the TFTC, okay? So Mingli, you have the floor.
Yeah, okay, thank you. I think the white paper took quite some heat in academia, but I personally happen to agree, especially in principle, in competition law is that some of my colleagues, well, many of them good friends, taking cues from the so-called New Brandeis School and argue for a more active role in regulating the digital economy through antitrust law. But I think the white motor case, Andy mentioned in the keynote, I think it's a good reminder that sometimes patience is a good virtue. And especially it's written, the case is written by Justice Douglas. And Douglas is, well, it's one of the first, the so-called neo-Brandeisian. And so I think that's a very good caution. And especially that EU's approach as seen in Digital Market Act and Digital Service Act, especially the latter. But I think a large part of it's actually competition. It's not competition law. It's in fact industrial policies in disguise. They are, well, I see them mostly as it's EU's attempt trying to rein in on the big players, mostly non-EU companies, and trying to take it as an opportunity to show up their own digital economy. Well, I wouldn't say that's the wrong approach, but it's industrial policy. It's their attempt to make digital economy a more viable industry in Europe. But as all industrial policies, conditions matter a lot than competition law. The traditional competition law approach, we have some, you can say, universally accepted common principles. But with industrial policies, it varies greatly from state to state. As I say, I was educated in California, and California has a very interesting neighbor called Nevada. Okay, and my professor, I remember vividly, my professor at the law school says that, well, Nevada basically make a living by permitting whatever California forbid. Okay, you can gamble, come here. Okay, difficult to divorce, welcome here, etc., etc. Okay, and so it turned Nevada. Well, it make it possible to have a relatively vibrant economy, especially in the early days, in the desert. Okay, it's basically a state in the desert, and they find a way to survive and to prosper. But the same approach doesn't apply to just about any other states in the United States, right? It worked for Nevada, but only Nevada. And so it's the same. If Taiwan is to take cue from the EU or try to mimic whatever EU is trying to do, we have to ask, do we have the conditions for it? Okay, do we have for example, the leveraging power as the EU market with such a tiny local market? Okay, and etc. There are a lot of things to consider. And so I'm not saying that we should just, well, I'm not that radical to say that we should just get rid of all industrial policies. But for industrial policy to work, we have to think carefully what works for Taiwan, given our strengths and weaknesses and all other conditions. That's my opinion.
Thank you very much, Minnie. Great to know, to have your support. Okay. Payal, I know you have worked for the CCI for more than 10 years as a professional economist. Could you share some of your experience during the time that you worked for the CCI regarding the successful enforcement experience that the CCI used remedy, used advocacy to convince or to implement the smoothly operation of the industrial policy? I will assume there are many, many successful stories. So you have the floor.
Thank you. So industrial policy, competition policy, there's purity of instruments is no longer there. So competition policy, when I joined, I was naive as an economist, was talking about just efficiency, etc. But my engagement with the bureaucratic commission, in some sense, did not change my mind, but also gave me a perspective that competition policy and competition law is one instrument out of the whole architecture, regulatory architecture and policy architecture. And there could be some policy objectives, some, for instance, in the digital markets, the objective in 2016 was a huge digital transformation, and the current competition and the level in the telecommunication market was not supporting that. And so therefore, a disruptive entrant was brought through relaxing some of the regulations, and which could be against a level playing field for already existing players. A lot of, and it did lead to the shrinking of the market, because many players exited because of the disruptive entrant, and I think you know whom I'm talking about here, when Jio entered, but the objective was to be able to change the status quo such that tele-density increases, and now we have 9 years of hindsight, it did increase. Yes, it did impact competition, it did impact the point, and CCI's advocacy in that matter did not hold good stead with the government, because at that point the government's ambition was to just increase telephony access for delivering digital transformation. Having said that, even competition law has sometimes given in to the government's industrial policy of actually being a techno-globalist in some sense, allowing a very, very permissive environment for M&As, because scale was one of the objectives of the industrial policy, to increase the global standing of some Indian firms, because competition was now moving away from domestic to international. And so therefore, there has been some kind of a hand-waving when it comes to clearances of certain M&As, keeping that industrial policy in mind. But I don't think that a very, very pure competition policy implementation would have been wise, given now that we know that we have been able to bring in a lot of foreign investments, because foreign investments was on top of India's, investment was on top of India's agenda, and if that meant relaxation of certain M&A rules, so be it. So the industrial policy and competition policy have sometimes worked in synergies, but sometimes there have been tensions. Just to give you one last example, that the competition authority has been implementing and enforcing strictures against the big tech, be it Google, Meta, in the WhatsApp case, and also an Indian homegrown big tech, Make My Trip. Various antitrust orders have been passed, but when the digital public infrastructure has trying and is resulting in mirroring of the same kinds of anti-competitive conduct, be it capture of the infrastructure layer for data extractivism, and the data layers, such that we are now in the UPI, that is the payment interface. We are just ending up with two large players, resulting in re-centralization and remonopolization of the digital, of the application layers. I think the advocacy has been a bit muted, I guess, to be aligned with the industrial policy of the government to increase payments and make digital as a default when it comes to payments.
Thank you, Paya. Finally, I would like to turn to Huang. I know there is a continuous sort of a tug of war between the Congress and the industry regarding the necessity of promulgating or enacting a DMA type of legislation to address the problem in digital market in Korea. Can you update the recent development on this front? And what is your view regarding the regulation? Huang, you have the floor.
Before answering your this is working, right? No?
Use the
Okay,
microphone.
okay.
Let me share some of the experiences in Korea about the plausibility of a industrial policy, and I totally agree with Professor Wang's view about saying that a long-term vision is a rare commodity for a government. I totally agree on that. And I have chaired the Innovation Economy Division of the National Economic Advisory Board for the President of Korea several years. And last year, we invited many researchers and executives of private firms in the field of semiconductor industry to revive, because 1.5 years ago we were concerned about the future of Korean industry, semiconductor industry. And all the researchers and even the richest firm in Korea, they all approach it and say that, just give me money and leave me alone. That's all we want. Our top engineers are moving away to United States or China for more salary. It's a real danger, real threat to our future, and please lock them within the Korea. It means we are exposed to the government capture. At the time, they also said that at the time that the HBM sector of the semiconductor was fast growing. And many of them say the HBM has a very limited market size. It is not of great concern for the market. And it proved to be wrong only after 1 year. That means the government has no information to make a sound decision on what the industrial policy should be like. Even today, the new administration in Korea that started just about 2 months ago, we are conducting a beauty contest among many Korean AI firms to make a choice about who should be the sovereign AI developer. I'm not sure about the final decision and should the future would like be, but many are concerned about how correct the government decision would be like. And today, the third example is that the KFTC today, they announced that they are imposing heavy fines over the Korean airline. There is a merged firm between the Korean airline and Asian Airlines. The fundamental decision to approve the merger was made without the contribution by the KFTC, but by the departments of government who are in charge of the industrial policy. And I guess that the primary reasonable purpose to approve the merger was recover the government public fund to save the endangered industry during the COVID-19 days. So in conclusion, I'm saying that the industrial policy is very, very effective, but at the same time, very, very difficult to execute. Very hard job to make. That's my observation. And I want to give a quick answer. I understand Emily is pushing you to keep the time. And I really appreciated the Taiwanese, the white paper in 2022, because in designing Korean legislation over the digital platform regulation, it was of great help to us, and it kindly appeared in several of the Korean conferences and interested your experience, and it was very, very helpful. We all know that the current government started arguing for the ex-ante regulation over digital platforms 5 years ago. We are still in the middle of the argument and controversies. And the Trump administration, they intervened in the beginning of this year, and it became a determinant factor today. The new administration, during the presidential election, just a few months ago, they publicly announced the promise to introduce the DMA-like, the ex-ante strong regulation. But, well, the Trump administration says, well, no, you are discriminating U.S. digital platforms. You are not going to do that. And we don't know what to do right now. And it can be rightly expected that some small parts of the proposals may be legislated in the future, but no one knows, because even that a small portion of the legislation, the Trump administration says, well, it has a potential to disadvantage American platforms, and so it should be a big trade negotiation concerns, and so no one is sure about the future. So my conclusion is that, well, even the cutting-edge industries like the digital platforms, semiconductors, and everything, the government has very limited resources to make a right decision, and consumer policy has a comparatively very limited voices over the government decision. So we need to make a sound compromises, harmonization between the two policies. Thank you.
I think we are running terribly out of time limits. So you can see Emily pointing aloft at the back of the seat. Thank you so much for your participation. I think in conclusion, I will share a quote from a very famous economist, Ruchi Agrawal. He said that just like a salt in cooking, a pinch of industrial policy can be helpful, but too much can overpower, and the prolonged excess can harm. And from this discussion in our panel today, I think you will know how complicated but also intriguing this trilemma is. And I hope our discussion could point to the path forward for us to think about how to address this challenge in the future. So join me again to give a big applause to our distinguished panelists today. Thank you. Thank you so much. Thank you so much.
Well, good morning, everyone, again. Welcome to our panel on dynamic competition. The central theme of our conversation is really one of the most pressing questions in competition policy today. How can we effectively integrate the realities of innovation, investment, and technological change into an antitrust framework? And for a long time, antitrust has really been focused on static measures, things like market shares at a particular point in time, short-term price effects, output effects. But we know that competition is often a dynamic process, a race to create the next great product or better way of doing business. And the challenge, of course, is that these dynamic effects are much harder to measure and predict than their static counterparts. And so there is definitely the old joke about the drunk looking for his car keys, in the street, and someone comes up and says, "Where did you lose them?" And he says, "Over there." And he says, "Well, why are you looking for them here?" And he says, "Well, because the light's better here." There's the static effects are under the light, and dynamic effects are in the dark. So our goal today is not to solve this challenge in 90 minutes, but to explore it from several expert perspectives. We're going to try to have a free-flowing conversation, an exchange of ideas about what dynamic competition is. I think we should probably define our terms first, how it works in the real world, and what it means for enforcers and businesses and consumers. Now we have a really stellar panel here today, and I'm going to introduce them very briefly. I encourage you to look them all up and see their full biographies, and I know you can all Google or nowadays chat GPT and find everything you need to about them, but I'll give you a little bit of information about them. On my far left is Reiko Aoki. Reiko is a commissioner with the Japanese Fair Trade Commission. She's an economist by training. She brings a wealth of experience from academia and enforcement, especially around the economics of IP and innovation, which was her field of specialty as an academic, and probably as an enforcer too. Maybe I should go in order. So Ian McEwen is a visiting scholar professor at the National University of Singapore. Ian is also an economist, has written extensively on the economics of innovation and antitrust, especially in Southeast Asia. He was also formerly the chief economist at the Singapore Competition Commission and spent a good deal of time at Australia National University as well. In fact, I believe was the founder of the Law and Economics Center at Australia National University. Kevin Shi is Deputy Director for Competition Law at Taiwan Semiconductor. He can offer a crucial on-the-ground perspective from one of the world's most innovative companies. It's always essential for enforcers and business people to learn from each other, and especially for the enforcers to learn from the business people. Dae-Sik Hung is the Dean and Professor of Economic Law at Sogang University. He has deep expertise in competition law generally and Korean competition law in particular, and also in particular its application to technology markets. And then at the far end is Yalun Yen. Yalun is a law professor and a commissioner with our host, the Taiwan Fair Trade Commission, who is of course at the forefront of applying these principles in a key technological jurisdiction. So I think we should dive right in and ask the preliminary question of, first of all, what do we mean by dynamic competition? It's always, we want to avoid talking in slogans, but there's definitely something very real and very meaningful that this notion of dynamic competition conveys. But I think maybe I'll ask each of you to say, if you can, in 5 or 10 words, what you think dynamic competition is. Now, I mean, it could be something as simple as the effects on the incentives and capabilities to innovate. I'm not saying you have to, provide a Wikipedia-level dictionary definition, but just what it means for you. I'll start with Yalun. Yeah, I think there should be enough microphones for everyone. So.
Thank you, Geoffrey, and it's my honor to participate in this discussion. And this is a fundamental question, especially dynamic competition is a critical issue and challenging in modern competition law policy. And dynamic competition typically manifests in innovation-driven markets, and it fundamentally differs from static competition by emphasizing future market evolution rather than current equilibrium. And competition and innovation are deeply intertwined, though there is no single universal model of their relationship. And I also want to mention some supplementary effects and error effects about the innovation, capability, and the incentive discussion. And the Schumpeter pointed out that competition from new goods, new technology, new source of supply, and is more important than price competition. And large enterprises have greater resources, enabling creative destruction. According to Schumpeter's view, dynamic competition is superior to static competition. The prospect of obtaining temporary market power provide strong innovation incentives for both existing firms and the new market entrants. Strong innovation appropriability can also enhance firms' innovation capability and incentives. The Supercharger effect, as mentioned by Agent and others, indicate that dagger firms may have minimum innovation incentive because the rewards of catching up the leaders are very low. Conversely, the arrow effects suggest that monopolies have weaker innovation incentives because they must consider cannibalization of existing profits, what we call the replacement effect. Essentially, a monopolist must account for losses from existing profits, while a competitive firm has strong incentives to seize the market through innovation. This effect is particularly strong with drastic or disruptive innovation that could completely replace existing products.
So, Yalun,
yeah. So
I wonder if I could just ask, what I guess it's obviously means something looking to the future, and obviously we're looking at innovation as the dimension on which the competition is happening. And in some ways, I think you alluded to this, often we're talking about a competition for the market rather than a competition of, allocating shares sort of within a market. I guess, so before you go any further, I wanted to ask you whether you think that, conceptually, we get that, but practically, how do we measure that? I mean, it's not surprising that we have this focus on static effects because, as I said, you can measure them. And so I don't want to get too far ahead of ourselves, but I just want to ask whether you think, it's one thing to talk about these things in the abstract. As a practical matter, do we have tools that will enable us to focus on dynamic competition? And I really want a very short, it's just almost a yes or no answer, because we're going to come back to it. But
I think this is an extremely hard question, especially when we need to predict future development. Right. And we probably may resort to some theoretical frameworks help, but we need some fact-finding and some qualitative evidence to support each cases and to make each case analysis. Yeah. Otherwise, we can have any essential and sufficient evidentiary support to our case.
But okay, so maybe Dae-Sik, again, we're getting a little ahead of ourselves, but I want to just go where the conversation goes. So you mentioned evidence, and excuse me. I mean, how is it possible to get evidence of future innovation? What are the things we should be looking at? David Teese would say we should be looking at dynamic capabilities. We should be looking at the abilities that are within the institution of the firm to take advantage of unexpected, unpredicted future innovations, for example. Not that David or anyone else has a very good way of measuring that, but it's a good concept, certainly, to think of. What do you think, what is the possibility of getting evidence of this kind of not yet existent competition that we could actually integrate into antitrust enforcement?
Yes. First of all, I am very honored to be part of this wonderful panel. I'm very grateful for inviting me to this this seminar. Actually, before answering the question,
you're not allowed to not answer the question.
Okay. I just one remark. Yeah, the word dynamic reminds me of my everyday life in Seoul, Korea. Seoul.
Is that mic not working?
Okay. People in Korea live a very dynamic life. Less than 10 years, we Koreans impeached 2 presidents. So it's more than dynamic. And then KFTC. Yeah, the KFTC, yes, in Korea, a dynamic competition is not just a theoretical matter. It is realized in the real case. Yeah, I'll talk about Qualcomm case and Google Android case and in more detail later. In both cases, KFTC questions about harm to innovation in just a complementary way and then standalone way. Most of all, in Google Android case, you know, the KFTC delineated the separate market is licensable non-mobile OS development market. It's a kind of innovation market. And then in that market, KFTC recognized that the Google Android's anti-fragmentation agreement infringed the Korean competition law by harming, by deterring innovation. And that is the only harm to competition. There's no such thing, price reduction or quality reduction, only innovation harm.
That's the basis of the finding, is purely an innovation harm.
Yeah, and I wonder how the KFTC could reach that conclusion. What kind of evidence support that? I don't know.
Let me just mention, you talked about the anti-fragmentation agreements. For those who may not know, with an open operating system like Google Android, there's a risk that you know, companies and others will adjust it for their own needs, and it'll fork, is what it's called, and we'll have multiple versions of the same operating system. And there is Google at least thinks, and everyone I think agrees, there's some value to having you know, a sort of a single standard. Google can then push out updates, right, to everyone. If there's forking has happened, no single update can update for everyone. There are lots of reasons why it makes it harder for developers, for example, to develop. You have to develop for all the different operating systems, the forked operating system, not just the one. So so here's my question is you could argue that is beneficial for long-term innovation, especially if you're looking at what happens for developers, for example. If you allow forking to happen, then you've just increased the costs for all your developers, which presumably in the long run will make it less likely that you'll get, you know, at the margin, you'll get innovation from them. Now, in neither case are we going to have actual, you know, evidence of what's going to happen in the future. So from an evidentiary perspective, I'm not saying that looking at an anti-fragmentation agreement as that it's sort of inherently more pro-innovation than anti-innovation. But I am saying that I doubt that there's any more evidence on one side or the other.
Oh, yes, I recognize some evidence. I don't know the details of the evidence, but the KFTC pointed out there are some internal document showing Google's intent to disrupt, to prevent it's a device manufacturers to develop non-OS development, non-OS software. And then the KFTC took one example, two examples in particular, for Samsung's case and LG's case. Samsung tried
what
to
was the second one?
LG. Yeah, Samsung tried to develop, you know, non-mobile OS into wearable device, and LG tried to develop non-mobile OS into smart TV, but they gave up their attempt because of AFA, anti-fragmentation agreement. So for those examples, KFTC very conveniently recognize the harm to innovation, but I'm not sure it is so sufficient to that to that objective.
It is at least some evidence. That's
Yeah.
better than nothing. I mean,
Oh, yes,
we can,
better than nothing.
we can
You're
say,
right.
And I do think that it's not sufficient, right? Because they probably didn't consider. I mean, for example, this is one of the problems with static market definitions. You're sort of locked into looking at the operating system market, and you almost intentionally, for maybe good administrative cost reasons, don't look at what happens to developers, right? Because you're looking at the effects in this one market. I mean, I'm not saying that you always do this, but you might. And it might actually be that the benefits for developers outweigh the harm to a competing operating system creator. And again, I think it doesn't tell us anything. We're going to come back to the intent question, because I think that's a really interesting one. When you don't have any actual evidence, enforcers always say, well, they meant to do this. They meant to do bad things, as if that's an answer. But we're going to talk about that. Okay, well, let me, it's my fault for bringing us down this evidentiary road so early. So I want to come back, take a step back again, back to our original question of what dynamic competition is. Yalun did a great job of talking about the role of innovation, the importance of large firms having the ability to innovate, of course the arrow effect as well, which sort of cuts the other direction, which goes to the point that we don't really know anything. Or let me ask somebody who works at a big firm, what's your definition of dynamic competition, I guess? What does it mean to you?
Thanks, Jeff. I would give very short answers. So dynamic competition for me means three things, right? So I think the first things, like Yalun said, Joseph Schumpeter talked about, destructive innovation. And for me, that's the race to win the technology leadership. And we are doing that every day, right? Like in the semiconductor world, people probably know we have so many different nodes. Nodes means definitive manufacturing technologies. Moore's law predict we need to have one new technology every 2 years, and every new technology will replace the former one. So that's one type of dynamic competition. I think that supports the notion that current success does not guarantee at all future success. So that's one type. The second type actually, I think, contradict the arrow effect, right? So arrow effect things assert that the successful firm will be less incentivized to innovate, which is wrong in the real world, right? You look at the tech industry, people need to continue advance, push the technology envelope. Like, we got GPU, we got CPU, we got AI. That's how you grow the market. Grow the market may cannibalize the prior application, but enable so many more. And that's how semiconductor industry can grow 5-10% every year for the past 3 decades.
Is that just, sorry,
Yeah.
Just really quickly, how much is that motivated by the contestability of the market and the fear that if you don't do that, you won't be the leader for very long? I mean, you can't, right? Isn't that the point, at least part of it, that you can't rest on your laurels, because in these kinds of markets, once you're the leader, you may not be the leader tomorrow if you don't.
Right. Definitely, I think that's some of it. Yeah. But I think the desire to reinvent yourself to grow the market is independent from the competition with your peers. Right. Even without competition from the peers, the leading firm or the people in the market have a strong motivation to grow the market, grow the pie, right? So always you can, grow your business by getting a larger share, or you can just grow the pie. And I'm saying that in the real world, growing the pie, the motivation from growing the pie is a huge incentive.
Yeah. It's really something worth keeping in mind. I don't think it is any part of antitrust enforcement. Or even IO economics. But you're talking about a sort of human psychological factor. You're talking about the way people behave in the real world, and you know, the standard line is once you're, you know, what is it? The greatest reward of monopoly is the quiet life. You know, the idea that once you become a monopolist, you don't have to try anymore and you can go on vacation all the time, whatever. But, you know, the people who actually have the drive to become monopolists often don't lose that drive just because they become a monopolist. I think to some extent that's what you're saying. And of course, there are institutional reasons for this, because if you're a publicly traded company and you have shareholders, you could try to rest on your laurels, but they're not going to be happy about it. So I mean, I think it's. I mean, I would love to see if anyone thinks that this is a part of the way we think about antitrust. I'd love to hear otherwise, but I don't think it is. And maybe that's because it defies measurement. Right? We can talk about it as a concept, but I'm not sure we can measure the strength of that kind of psychological impulse to continue to expand. All we can do really is acknowledge that it exists, but that's at least something, I suppose.
Yeah, I guess it's not really just psychological, right? Like you mentioned, Jeff, like every public company, they get to tell the investor, I'm growing 30% every year. So it's built into the system, and I'm glad you mentioned the problem of how to quantify that. I think at least in U.S., right, like people does not really need to quantify it, because the Supreme Court already say competition law is to protect the competitive process, not to protect competitor. So really what comes down to it is what is exclusionary conduct, right? So it's really more a qualitative analysis as opposed you need to quantify it.
Yeah. Oh, well, we're going to come back to that too, because I think the problem, of course, is one man's exclusion is another man's long-term dynamic competition. And so I mean, I agree in the abstract with you, but I don't think it solves our measurement problem. Okay, well, let me turn to Ian briefly. Ian, maybe you could talk a little bit about. Give whatever answer you want, but I was hoping you might. I know you might talk a little bit about maybe some of the economic history of the idea and why it's something different than static competition. Why isn't it already a constituent part of antitrust?
Okay, you've gone over about 7 pages of my analysis, and I've got to find bits and pieces from it now. Look, I was going to start off with G'day. Many times in Asia, people have said to me, you don't speak like an Australian. And I find that very surprising, because I come from the country where allegedly the true Australian speak. In fact, neither of my parents even went to high school, because back when they were growing up in school, it was too far to ride on a horse to a high school. Now you think about how they would have been predicting what the world would be like now, 100 years later. I mean, it's just impossible to do. And anyone who believes that you can do it, I think, is fooling himself, or they've got a vested interest in doing so. So, look, but anyway, the original question was in 5 words or less. I can do it in 8 or less, so I'm going to indulge you for 3 words. Really, dynamic analysis addresses how competition, innovation, and strategy evolve. Now, a point I really want to make is firms have always considered dynamic competition as part of the general strategy. Competition regulators have always considered dynamic efficiency. Barriers to entry was a very big issue back in the 1980s, which is looking at future competition. Right. And Stigler has a different definition of what constitutes a barrier to entry to the interventionist school, I call them, who argue that it's any potential impediment to entry, which I think is totally wrong. So look, we always have considered dynamic competition in one sense or another. Okay. But why? So the question is, why do we now consider it in a broader sense? And I think the explanation for that is the changes in technology that are occurring now are far, far more widespread than they would have been 50 years ago. Our innovation occurred 50 years ago would only affect one market generally. It would be the cost of producing steel or alumina, if you're American accent. But now things like AI and digital technologies are affecting a whole range of industries at the same time. And so obviously competition regulators have got to be more focused on potential competition than they would have been in the past. So look, I don't think it's, there's another explanation for why so much of it is occurring at the moment, and that is that so many countries around the world are now adopting competition laws administered through a legal system. The legal system wants certainty. They want definitions about what various words mean in different contexts. And that is what really is driving a lot of the debate now.
So, okay, so really good point that we should also come back to. We're going to come back, have so many things to come back to that we're never going to make it. But about the extent to which a more traditional sort of static approach actually does have dynamic elements to it. But I think that the big difference is, it's another way of saying dynamic doesn't just mean that we're making predictions about the future. It has something to do with innovation. It has something to do with a world in which competition is happening on a kind of a different dimension, one that I think tends to be non-simultaneous. Right, you know, it's so it's a little bit of competition for the market. It's a.
Can I add something else,
yeah,
which is
of course,
a bit
and
different
anyone else who wants to jump in can
can
try to as well.
Yeah, look, the problem is that most people see this as an issue of adding on dynamic efficiency to static models. I don't see it like that at all. I don't believe that that's the proper approach. I think dynamic efficiency has to be competition has to be considered as the first element of any analysis of antitrust analysis. The first, you start with that, and but
what does that mean? How do you start with that?
Means, but see, the problem is, you look at a lot of the literature, the history of competition analysis dynamically. It's always adding on to something, you know. Whereas I think that now is real time to come up. Look, Thies was doing it to some degree. But again, he was still adding on to the existing models of competition.
You're saying we need a complete sort of revamping.
Yeah, but particularly in dynamic, in digital economies. Right. It's a different sort of problem.
Right, we're definitely going to come back to that. Okay, so I want to let Reiko talk for a minute. I want you to answer the question as well. And I also want to ask you about, I have a couple of questions for you. I'm going to ask one that comes out of order from our plan, and you can answer what you want, about the role of intellectual property in this. We talked about innovation, we talked about you know, the temporal issue involved here, and IP is definitely, it's certainly, you don't have to have IP, you don't have to have patents in particular to have a world where dynamic competition is going on. But it does happen a lot, and IP is of course intended to open up a sort of space for innovation into the future, but whatever the term of the patent is. So if you'd like, I want to hear your answer to the dynamic competition question, and then maybe a couple of words about how intellectual property fits into this, because it seems to have a place.
Thank you. Thank you, Jeff. And I also want to thank Andy for organizing this event and opportunity to speak. First, I'll talk about dynamic competition. Everything that needs to be said has already been said, I think. But intertemporal, I think, is the key. And I just want to remind everybody that in intermediate microeconomics, in addition to this downward slope, supply and demand and utility maximization or profit maximization, you also learn about the U-shaped average cost curve and how you go down that curve with exit and entry. And I think that's a very important part of dynamic competition. And also, you need that entry and exit moving up and down the average cost curve in order to have efficient allocation of resources. So I think that's something that I think everybody's covered, but I like to remind everybody. And getting to the IP question, IP's there exactly because of this uncertainty about what you're going to get in the future, right? Patents, people often find are either too long or too short for whatever discovery you made. But the good thing about it is you know what length it is going to be, and you don't know what you're actually going to be discovering. So it's, in a sense, it's predictable in an unfortunate way, but I think it's very important that it doesn't vary depending on what discovery you make, because it would make your appropriation very uncertain. And it's, by definition, there's always this dynamic versus static efficiency with IP, just like we would have in antitrust also.
So you mentioned appropriability, which is obviously an important, which is, mitigating or making appropriability more difficult when it's, non-contractual is one of the purposes of IP. And Yalun, I think you have some thoughts on different types of innovation and the appropriability of innovation. I don't know if that maps onto the IP question. I mean, it must to some extent, but let's talk about that for a minute. One of the issues with dynamic competition is that if you can't capitalize on the value of your investment today, you're not likely to make that investment in the first place. So we do have to have some kind of mechanisms that look almost like monopoly-like protections to facilitate, room for companies to make these massive investments today to realize innovations tomorrow. I don't know, how does that, are there different types of innovation? Are there and do they fit into antitrust analysis in different ways?
As for the appropriability issues, and if one innovation could be patentable and by, especially for the product patent, the appropriability is high, and it could be less necessary to be a monopolist and to recoup its investment. But as for some process innovation that is inappropriate or could not be patentable or protected by patent, probably the innovator need to expand its scale to prevent imitation and to deter the spillover effects. And so we are vigilant, especially for some product patent innovations. Because
grab the other mic.
Especially if this product patent innovation has been held by some dominant firms, and we will be careful to pay attention to if this firm has adopted some exclusionary conduct, and this conduct cannot be substantiated as promoting innovation. But I agree this is always very hard, especially we need to consider the patent holder need incentives to keep their investment in research and development. But we also need to consider the gaps between the existing competitors, especially between with a dominant firm with a strong patent protection, and we will need to consider if this will deter the follow-up and follow-on to innovation, especially for some technology implementers. Thank you.
This is, Reiko has papers on exactly this topic. Well, okay, so I want to, Kevin, the process that Yalun just described sounds an awful lot like your industry. There's a lot of leapfrogging in your industry. There are examples where the dominant company in at one technological node is not the dominant company at the next node. And there's a lot of IP in your industry, too. But I have no idea. I'd love to hear, to the extent you can, talk about sort of, I guess, two things. One, how important IP is to, how important you think it is, at least, to a company like yours' success and ability to appropriate the value of its investments. And then secondly, whether there are, sort of other types of innovations that are not patented that may be more or maybe less important in facilitating that competition to be the leader?
Yeah, thanks, Jeff. And I would say I would agree with what Yalun just said, right? So patent definitely is an important incentive because, it's protect intellectual property right, and you need to have these man-made rights given to you so that you can hopefully recoup some of your investment. But patent definitely is not everything, right? Like I think Yalun pointed out, a lot of the know-how in semiconductor is protected by trade secret for the exact reason
but it's still intellectual property.
Yeah, but it's not patent. And and why is that is exactly what Yalun pointed out, right? Like it's hard to detect infringement on process patent, right? So I think people will try the alternative, right? With patent, you need to sue people. With trade secret, you just need to keep it secret. As long as you keep it secret, no one will know, right? So, and I think that goes to Yalun's points that when it's higher enforcement cost, then you need to have some other asset to be able to capitalize on your research, right? I think semiconductor might be one of the example because it's so hard to protect the process by patent. So you got to build your own fab, right? Yeah. If you want to do process technology innovation.
So, okay, that brings up a great point that I would love for you to answer, but again, I understand that you may not be able to, so others can suggest they know how this actually works, even though they don't. So one of the things you suggested is that you'll see investments being made in capabilities to capitalize on, to appropriate investments, ideally in ways that others can't easily emulate. That becomes a source of differentiation. We can capitalize on this investment. We can't actually keep you from learning about the patent or whatever, but it's fine because we have a much greater ability to actually take advantage of it and keep ourselves ahead of the competitor. Now here's my question. There's presumably some of those kinds of abilities take a lot of investment, or they may come in the form of contractual restraints that might, to someone's eye, look anti-competitive, look like the goal is, in fact, the goal is to exclude to some extent. That's the whole point. But it suggests that from one perspective, from a more dynamic perspective, these things might not be so problematic, and in fact may be facilitating a kind of investment that has to go along with the more direct, I'm speaking in very generalities. Let's say it's something like, on the one hand you have the innovation investment, the R&D and the like. On the other hand, you have, like Kevin mentioned, you may have a massive investment in physical plant. You can't really take advantage of the R&D if you don't have multi-billion-dollar fab and I'm assuming this is how it works, in semiconductors, right? And if you make that investment ahead of all of your competitors, even if they have the technology, they're still going to be behind you. Now, I don't think anyone thinks that's an antitrust problem in making that investment, but I also don't know that it's not the only kind of investment, and it's not the only kind of arrangement that might be made to sort of facilitate this. You might enter into long-term contracts. You might enter into if you might exclude others. So you have well, I don't know. I don't know enough about the industry, but you can imagine things that might look problematic, the goal of which is to facilitate appropriation. It can't be that we think a patent is the only way you're allowed to do that. So how well do we take account of these other ways of doing it in our yeah, anyone can jump in.
It depends on what you're protecting. Like Coca-Cola, the secret has been kept for more than 100 years. No one, allegedly, there's only 2 or 3 people who wear black hoods and etc. to access the formula occasionally. But look, in that sense, the appropriability problem is not difficult. You don't need to. The problem with the patent system is you need to disclose the formula. And so there is an incentive so there is the type of product that will be protected by a trade secret will be products where it's easy to keep the secret.
Yeah, okay.
And look, perhaps the patent system could change in a way which those sorts of protected ideas, etc., are disclosed subject to perhaps relaxation of the antitrust rules, like the sort of things that you were talking about. I mean, you've got to think outside the box. It's not just the IP system, it's a combination of the IP and the antitrust systems.
Well, so, I mean, I guess, again, you don't have to answer this, Kevin, but would it be accurate to say, for some industry, that upfront investments in, say, physical plants is intended to be a form of exclusion in a way? It's we build factories that we don't know for sure. I mean, we hope and we expect that we're going to use the capacity in them. But the main thing is we get them built before someone else does. That sort of guarantees us a place in the market and in a way excludes them from the market. Is that part of the intention? Is it part of this ongoing race to maintain leadership?
No, not at all. I think you first get the technology, and then you will think how to get your return, right? And there are multiple ways to get your return. Like in pharma, probably a patent can do the trick. But in other industry where patent right is not easily enforceable, or like every other firm have like 10,000 patents, so it's never going to work that way. You get to use different route to capitalize on your research. And I think in semiconductor world, especially on the manufacturing side, right? To build a fab is a very straightforward way, right? We got the technology, and we want to make sure everyone get to use our technology, so we got to build a fab. Every other firm can build their own fab as long as they get the technology.
Well, that's an important point, right? There isn't any actual exclusion in your building a fab doesn't preclude anyone else from doing it, but it might make it economically impractical for them to do it.
Yeah, definitely. If certain firms build that capacity, that really means something to everybody else. That you mean business and you're willing to produce up to capacity. I think that's a very important. It could be an important signal.
Whether intended or not, it could be. Yeah, fair. I think that's the one that works.
Again, taking for real case, Qualcomm case. Samsung Electronics also very successful competitor in the semiconductor industry, and actually the company started with a foundry business, but in mobile phone industry, Samsung Electronics complained about the high royalty for Qualcomm. So it decided to enter into chipset making industry. And Qualcomm, I think Qualcomm was fearful of that approach from Samsung. That's why they designed a very unique license policy: no chip, no license, no chip. And then that's the that's the beginning of the case. I think the competition authority carefully consider what the mechanism of industry is going on. Yes, if Samsung Electronics just remained as and satisfied with the foundry business, and no such thing with the KFTC intervene the practice of Qualcomm. So the Samsung Electronics has a capacity to invest on R&D, but they require the license from Qualcomm. That is a very standard essential patent. So in that case, I think to kind of to protect the incentive of Samsung to enter into that chip making market, the KFTC had to intervene in that scene and punishing Qualcomm.
Okay, but this is a great example that really highlights the sort of push and pull of dynamic competition, and inherent in IP, in fact, because we also need to make sure that Qualcomm has the incentive and ability to take advantage of the massive investment that it made ahead, beforehand. As I understand it, Qualcomm wasn't doing anything that violated FRAND agreements. They weren't, I would say, weren't doing anything that violated antitrust agreements either. That what they were doing was acting like a vertically integrated company that had two revenue streams, and they were optimizing between how they earned revenue from those two revenue streams. We should encourage that. And the problem, but at the same time, you could see that it might impede a competitor. Now, what do we do about that? I mean, we have some concepts that help us, like we only worry about an equally efficient competitor, right? We don't worry about, if Samsung was just bad at doing trying to copy what Qualcomm was doing, we shouldn't intervene to try to protect them. But maybe there's evidence that they or someone could have been just as efficient, just as capable, and yet still unable to compete in an environment where Qualcomm had this policy. So how can we? So on the one hand, I mean, you can take issue with my setup here, but my setup is the no license, no chips policy was essential for Qualcomm to continue innovating the way it had already, because it was how it earned its revenue. And at the same time, it may have been something of an impediment to someone else entering the market. Which is more important? What are we supposed to do? I mean, again, now, I'll tell you my view later. The case was terrible, but I want to hear others' views.
Well, that case, I can't remember the details of the case, but I had the impression that Qualcomm was trying to leverage the old patent, old SEP, to the next stage. So that's a case where I personally think is kind of abuse of using a patent, capitalizing on your legacy patent instead of a contemporary patent. And it's almost like Kevin was talking about firms always having this motivation to keep on innovating. If that's always the case, that's fantastic. But sometimes maybe firms are not as successful as they intended or something, and try to fall back on old patents to try to milk their patent a little bit more. And I can't remember the details of that chips, no license case.
I don't think that was an issue in that case.
Okay.
But what you describe is, of course, no, it's fine. I mean, it's a relevant concept, certainly.
Yes. There is always a conflict between innovation harm, offense, and then efficiency gains relating to innovation defense. And I think that if the competition authority decide to investigate and pursue some practice, there is always some theoretical framework to adopt. In the case, the KFTC presumed anti-competitive effect based on the vertically integrated company character of Qualcomm, and I don't think you agree with that, but they they recognize a breach of FRAND commitment, and combined with that two factors, the KFTC very conveniently presumed anti-competitive effect, and they consider that is more important than efficiency gains. And there comes some asymmetric approach.
Okay, so this is one of the issues I said we'd come back to, so maybe we can come back to it now. Oh, no, Yalun, I'm sorry, did you, please answer.
I just want to echo some discussion in previous, and I think the number of sufficient and capable innovators about capability and the incentives is still matters. And sometimes error effects still plays a lot of important role. As, for example, as we talk about standard essential patent, SEP holder, patent holder could be prioritized incremental, not disrupted patent to replace their patents to avoid cannibalizing their profits. So, in this kind of SEP licensing in SEP licensing issues and cases, sometimes we need to consider 3 dimensions. One dimension is for research and development market, and the second is about the technology market, and the third is about the downstream product market. And it's a very complex ecosystem. But in my view, I don't think we should assume that a competitive harm could be only limited to the technology market. We need to incorporate some consideration from research and development market, and also including the downstream market for technology implementers. But this balance is could be very delicate and very difficult, but I don't think we could limit our view to only one dimension. Yeah.
So, okay, so I think that's a great point. We've just, I mean, all we do is pile on complication, and this idea of dynamic competition becomes sort of less and less tractable. You've just expanded it now into every dynamic competition case becomes a case about 3 different markets simultaneously. And I agree with you, I mean, I think that's exactly right. Okay, but you framed it, and I know you didn't mean this to the exclusion of the opposite, but it sets up a good question, as we have to take account of the possibility that some conduct is having anti-competitive effects, not just in the technology market, but say in the R&D market. But what about the opposite? What about when you have, maybe you have some observable apparent harms in, let's say, the technology market, but as a consequence of this behavior, massive efficiency in the R&D market? Shouldn't that be allowed to offset the apparent harm? It can't be that we only identify effects on innovation that are negative. We must also have to identify the ones that are positive, right? I know Dae-Sik has some thoughts on this, and Ian, maybe you haven't spoken for a while, you can go first. The idea that we need to have some sort of symmetry in our treatment of the locus of innovation or the effects of conduct, and similarly, this brings us back to the market definition question as well. That means, as Yalun described, you can't just look at one market like we do in sort of more traditional antitrust if every sort of innovation, a dynamic competition issue has implications for 3 different markets simultaneously.
I was just going to say, look, I intended to be here as a disruptor. I've known Jeff for a long time, and before him, his father was one of the people who helped me to get into law and economics. He's a wonderful guy, one of the real founders of modern law and economics. I've got to say that because I agree with him on this. It doesn't make sense from an economic point of view only to consider the harms in a limited way. It just doesn't make sense, and that's one of the problems with antitrust. The need to confine benefits and costs to particular markets to fit legal definitions of what a market is. I'll leave it at that and not do any more disrupting.
Okay, well, okay, but I think I learned from you that I should just be the contrarian all the time. So on the other hand, if we're going to have an operative legal system, it has to be tractable. We have to, we have to make some, nods toward practicality. You can't just say, well, maybe you can. I mean, this is too complicated. Antitrust cannot apply here ever if any innovation is involved or something.
Well,
that can't be right.
The Australian system, and I'm a little bit out of date with what's really going on there, considers competition, but has a process for allowing other benefits to be claimed, and that benefit type of system. That's done through our competition tribunal. And I think some other countries,
and those benefits can be in other markets.
Singapore have got a similar system. Alvin would know more about what's happening there in Singapore than I do, but I'm pretty sure a competition tribunal there would allow for benefits.
In other markets?
Yes, in other markets to be taken into account in terms of anti-competitive.
Is that true for the JFTC and TFTC? Do you want to speak for your agencies?
This green things, with sustainable economy, I think we're beginning to consider that out of markets. And in our latest merger case, we did look at out of markets benefits. We did, but we talked about it, but it wasn't really in the trade-off. We thought the merger was okay as it was our traditional evaluation method, but we also realized in this case there was this extra benefit that switching to new technology would be speeded up, which was an added benefit.
And did you acknowledge
market.
it in
yeah,
the?
we did.
Okay, but what you're saying,
But that
I think
was not the trade-off.
Right, so
it was just an added benefit.
if the other analysis had gone the other way,
Yeah.
it might not have changed. It
That's
might
right.
not have been.
We didn't have to go there.
Right. Yaloon, what do you think? Oh. No, no, I like to put enforcers on the spot. Let's go with Yaloon first.
So, traditionally, we will not consider advantage from the other market to offset the anti-competitive effect in the relevant market. But I don't mean I want to break up this line, but my opinion is that we need to evaluate the overall effects and impact on to the consumer side for the whole consumer according to consumer standard. Even we adopt this and to try to keep this standard for consumer welfare standard, we need to incorporate three-dimension incentives and to evaluate and assess each competitor and the possible potential competitors' capabilities. And because in some cases, if the capability gap between existing competitor or potential competitor is huge, the leading firm could not feel the pressure, competition pressure from the other side. Even for the competition, for the market competition or dynamic market competition, the existing firm or leading firms need to keep their incentive and capability to invest disrupted technology or the next age development, precisely because there could be probably some potential existing competitor in the possible new market. Right. Yeah, so my view is to emphasize that we need to evaluate overall the impact according to consumer welfare standard, even if that, but especially for the SEP licensing question, if we only put attention to the technology market, this consideration could be too limited and it could not encompass entire industry incentives and innovation. Yeah.
I mean, inherently that means looking at other markets, right? I mean, it means that I don't want to put words into your mouth, but it means that the general approach of we look, you know, only at within market effects. We don't look at out of market effects, especially in mergers, but in other contexts as well. That in you know, dynamic industries, that's inherently misleading, right? And so, you know, here we can flag this for everyone who wonders what we talked about at this conference. I would say one of the things is we acknowledge, you know, we have a general agreement. You can tell me if you disagree, that's fine. That the very traditional approach to sort of market definition is not easily, at least, I'm trying to hedge as much as possible to get everyone to agree, is not easily consistent with the way dynamic competition works, which has this, you know, this sort of broader effects. I mean, unless you define the market as something, you know, much broader, but that's not traditional. That's not usually how it's done, and certainly it's never how the plaintiffs want to do it. So,
for example, the IP market, digital markets, as I said earlier, it has had an impact right across the board. How could you take that into account in an early decision about the misuse of IP or an antitrust case? You would not have even considered it at all, and if it had been thwarted back then, look at the benefits we would have missed out on.
That's a good point. Under a very traditional approach, you would say all IP is anti-competitive. Yeah, absolutely. But we obviously know that's not the case, right? Dae-Sik, did you want to speak to this?
Yeah. The question always in mind is that how competition authorities can work in a more balanced way with the Indonesian arguments in both ways. All right. Yes, it really works. And actually, yes, for the KFTC, as keep on broadening the scope of anti-competitive effect, yeah, including, you know, innovation harm, yeah. So, but conversely, it is very reluctant to admit efficiency gains relating to innovation. That is definitely, you know, the asymmetric approach. Yeah. Yeah. So my suggestion is that the recognition of innovation harm should be more concrete and, you know, robust. But if that is not enough to reach the final decision, and the competition authority should be more, you know, open to consider efficiency gains. So my suggestion is two kinds. One is that traditionally competition law analysis is confined to the same relevant market for efficiency gains, but we need to incorporate cross-market efficiency gains as well. And then second is that, you know, the not just incentive, innovation as incentive, they should consider capabilities as innovation. You know, in Google Android case, anti-fragmentation agreement should, I think it was needed to compete with the Apple ecosystem, you know. Yeah, the Google Android is, you know, the open system, so they requires such kind of anti-fragmentation strategy. And with that, they developed its own ecosystem. So ecosystem building, you know, strategy and platform strategy should be considered in efficiency gains as innovation, as capabilities. And so, hand in hand, they have to broaden, as they broaden the offensive way, and they should follow up broadening the defensive way. It should step by step. It should go in hand, go hand in hand.
Is there any? So I mean, take devil's advocate point of view as much as you can. What would be the justification for opening the door to sort of offensive innovation effects, innovation harms, but not opening the door to innovation benefits? Is there a defense of the asymmetry, or is that just crazy?
I'm not defending the asymmetry, but I never thought our conversation would go this way. But because allowing for future out of markets benefits is going to promote greenwashing.
Say more.
Don't you think so?
Well, say what you mean by greenwashing.
So you have these merger cases, and right now greenwashing is just accused of having another contemporary market where there will be a benefit. But if you think about the future, if we allow, you can argue, if you allow this merger, there will be so much benefit down 10 years from now from so much better technology that's sustainable energy or sustainable production systems that you should for the benefit, to get the benefit, long-term benefits from innovation, this merger, despite the static downsize down, should be allowed, which seems too much. Or maybe we should ask for very concrete proofs, right? It can be coming back to the proof of measuring what the benefits were, that you'd really need some proof in numbers that you would succeed by the probability of this technology being successful at what time scale, for instance, might be necessary in order to do this kind of argument.
I mean, I think, what you're saying, I think, is there's no stopping point. There's no obvious stopping point, and which is an inherent problem. I mean, on the other hand, if the stopping point you have adopted is zero, we don't move any way into taking account of future benefits. That's not necessarily any better. I mean, but I would like to know if it is better. Maybe there's a justification for saying, look, if it's a choice between we allow any plausible explanation that we're going to lead to future benefits, or we allow none of them. Why is allowing none of them actually, given two bad alternatives, why are we better off allowing none rather than allowing all of them? I don't think there's an answer for that, but I mean, you could say, well, allowing none is a lot cheaper to adjudicate, and so we're saving. It makes adjudication more efficient. I do, but no, I know, of course not. But I do, but there is an interesting point, and we can maybe talk a little bit more about sort of some doctrinal issues or some of the shift, the ability of our traditional antitrust approach to accommodate dynamic concerns. So you mentioned something that made me think of this. I don't know if you're familiar with the Chicken of Tomorrow case, right? It's the best case just because of its name, really. But I'll give just a very stylized version of it, and so this doesn't map perfectly onto the facts, but you should look it up because it's great. But here's what I take away from that case, without giving all the facts away, is maybe, at least when it comes to conduct, if collusion, if agreement between competitors is necessary, as it almost inevitably is for future sustainability, because you get there by reducing output, and that's something that requires coordination with everyone. Maybe we will entertain that argument. The argument we won't entertain is if you use that excuse to exclude other competitors who don't agree with your little cartel. And that was, in some ways, that was the issue in the case. There's in my stylized version of it, it maybe have been okay for chicken producers to agree we're only going to sell free-range chickens, but it was not okay to have an agreement with grocery stores that would say, you won't ever sell the non-free range chickens either. Right? Is that, I don't know, I mean, does that make sense? Like agreeing that if you went on your own to sell the free range chickens, you'd have a hard time competing because your chickens would cost more, everyone would undercut you, it would be tough. So if you can get most of your competitors to agree because it's better for the environment, we're gonna sell free range chickens, maybe that's okay. But what's not okay is to include in your agreement the grocery stores and have them agree that they will refuse to carry any chickens that are not free range. I mention this because, so there's an example of, it's not going to be perfect, it's not going to apply in every case, but it's a heuristic that might help us in differentiating in cases where it's all uncertain, but maybe we think the risk of harm from the conduct outweighs the potential benefits. Is that consistent? Is that sort of, so here's my question. Is that
Depends on the entry barriers after the agreement.
Okay, so that's
that's
another thing, right?
Which is one of the points you're going to lead on to, I'm sure. Look, sorry. The feasibility of a cartel depends on the ability of people to enter to take advantage of the extra rents that are being made by the cartel members. In the case of chicken producers, entry barriers would be quite low unless there are regulatory barriers. Well, that's the only possibility that there'll be regulatory barriers. So when a competition agency is considering this issue, we'll have to consider these possibilities and their feasibility as well. When we're talking, we're not just talking about technologies here. We're talking about, you started asking me a question right at the beginning, which I didn't get onto because I'm such a verbose person.
I'm going to cut you off.
No, but look, it's also the introduction of business models, cost structures, as well as technologies. And that was the point I was going to make right at the beginning. Niall Ferguson wrote a very good book on civilizations, which said, why was the West so far behind Asia up until about 1500? Then in the last 500 years, the West has gone ahead. His explanation really is all to do with entry and exit barriers. That is, the Ming and Qing dynasties in China essentially closed up, reduced innovation. Many of the innovations that were introduced by the West after 1500 were actually improvements on what had already been developed in China. The same with the Mongols, the same with the Ottomans. All of this really was led at the top by lack of institutional opportunities for technology change. And that's one thing which I think you've got to see this issue that we're talking about in a broader policy context. There's no point in having an optimal antitrust law if you don't have the opportunity for innovation to occur in the first place, because you're never going to have any innovation.
Can you make the case that's so valuable, that's so important, that despite the fact that we know there will be false negatives, that we would let through a lot of anti-competitive harm, that the benefits are so much greater than that, that it's absolutely worth it? I mean, essentially an argument that we should have, certainly we should have no antitrust enforcement, because we're going to get it wrong more often than we get it right, and we're going to get it wrong precisely on this long-term innovation dimension.
How do you work out whether we're doing it well or not? Yeah. Because it's very difficult empirically to assess whether a competition regime is doing a good job or not. You can point to the wins in court, but that's not a very good substitute for actual benefit from the antitrust regime. It's almost impossible to do that.
It's also not a measure of the cost either, because there'll be you'll see the enforcement actions, but you won't see all the positive conduct that's not undertaken.
That's the whole point about but-for test. It gets back to a point I made earlier. Most antitrust enforcement uses some form of forecasting about what the likely implications are in the absence of prohibiting the agreement versus prohibiting the agreement. And I mean, what sort of evidence do you require on that? Very, very little. It's largely in a common law system, the input of the two opposing parties. In the case of the civil law systems, which mostly apply in Asia, it's also the government intervention, the policies overriding the judges, predilections, etc., in the courts? I mean, there's no easy answer because we just don't know the future. But so I'm always for free go. Let it go, except in obvious cases where you know your benefits are going to be recognisable.
But aren't there margins on which we could improve things? For example, as we've said, one of the important elements, one of the necessary elements of dynamic competition is that it takes place in the future, that it's forward-looking and therefore speculative. Is that not a good argument for scaling back on ex ante enforcement? Say, for example, merger. Let's not enforce it. Let's allow all the mergers to happen because we know we can. If they lead to anti-competitive effects, we can enforce, ex post. We will actually have some evidence. We'll see what transpired between the merger and the point at which we think the result is anti-competitive, and so at least we essentially. For some of the evidence, we move it from speculation about the future to actual evidence that happened in the past. Does the concept of dynamic competition suggest we should rethink some of our classic doctrines precisely because they happen, before the effects happen? Does anyone want to support that? And if any enforcers want to say, yes, I completely agree with that, that would be great. But I also would love to hear if you think that's a terrible idea.
Especially in the merger case, sometimes competition authority face some difficulty because in some case, the negative price effect is obvious.
Yeah.
But the merging party proposed they could achieve innovation benefits in the long run.
Right, which won't be obvious.
So from the agency views, we will need to ask them to provide evidentiary, to substantiate their argument about innovation benefits. Otherwise, the obvious non-price price effect could push us to do some to design some remedies. So, but sometimes we need to consider. We are happy to consider the innovation benefits and in the long run, but without a very evidentiary basis, we could not accept that. Yeah, so this is.
But there won't be evidence. I mean, we have in the U.S. we have, I think, literally one case, the T-Mobile Sprint. Is that right? T-Mobile Sprint? Is that who it was? Merger? T-Mobile Sprint merger. Maybe the only single example in all of U.S. merger history where a judge excused a merger because of the prospect of future innovation or investment gains outweighing the present price increase. In concept, at least since the 97 merger guidelines, that's supposed to be part of the analysis. But it seems unlikely that it's really an effective part of the analysis if it has literally never happened except for once. And by the way, when the judge did decide the case on those terms, people cried bloody murder. I mean, some economists who will remain nameless think that it's the worst decision to ever happen precisely because the judge actually said, well, look, there are these efficiencies or potential efficiencies, and I think it's likely enough to happen, but it's always speculative, that will account for them. And I guess what I'm saying is, I mean, it's great to hear that, and I just, as a practical matter, I think what you said is exactly right, that, without some really strong substantiation, the current observable or, better predicted price effects are going to predominate. And sometimes, and maybe even a lot of times, that has to be wrong, but it's just a function of the kinds of evidence that are available.
Gets back to your point about the Chicago economists looking, the non-Chicago economists looking for.
I said a drunk,
exactly
but
get back to that point. Look, I think from a practical matter, given that we're not going to see the abolition of IP or antitrust anytime time in the foreseeable future, and I might be wrong in 100 years when I'm looking up to see what's going on here. But the best an antitrust agency can do, I think, is to incorporate people with the IP experience from IP agencies or even seconded from industry. That is the only way you're going to get a good estimate of likely future development.
I'm going to open the floor to questions if somebody wants to walk around with microphones. And while that's happening, I'm going to ask Reiko, just to build on that point. The JFTC did a study recently, right? But you, yeah, right, exactly. But I like it because you involved business scholars in the, I mean, sort of normally it would just be a bunch of economists who would look at everything statically or something. It wouldn't be a David Tees, right? But it sounds like you thought it was important to hear their perspective. It's not quite the same as what you're saying, but it's a step in the right direction. What was the result of that?
Thank you for the question. Sure, yeah. So JFTC did a study started in early 2023, and it was published last year in June, and the report is available in English also. And it was a report of a study group that included economists, legal scholars, business people, but also business school academics, where they tried to look at what was really included in innovation from including the business point of view. And they identified the effect of corporate conduct on innovation incentive as impact mechanisms. So they came up with a list of impact mechanisms that would matter to innovation incentive. And of course, that included the usual probability spillover and spillover. But it included things like capability and capacity, cannibalization effect, which is in economics would be replacement effect, but also escape competition effect, trying to get out of competition by being innovative. So those were things that have economic foundations, I think, but they're business concepts and should be taken into account when you looked at antitrust. So first thing they did with the impact mechanisms that I just listed is try to apply them to merger review. So for instance, for horizontal review mergers, the impact mechanisms would, for instance, have a positive effect on a probability, probably decrease in spillover effect, increase in synergies. In case of vertical mergers, hold up resolution would be something that was another impact mechanism that would have positive effect in case of a vertical merger. So that was part one of the report. In part two of the report, they tried more generally what these impact mechanisms related to the application of the AMA, and they came up with 3 points. One was that the market definition focusing on R&D competition was very important, and there should be realization that there were these markets in the future that was not quite, that didn't exist now, that should be taken into account when applying for an AMA, applying the competition law. The second point was we should think about the long-term perspective, i.e. the static and the long-term trade-off, and that it in fact should go both ways. But for the long-term effect, it goes to the third point that they made, that there should be some kind of proof that there were these long-term effects or long-term harms if you were trying to argue in that direction. And it was up to the firms, the corporation enterprises, to provide some kind of quantitative assessment of long-term effects. For instance, what was the likely effect of result of the R&D or probability of success, magnitude of the results, and when they were making these claims that they should try to provide as much as possible some kind of a proof of the claims that they were making.
What would that look like? An experiment, a theory? I mean,
I don't know, maybe to try to look at similar technologies in the past and try to assess the probability of success. Or something like to try to, well, so I know economists that do R&D and innovation economics, and they have some historical evidence about kind of investment or investment strategy and what the outcomes are going to look like. Of course, we don't know innovation.
Especially if what's happening is a business model innovation, maybe an investment model innovation that hasn't ever been tried before.
Yeah.
Were there any questions? Because I'm sure we can keep talking.
Hi, my name is Matthew. I'm a partner from Southside. Thank you for your wonderful sharing. So my question is, because there are a lot of companies who maybe start a company or a small company, they are developing new technology. So during the innovation, the development stage of their technologies, which means their technology has not been proven to be successful. However, if they enter into some kind of joint development agreement with their potential customers, however, under the agreement, the potential customer prohibit the technology company from offering this or licensing the same technology to the customers' competitors around the world, which means if the technology is successful, only the customer can use the technology, but not its competitors. So, and also the customer may enter into similar agreement with several startup companies who are using different technology to develop the same product. So my question is, apparently this is a vertical restraint agreement. So from the agency's perspective, how to evaluate the harm to the competition? Because the technology has not been successful. So we don't know whether the technology was successful or not.
It's a great hypothetical that sort of puts into sharp focus the indeterminacy of this. Does anyone have any thoughts about it? Other than who knows? I mean, it's a toss-up. But it does get to the question. So given that it's a toss-up, if you had to err on one side or the other, which side would you err on?
Let me comment, right? So I think that the hypo you discussed is not really vertical restraint. It's called exclusive license. Exclusive license is clearly permitted under all applicable laws.
Well, except it also, in his hypothetical, entailed an agreement not to license to others, right? So
right,
it's an exclusive license.
Let me qualify, right? So if this technology, this supplier or this R&D firms is the only one in the world that has this technology, and you enter into an exclusive license agreement, then this may merit some analysis. But it's hardly, you don't have that kind of cases. Like normally you got multiple firms, and especially you mentioned that this is not proven yet. So when something is not proven yet, usually you get multiple different solutions. So actually it's interbrand competition.
No, and in fact, actually, the hypothetical is pretty close to Illumina Grail, except in Illumina Grail, Illumina said, we absolutely will not do an exclusive license. We promise we'll license it to anyone who comes. And what was the outcome in that case? Not allowed to merge. I mean, right, so I mean, you're right, but also there's a strong incentive to find anti-competitive fault with those kinds of agreements, and even with ones that are far less problematic. some of us would say that we lost, a lot of people will die from cancer because that merger was not allowed to happen. How do we measure that? All right, well, I think that we're being told that we have to go eat lunch. I want to thank the panel. This was a great discussion. And Todd is the Michael J. Marks Professor of Law at the University of Chicago Law School. Many of you may know Chicago as the historic center of law and economics, and I'd argue that these days Todd is doing most of the heavy lifting to keep that reputation alive. Todd and I overlapped for 2 years in law school, and it was obvious even then that he was on a different level. Before law school, he was an engineer building dams. After, he was an appellate lawyer and a consultant at McKinsey. His scholarship is just as broad. He writes on everything from corporate governance to American Indian law. And he also puts theory into practice. He teaches an entrepreneurship course that's actually launched new companies. I would say there are very few, if any, other law professors who can say they've had that kind of practical influence. And I have to mention, in a point of personal pride for me, that he's also the winner of the so-called Manny Madness tournament, a competition that was named for my father to determine the best law and economics professor teaching today. And so when I say he's one of the most insightful scholars of our generation, it's not just an opinion, it's a verified market result. His contribution, yeah. And I believe he won $50,000 for that too, so he's buying, yeah. His contributions, especially to corporate law, securities regulation, and law and economics are foundational. He's one of the rare thinkers who doesn't just participate in a conversation, but fundamentally shapes it. If you want to understand the economic plumbing of the modern firm, you read Todd Henderson. If that weren't enough, by the way, he also moonlights as a successful novelist. I'll leave it to you to decide whether his thrillers are more suspenseful than his articles on corporate governance. It's a close call. I highly recommend both. Now, you may look at Todd's resume and say, this isn't an antitrust scholar. What the hell is he doing here? I do have to note that he did briefly work in the DOJ antitrust division. But other than that, you'd be right. But it's also precisely why I'm so excited to hear his talk. Too often, I think we in the competition world get lost in the weeds of market definitions and doctrinal tests. We risk forgetting that antitrust isn't an end in itself, but a tool, one of many, for promoting a dynamic, innovative, and prosperous society. And to apply that tool correctly, I think we have to first understand the institutional landscape in which we're doing it. We need to understand how firms work, how capital is allocated, how innovation and entrepreneurship happen in the first place. Todd's work provides exactly that kind of essential knowledge. It's the intellectual foundation on which sound antitrust policy must be built. So please join me in giving a warm welcome to my friend, Todd Henderson.
That was completely over the top. So even if half of that is true, yeah, definitely. So thank you to Emily and to Jeff and Lazar and Andy and Kevin and the staff here at the hotel for putting on a great event and for having me. I really appreciate being here. As Jeff said, I don't really teach or write about antitrust. My most impactful accomplishment as a lawyer involved antitrust. My biggest mistake as a lawyer involved antitrust, and I was responsible in part for sending somebody to jail for violating the antitrust rules. But this is not something I've thought about for a long time. When Jeff invited me, I thought about antitrust in a kind of historical context and as it relates to corporate law, and that's what I want to talk about. So bear with me. I hope some of this is interesting. So there's a well-known story about the history of antitrust law that there was sort of a perfect storm of ideas and people in the 1970s that revolutionized the field, and now we're being dragged back to the dark ages. There's a lot to this story, but it's only part of a broader change that happened across numerous fields at the same time and in the exact same ways. That perfect storm could be told in fields from corporate law to criminal law. This can't be a coincidence. Something deep and fundamental was happening, but what? What were the conditions that enabled that change to happen? And perhaps most importantly, is this process of change different than in other fields, other human endeavors? So here are my short answers. As to the first question, there are two main drivers of change: rebellion and milieu, or environment. The world changes when these two things coincide, and this is very rare. Rebellion arises from people trying to differentiate themselves from the status quo. Being unsatisfied with the way things are and a desire to be recognized drives innovation in everything from art to law to chip design. The more established and sacred things are, the greater the returns to rebellion. Most of us are sheep, happy to eat the grass in our particular pasture. But the rebels are out there, and they're constantly looking for the new thing. But many new, potentially world-changing ideas never see the light of day because they come when conditions are not right. Thinkers are constantly planting seeds, but the soil conditions must be suitable or nothing new will grow. And of course, the two factors of change are interrelated. Farmers plant more seeds in fertile than barren ground. What makes ground fertile for new ideas, legal or otherwise, is a deep and vital question, and I don't know the answer. But at its core, it must be something like human satisfaction with the way things are. As to the second question of whether law is different, my answer is a tentative yes. Innovation in other areas of life is boundless. The architecture, music, art of our era is vastly different than those 50 or 100 or 1,000 years ago. In the future, I expect similar change. Modern law, by contrast, I predict, is stuck in an endless struggle between two very simple paradigms: expand the pie, divide the pie, efficiency or fairness. I think we're just stuck in an endless cycle. A quick history of antitrust and how it moved in parallel with these other fields will hopefully illustrate my points, such as they are. Antitrust law in the United States rose as a response to economic and technological change. New technologies like railroads, the Bessemer steel mill, refrigeration, and steamships generated enormous wealth by increasing human flourishing. Law, being famously slow to change, failed to keep up. The business entities and laws of the Gilded Age around 1900 would have been recognizable to the Romans. They were simple partnerships of a few men. The entire economy of the United States was run by a handful of people. Consider Andrew Carnegie. In 1889, on the eve of the passage of the Sherman Act, Carnegie Steel controlled 50% of steel production in the United States. It was a partnership entirely owned by 4 people. The same story, except for the names and a few other changes, was true in oil, chemicals, retail, railroads, shipping, everything. The average American was way better off as a result of these, but remained just a wage earner. Americans didn't own stock. They didn't participate in the capital part of capitalism. 60 years later, in 1950, 4% of Americans owned stock. Today, the number is 65%. In 1890, it was effectively 0. I just saw a news story to tell you about what it's like today. NVIDIA, which has a market cap of more than $4.3 trillion, 80% of their employees are millionaires. The average, 25 million US dollars. Americans are participating in the capital part of capitalism. But in the 1880s, this model of 4 men owning half the steel production did not work for the country. Louis Brandeis comes along and and bemoans the curse of bigness. And President Theodore Roosevelt says, we got to do something about all these so-called robber barons. The Sherman Act was the law's answer. It wasn't intended just to protect consumers from high prices, but to end the corporate domination of society. There was an alternative. Taxes could have worked to discourage some of the wealth from the robber barons, but it was unconstitutional, said the Supreme Court. It took a constitutional amendment, our 16th in 1913, to change that, but it wasn't available to Roosevelt in 1890. There were price-fixing schemes, and those the law targeted, but with respect to getting at bigness, the law was a dud. It broke up Standard Oil, but not Carnegie Steel. Carnegie pursued dominance through vertical integration, owning iron mines, coke fields, railroads, and mills, but this didn't violate the Sherman Act, said the law at the time. In fact, Carnegie spoke out against monopolies, talking about the efficiency and lower prices, and contrasted himself with Standard Oil, which he said was just a price-fixing cartel. What brought change and what got rid of the robber barons wasn't law. It was innovation in capital markets. In 1901, Carnegie sold his steel company to J.P. Morgan, who then turned around it and sold it to the public, putting $1 billion in the pockets of those four men from Pittsburgh. The shares in what became U.S. Steel were now sold widely in the public, allowing the public to participate in capitalism. This was the first IPO of the modern style. In the following decades, AT&T in 1901, General Motors, and IBM in 1916 participated in this. The need for a government stick to bludgeon big companies to make way for smaller ones was reduced. Although much of the motivation for the Sherman Act was addressed well enough and it could have been narrative focused only on schemes to raise prices, the law lived on. With broad powers in the hands of regulators needed to catch conduct that would be hard to define ex ante, the law became a tool for forces not interested in public welfare but for their own gain. Courts and government bureaucrats went along. Into the mid-20th century, they often condemned mergers or business practices simply for tending to concentrate power or harm small competitors. In 1945, Judge Learned Hand in the Alcoa case said, "Great industrial consolidations are inherently undesirable regardless of economic results." Efficiency was not part of the equation. Courts went so far as to say higher prices for consumers was an acceptable price to pay for having smaller firms. This should sound familiar to those of you paying attention to antitrust in the United States. The problem, however, is these broad laws, written as necessary to catch people who could evade narrow written ones, allowed lots of people to come up with their own self-serving reasons to deploy the antitrust rules. These many things that you could do and accomplish in antitrust were often at odds with each other. Politicians could target certain firms or industries for ideological reasons. Competitors can try to use formal doctrinal rules or other argument to protect themselves from having to compete against a more efficient competitor. Corporate fat cats might spin up bogus antitrust concerns to protect themselves from a hostile takeover designed to end their reign and improve corporate efficiency. And workers might try to get from antitrust rules what they couldn't get from labor laws. But the story of antitrust history goes on, and thankfully bends towards rationality. In the early 1960s, after co-teaching in antitrust together, two Chicago scholars, Aaron Director and Ed Levy, began attacking these populist antitrust doctrines. In the 1960s, in a series of debates in Fortune magazine, Bob Bork and Ward Bowman started to make the case for economics and antitrust. Then in 1968, Oliver Williamson published Economies as Antitrust Defense, the welfare trade-offs, making the case for efficiencies in mergers. Williamson told us, compare the triangle to the rectangle, and antitrust was never the same again. Bob Bork put this into a book in 1978. Efficiency would replace what masqueraded as fairness. The so-called perfect storm needed one more thing, so the story goes that's Ronald Reagan. Although the economic groundwork was laid, and the Supreme Court eventually adopted the consumer welfare test in the late 1970s, it was Reagan judges like Richard Posner, Frank Easterbrook, and Doug Ginsburg who took economic theory and baked it into law. Without them, the antitrust revolution would never have happened. But notwithstanding this, the specter of big is bad still stalked the earth. An anecdote. In the mid-1990s, I worked at a big New York law firm. Our client was the second biggest of four players in a market. We had an emergency call one night because the biggest company in the market announced a deal to buy the fourth biggest. Panicked, the CEO wanted advice on how to kill the deal. Selfishly, the company didn't want the efficiencies that would arise from that combination. After about an hour of brainstorming about HHIs and economic analyses and DOJ personnel, I spoke up. I was just a summer associate. They usually don't speak up on conference calls with CEOs. But the answer seemed so obvious, I couldn't keep it in anymore. Buy the third biggest, I said. After just a few weeks in the field, I knew the doctrine was fuzzy enough and political enough that while the government might be willing to go from 4 competitors to 3, it would never let the industry go from 4 to 2. A few weeks later, the client announced a merger it had no intention of completing. The DOJ raised an eyebrow, and both deals were called off. But for the most part, by the 1990s, the economics paradigm held sway. Low prices and efficiency were king. To borrow from Francis Fukuyama, it was the end of antitrust history. Then in 2017, the Yale Law Journal published the most famous student note in the history of all American law, Lina Khan's Amazon's antitrust paradox. She pointed out that since internet platforms mostly give away stuff for free or charge famously low prices, they're untouchable by the consumer welfare standard, and they're doing all kinds of bad stuff. The note went viral in both academic and policy circles, especially on the political left, and what we call hipster antitrust was born. Everything old is new again. Khan was writing against the moment, but also for the moment. Her innovation, such as it was, landed on fertile ground. The world was changing, just as it had after the Civil War and the economic boom that followed. The technologies of the era were the internet and smartphones and real-time manufacturing and auction markets for online ads. Change brought prosperity, but also upset the status quo, and the status quo always fights back. There were also crises like the financial meltdown caused by a combination of bad government policy and risky bets on credit derivatives that were not well understood. The Occupy Wall Street movement in 2011 reflected a populist anger at a growing wealth inequality and the so-called 1%. That idea, the 1%, took hold and would become a history-changing one. As my kids like to say, there was a vibe shift. Something had to be done. The constitutional impediment to raising taxes were gone, but raising taxes is unpopular. The path of least resistance was again antitrust. It was ill-suited to the moment, as it was in 1890, but something had to be done, and this was something. And the Americans have always had a kind of love-hate relationship with bigness. There is a little bit of Thomas Jefferson's idealized yeoman farmer baked heavily into the American DNA. The move found support on the other side of the political spectrum, as ideas must to have any impact. Big tech companies staffed with young progressives engaged in widespread suppression of speech they didn't like. Right-wing politicians wanted to go after big tech for this reason, and again, the path of least resistance is antitrust. President Biden issued an executive order on promoting competition, which explicitly linked competition policy to broader goals: raising wages, benefiting small businesses, reducing income inequality, the health of children and families, the environment, throwing everything in but the kitchen sink. Biden also appointed these people, Lina Khan to head the FTC, Tim Wu as a White House advisor, and so on. Antitrust history is not over. Well, it's too early to declare a full doctrinal revolution in antitrust. The issue is ripe for the first time in decades. It's easy to dismiss this attempt to forget about economics and antitrust, but let me try to steelman this approach for a second. If you believe the legislative process is broken, then why not try to achieve popular programs through flexible legal standards? The law is supposed to be an instrument to reflect what people want. To be sure, it would be better to do labor law or campaign finance law or small business law separately so as not to mess up the efficiency of antitrust, but maybe the perfect shouldn't be the enemy of the good, or so the story goes. Of course, the problem is antitrust is not a good tool to achieve these goals. If there's too much money in politics, breaking up Google or Amazon into smaller pieces isn't going to fix that. There are better laws to address wealth inequality or promote innovation. Pretending antitrust can do these things will only give false hope and undermine people's faith in government. Or maybe, if I'm being optimistic, a few antitrust cases that make things worse are a small price to pay for letting off a lot of political steam that might otherwise do more damage to the economy. Markets are resilient. Killing Standard Oil might have saved capitalism, and it was reassembled. Same for AT&T, the original version, and Microsoft. These casualties of antitrust may have been sacrificial lambs that serve the greater good, politically speaking, but I don't know, this whole thing makes my head hurt. In general, I'm not even sure I understand the idea of a monopolist as tenable outside of a very limited set of natural monopoly cases. With the deepest capital markets and richest entrepreneurial ecosystem in the world, the idea that corporate power in America needs to be checked with antitrust seems quaint. Have you heard of AOL or Yahoo or MySpace or BlackBerry or Nokia or countless other companies that had monopoly-like power? Yeah, I've forgotten about them too. Consider the Google case, now pending. It was found to have monopoly power in search with its involvement with Apple. This is absurd. Insofar as Google had a dominant position in search, it was because it built a better mousetrap. When forced by European regulators to choose a default, everybody picked Google. But that's about the past, and antitrust should be about the future. But it isn't. I haven't used Google search once since I first signed up for ChatGPT 4.0. My guess is that it's DEFCON 1 at Google, especially since Apple didn't opt for its AI to be its default. That alone should tell us about its alleged power. But I don't want to take a strong view on hipster antitrust. I'm inclined to be against it, as I see the world through the lens of expanding the pie rather than dividing it. I worry about regulatory mistakes and regulatory capture. I'm afraid of people who think they know just how the world should be ordered. Tim Wu scares me to death. But I can see that others prefer to keep the pie the same size or even shrink it so they can divide it differently. These people are ascendant in our politics, and law is just an instrument of their preferences. The likely mayor of the largest city in America is an avowed socialist. And according to a recent poll, I got to breathe deep for this one, nearly 1 in 3 people under 25 in America have a favorable impression of communism. And maybe at one level they should get what they want from law. At another level, maybe giving them a little bit and pushing back so it's not too much in antitrust is a decent second best. I don't have answers to these questions, but it's a question worth asking. To understand the history of antitrust, though, I want to put it in a broader context. Economics came to every aspect of law around the same time it came to antitrust. And the rebound is happening in these places too. In the period before the 1970s, when antitrust was a vague tool in which countless aims could be pursued, the rest of law was of a piece. Tort law was about doing justice or achieving fairness. Criminal law was about retributive justice or rehabilitation or social justice or some combination of these things. Contract law was about helping the economically downtrodden. Corporate law admitted what was the reality of the age. Managers ran businesses as they liked, focused on some combination of the welfare of workers, communities, and of course themselves. Academics came for this entire set of affairs at the same time as they did for old-timey antitrust. In 1968, the same year Oliver Williamson published his seminal piece on merger, another Nobel Prize winner, Gary Becker, wrote Crime and Punishment, an Economic Approach. Becker told us what we should be maximizing in criminal law is deterrence, which is the product of the probability of detection and the amount of punishment. Everything else is a sideshow, and if included in the calculation, it's just going to mess things up. The key insight was that focusing on one thing, a single thing to maximize, made policy better. 2 years later, in 1970, Guido Calabresi published The Cost of Accidents, which brought economics to tort law. Calabresi told us, minimize the cost of accidents, net the cost of precautions. Keeping torts focused on incentives and optimal precautions grows the pie. Other laws should divide it. So the law and economics story goes. Richard Posner followed Calabresi's lead and extended this single maximand policy to every other area of law in his 1973 book, An Economic Analysis of Law. It's one of the most important and influential texts in the history of mankind. In the corporate world, what I know best, Milton Friedman usually gets credit for his piece in the New York Times, again in 1970. The headline tells the story. The social responsibility of business is to increase profits. In 1970, Friedman was writing against the tide. This is, of course, why we remember him. Corporate managers of the 1950s and 60s focused on providing stable careers and rising wages for employees rather than maximizing profits. Corporate executives thought of themselves as stewards. Corporate law let them focus on workers and communities and stakeholders, at least ostensibly. They were mostly thinking about themselves. It's the same story in antitrust, except instead of the government balancing all these things, it was CEOs. Milton Friedman took on this point directly in his piece in the New York Times, pointing out CEOs aren't elected by the people, and they're ill-equipped to make these kinds of trade-offs. They don't teach this stuff in business school. I teach at a business school. We don't teach this stuff. CEOs should focus on making the pie bigger and let the people acting through the representatives divide it up. Giving CEOs 3 or 4 or 10 things to maximize will end up simply reducing their accountability. They'll build empires, excessive perks, and be lazy with other people's money. We will all be poorer. Within a few years, academic work put a veneer on this. 1976, Jensen and Meckling published their seminal paper on agency costs. Soon law professors like Frank Easterbrook and the guy who taught me corporate law, Dan Fischel, applied this economic reasoning to legal doctrine, contending that corporate law should force companies to do this. By the early 1980s, when antitrust started to move towards consumer welfare and corporate law, shareholder wealth maximization became the norm in corporate boardrooms. The revolution in corporate law worked hand in hand with the revolution in antitrust that was happening at the same time. Jeff's dad, Henry, one of my intellectual heroes, predicted this. In a famous 1965 article, he described corporate takeovers, what he called as the market for corporate control, as essential to human flourishing. In a world of agency costs, takeovers discipline lazy or corrupt or bad managers, ensuring companies are efficient as possible. Many pitched this as an antitrust idea of sorts, that the gains from managerial improvement should be an efficiency that counts in antitrust considerations. His profound insights were ignored for decades in ways they still are. Antitrust tends to only credit marginal cost reductions within the market alleged to be harmed by the merger. Throughout the 1980s, antitrust law stepped back, and the market again provided the discipline on corporate excesses that antitrust had promised but failed to achieve. A vibrant market for corporate control emerged. If a company's stock price lagged, suggesting management was not fully exploiting profit opportunities, raiders would swoop in with hostile bills to oust incompetent and complacent managers. Innovations in finance helped. The availability of high-yield bonds created by Michael Milken made it easier to finance these takeovers. The law nodded in the direction of shareholder value, but the market led the way. Two prominent legal scholars, Hansman and Krachman, famously declared in the early 2000s the end of history for corporate law. But as in antitrust, the worm turned. History was not over for corporate law or for the common law areas like torts or contracts either. It started in the late 1990s as a broadside against neoclassical economics in law generally. It was a leftist attack on what was viewed as a right-wing move in law. The left-wing frustration with the single maximand revolution in law was that it offered a promise that was not fulfilled. The promise was that law would allow a focus on expanding the pie, conditional on politics dividing the pie on fair terms. While admitting law and economics had delivered on the first promise, these critics thought politics had failed to follow through enough on the redistribution part. As a result, these critics tried to destroy law and economics from within. They realized they couldn't get rid of economics. It was too powerful. It would be like trying to uninvent the computer. So they tried to undermine it as a technology. In 1998, Christina Joles, Cass Sunstein, and Richard Thaler, a future Nobel Prize winner, published a behavioral approach to law and economics in the Stanford Law Review. Building off work in psychology from prior decades, their attack was simple. The premise of law and economics that individuals are rational maximizers is erroneous. Pointing out that humans are, well, human, they declared victory. They were attacking a straw man. Law and economics never asserted that individuals were rational maximizers. Instead, it assumed that people were rational maximizers as a means of evaluating social policy. This assumption at the level of society yields testable predictions, and these predictions tend to largely be confirmed, even if individuals don't understand what they're doing, and even if it's not true in specific cases. Let me give you an example to illustrate the point. Jeff said I used to build dams. In this life, I designed an enormous dam near Los Angeles. If it fails, millions of people will be inundated. In designing that dam, I used Newtonian mechanics, such as his force equilibrium equations. Los Angelinos can sleep soundly, even though at the level of the individual atom, Newtonian mechanics is flatly wrong. I don't understand quantum mechanics, but it doesn't matter. As a matter of predicting real-world behavior at the level of a 500-foot dam, some crude assumptions are good enough. There are other problems with the behavioral counter-revolution in law and economics. Many of the experiments that undergird their conclusions are suspect and have not been replicated. It also suffers from the same problem as hipster antitrust. By trying to squeeze every kind of objection into, or policy into their framework, the theory is at war with itself and is whatever the person yielding it in power wants to be. The theory allows no predictions to be made at the policy level, but it provides plenty of ammo to criticize the status quo, which is the point. The tools of the revolution were forged. 30 years after the antitrust revolution of 1968, and in other areas as well, the revolution of 1998 happened. 5 minutes? 15 minutes, got it. But just as it took a few decades for the ground to be fertile enough for the seeds planted by Williamson and Bork and others to grow, so did these ideas have to wait their time. The bursting of the dot-com bubble, the great financial crisis, the returns to superstars in our economy like Jensen Huang from globalization and information technology were the fertilizer. There's been a growing uproar that a single-minded focus on efficiency or shareholder value, while beneficial in some respects, also fostered serious problems, maybe eroding democracy itself. These realizations have catalyzed moments to broaden the objective of both fields again. In my lingo, to move from expanding the pie to dividing it, or from efficiency to fairness. In corporate law, there was a very famous 2019 release by 181 CEOs, including JP Morgan and Apple and Walmart, who signed a statement renouncing pure shareholder wealth maximization as the goal of corporate America, and promising to lead their companies for the benefit of all stakeholders. Skeptics, me included, noted that talk is cheap and whether corporations truly change behavior remains to be seen, but the rhetorical shift itself indicated how far the conversation had moved. In legal doctrine, the law has not been revolutionized yet. Delaware hasn't renounced shareholder wealth maximization, and because corporate law in America is state law, it wouldn't matter so much if it did. But we see social pressure to widen the aperture to again incorporate plural values. But again, my point in this talk is not to take sides in this debate, but to point out the similar historical arc in these unrelated fields and ask what explained this. There's a couple of possibilities, and I'll just mention a couple. At one level, the level I operate at, we can tell a story of academic incentives and innovation. In the face of decades of confused doctrine and antitrust that admitted all sorts of potential policies and outcomes, the returns to offering a better way of doing things was enormous. Enter Aaron Director and Robert Bork and Oliver Williamson. They became famous. They got cited and feted and invited to things. People talked about them, just like Becker and Posner and Calabrese and Friedman. All of these people started new fields and became people that we talk about and will talk about long after they're gone. And for decades, being into law and economics was to be modern and to be part of the scene. Think of Claude Monet. The reason we all talk about him is because he was an innovator. In 1874, his first painting, Impression Sunrise, was shown at the Anonymous Society of Painters, Sculptors, and Engravers. He launched an art revolution, and for a long time, to be an impressionist was to be part of the scene until it wasn't. And then people were into Fauvism, think Henri Matisse, or Cubism, think Pablo Picasso. We could tell the same story in music, from Bach to Bing Crosby to Billy Joel to Busta Rhymes. In his book on modern art, Tom Wolfe said, "To be against what is modern is to be written out of the scene, and to be written out of the scene is to be nowhere." It's a big risk to go against what is modern. Most of us are too afraid. Those who make the new things are etched in history, and the rest of us go along until there's a new modernity. The longer things go on and the more out of whack they are with people's satisfaction, the greater the return to innovation. But is law like art and music, always changing, or is it stuck in the choice between arguing for efficiency and fairness? Duality like this is ubiquitous in law, always changing. Think of the choice between carrots and sticks, or negligence and strict liability, or most famously, rules and standards. One of my predecessors at the law school, Wally Blum, said you could never get a rule that is more than 90% accurate. For academics worried about optimal rules, that can be good enough. But for the public, with their heartstrings played by media and politicians, the 10% can matter a lot more. In antitrust, this insight was Frank Easterbrook's. You have to think not only about applying a given rule, but about the potential errors that can be made in trying to make it perfect. Blocking deals that should have gone through is likely much more damaging than not blocking deals that should have been blocked. Markets and innovation can address the latter cases, but the efficiency gains from the former may be impossible to replicate. 90% in the face of such asymmetric costs can be more than good enough. In criminal law, it's said it's better to let 10 guilty men go free than punish one innocent man. Whether the math checks out for crime or not, I don't know. But in antitrust, Easterbrook's view was the same. Better to let 10 bad mergers go through than to prevent one good one. To see this, consider the recent work of an economist named Henrik Bessembinder. He tracked all stock market value creation since 1930. That's about 29,000 companies in the United States. He found that 86 of these companies, out of more than 29,000, since 1929, have accounted for $16 trillion in wealth creation, half the total. 86 companies. If one of the mergers that created these firms was mistakenly prevented, the harm would be enormous. My guess is that in law, we're stuck in a duality of fairness and efficiency. My prediction is there'll be no rap music in law, just an oscillation between fairness and efficiency dressed up in new clothes, between those focused on expanding the pie and those with dividing it. Which takes us to politics. It is the milieu or environment in which rebellion either finds or doesn't find purchase. At a high level, the sentiment and preferences of the people is what moves law and public policy, but what moves the preferences of the people? During the economic stability of the 1950s and 60s, people were just happy to go along. This gave way to stagflation and economic malaise in the 1970s, which eroded faith in government and the government oversight of markets, creating receptivity to ideas that promised leaner, market-driven outcomes. Even if this meant stepping away from other policy goals, people wanted more pie and were worried less about splitting it up. Financialization and globalization also played a role. By the 80s and 90s, capital could move more freely, and investors were demanding higher returns. This put pressure on corporations worldwide to prioritize efficiency and shareholder value to attract investment. In antitrust, globalization meant US companies needed to merge and grow to compete with European giants or Japanese firms, and enforcers were persuaded somewhat by these competitiveness concerns. Crucially, corporate law and antitrust interact and can either complement or substitute for one another in controlling corporate power. Consider the late 1960s and 70s. Companies were not checked by activist investors, and shareholder wealth maximization was not the norm. The conglomerate craze of the 1970s resulted. But US antitrust was more aggressive in blocking mergers, which in a sense kept corporate sizes in check externally. While undoubtedly some efficient mergers were prevented, aggressive antitrust, even if wrong, might have been valuable given the other forces at play. In the opposite way, when antitrust relaxed in the 1980s and allowed a merger wave, corporate raiders simultaneously rose to enforce the efficiency through hostile takeovers. It's almost as if when antitrust stepped back, corporate governance stepped up. Private equity and raiders doing a form of private antitrust, breaking up conglomerates and disciplining management. This is a different way of looking at the kind of new neo-Brandeisian response to the current moment. In a world of shareholder wealth maximization, and a legislature that's non-responsive to what they view as people's actual preferences, antitrust can, through breakups or stopping mega mergers, smooth off the worst abuses of corporate power in the context of labor or politics, or so the story goes. Both approaches can thus be seen as different solutions to the same fundamental problem: how to align large corporations with the public interest. 5 minutes, okay. I'll talk fast, faster than I've been talking. Social and cultural forces are also relevant. In the late 1970s and 80s, we celebrated greed as good culture. The director, Oliver Stone, intended his villain, Gordon Gekko, in the film Wall Street to be a parody, but he turned into an icon. The ethos valorized corporate titans and free market capitalism, lionizing shareholder wealth maximizing CEOs and the aggressive merger dealmaker. In turn, the early 2020s cultural mood is more skeptical of big business. Elon Musk and Jeff Bezos, two men have probably done more good for the world than any others, are pilloried. 20-somethings today celebrate the assassination of a health insurance CEO. Big is bad again. Deep cultural changes drive politics, and politics is what puts law into action. We do not have good theories of cultural change. When I was a kid, the enemies in every movie was the government. Raiders of the Lost Ark, Star Wars, E.T., War Games, I could go on and on. Ronald Reagan's line about the scariest words in the English language being "I'm from the government and I'm here to help" were an articulation of the moment. Is it any wonder I think like I do? That particular moment was fertile ground for economics and the single maximand. At any other moment, these ideas, as powerful as they were, would have been inert. Today, the bad guys in movies aren't the government anymore. In The Constant Gardener, Syriana, Wall-E, The Social Network, The Big Short, Ex Machina, to name just a few, corporate greed, tech hubris, neoliberal dystopias dominate, with tech CEOs being the villain. Timing is everything. Let me close with an example to illustrate the point. Milton Friedman did not popularize the idea of shareholder wealth maximization. Henry Manny wasn't the first to come up with the idea that the control of a corporation was a valuable asset. And Carl Icahn and T. Boone Pickens weren't the first ones to make the case for hostile corporate takeovers. A man named Lewis Wolfson was. Never heard of him? Well, that's the point. In 1949, Wolfson, a college dropout and former junkyard operator from Jacksonville, Florida, got a telephone call from a friend in Washington. The friend heard a rumor about a company that ran DC's trolley car system. There were millions of dollars to be made. The stock was trading at $18 a share. The company had more than $18 per share in cash in the bank. It was a sure thing. According to the friend, the board of directors, lazy or stupid or unwilling to upset the citizens of the district, were spending other people's money on the operation that was going to be obsolete in a few years. Cars were coming. The Board of Capital Transit was typical of corporate boards everywhere at the time. They were content with the status quo. It was a David and Goliath story. It just needed a David. The junk man from Jacksonville picked up a stone and hurled it at the way things were done. Once in charge, he did something radical. He ran the company for the benefit of shareholders. Wolfson knew trolleys were going away, so he distributed all the company's excess profits in the form of special dividends rather than buy new trolleys with it. Shareholders got rich. But politicians decried Wolfson. He wasn't looking out for the interest of workers or riders or DC or something. He became, in the words of the Washington Post, the most hated man in Washington. Over the next decade, Lewis Wolfson became the most important, biggest business figure in America, if not the world. He pioneered the hostile takeover, trying to do at Montgomery Ward, then the second biggest retailer in America, what he'd done at Capital Transit. He failed. The world wasn't ready for the market for corporate control. It wasn't ready for someone pressing the interests of shareholders. Americans were rich enough. They wanted stability, not more growth. They were happy to divide the pie. They didn't need it to be much bigger. Not only did Americans not want Lewis Wolfson, they were happy to see him go to jail. Around the time Congress was passing the Williams Act of 1968 to kill the market, nascent market for corporate control, the Justice Department was sending Wolfson to jail for something that was clearly not a crime. That year is pivotal. The culture and law in 1968 were hard against efficiency. Enter Oliver Williamson and Bob Bork, and soon Posner and Friedman and the rest of the efficiency crew. Being against what everybody else was for made them interesting in a world where being interesting is everything. Had they come to the scene with the same ideas in 1949, when Lewis Wolfson tried to make shareholder wealth a single maximan rule, it is unlikely they would have had any impact. The ground was not fertile for their ideas to sprout. It's this combination, fertile ground set by politics writ large and ideas determined by the geniuses of the moment and the interplay between them, of what is in favor and what is about to be modern, that drives change in law. When they come together at just the right moment, as in the period when law and economics was born, they can change the world. Thank you.
Let's move on to the panel 3, the evaluation of global antitrust strangers. We would like to invite the moderator of this session, Mr. Lazar Redick, Senior Scholar for Competition Policy at ICLE, and the panelists, Mr. Thomas Zheng, Associate Dean Professor of Law, University of Hong Kong, Mr. Alvin Gao, Chief Executive of Competition and Consumer Commission of Singapore, and Ms. Shivangi Sukuma, partner of Axiom 5 Law Chamber, and Mr. Toshiaki Takigawa, Professor Emeritus of Kansai University.
Well, good afternoon, everyone. Welcome to panel 3 on global antitrust standards. Today's conversation will sit at the intersection of antitrust law, geopolitics, and institutional evolution. Around the world, competition authorities are grappling with common challenges: digital markets, cross-border mergers, and industrial policy pressures. Yet their political, legal, and strategic contexts vary significantly. But again, this is a truism. Contexts always vary and always have throughout history. For a time, though, for what seemed like a brief moment in time, in hindsight, despite these contextual differences, it seemed that a global convergence in antitrust was underway. The so-called Washington Consensus, doctrinal evolution, spurred by what Todd Henderson described as the law and economics revolution or evolution, meant that convergence in antitrust law was underway. The broader narrative of the end of history also contributed to this trend. This revolution, or this convergence, led to the elevation of the consumer welfare standard as the go-to yardstick to measure and demarcate anti-competitive conduct from pro-competitive conduct. But the question is, was this convergence the product of discovering a true antitrust universal embodied by this consumer welfare standard, or was it underpinned by a particular configuration of global power that is now changing? The more provocative question, of course, is, did such a convergence ever truly exist? This brings us to the core of today's discussion. Is global convergence in antitrust law still a viable goal, or even a reality? Or are we instead seeing a structural divergence driven by economic nationalism, policy fragmentation, and shifting geopolitical dynamics? To help us unpack this complex landscape, we're joined by 4 distinguished experts, each bringing deep insights from key jurisdictions across Asia. To my right sits Professor Toshiaki Takigawa, Professor of Law at Kansai University. He's one of Japan's foremost antitrust scholars with unique insights into both doctrine and enforcement practice, including experience at the JFTC and the OECD. Mr. Shivgani Sukumar, to my far left, is a partner at Axiom 5 Law Chambers in India. She's a leading competition litigator in her country who shaped constitutional challenges at the highest levels. Mr. Alvin Ko sits at my left, is the head of the Singapore Competition and Consumer Commission, with a remarkable breadth of public service experience across legal and economic policy making, including at the Ministry of Defense in Singapore, Ministry of Finance. Not working? No. Okay. How about now? How about now? Hello? Mic check. Working? Okay. And also at the tax prosecutor of the AG's chamber. Lastly, but last but not least, we have Professor Thomas Cheng at my right side from the University of Hong Kong, whose comparative work has been instrumental in understanding how competition law develops outside the transatlantic axis, and one of the main architects of Hong Kong's first competition law. Now, I think that given the international character of both the panel and the audience, it would be good to have a sort of contextual discussion or a back to basics introduction of the historical overview of the 4 jurisdictions that are represented today. So my first question for Shivangi, and again, it's a question that I will ask all of our participants, is Shivangi, can you give us an overview of sort of the historical trajectory of India, of where you've come from and where you are now? We'll discuss where we're heading at the end, so let's not spoil that. Again, you can, to structure your answer, you can look at, for example, 3 landmark situations or moments in Indian antitrust history.
Am I audible? Perfect. Firstly, thank you so much for having me. It's fantastic to be here and learn from other jurisdictions in terms of what we can expect in the years to come. And not to give away what we're going to be talking about later on, but I think the way in which different jurisdictions, especially in Asia, react to the same stimuli is very instructive for us as we embark on the next step. But to take a step back, very briefly, post-independence, we set up a system where we had to get permits and licenses for setting up a factory, increasing production. The goal of doing this was to make sure that we had adequate oversight, so there wasn't any mushrooming of power beyond what we wanted. But ironically, this created just that. And as a result, we had a legislation which was not as effective as we would have liked. And the premise of that legislation was to ensure that there is no bigness. And towards the late 90s, there was a gradual shift, and we enacted the current law, which is the Competition Act, which is very much in line with the TFEU. So a lot of Indian competition law draws inspiration from European competition law, and of course other jurisdictions as well. But this is the strongest parallel that is visible. And since then, we've kind of established a system where we're really trying to condition abuse and not dominance itself, and we condition other kinds of conduct that are commonly prohibited and regulated across the world. Where we're at is a very exciting stage because, and I know Indian regulators have been, Indian practitioners have been saying this for a long time, but we really are on the cusp of change because just last year we had a series of sweeping amendments to the existing Competition Act, and it equips the regulator to do a lot. So we're in the early days of the new changes to the competition law, and things look very exciting.
Just to go back to the 1968 law, which was your first antitrust law, right? How was bigness framed back in the day? You say that the law had an aim, which was to curb bigness, but how was it framed? Was it framed and was it couched in those terms, or was a synonym used?
Yeah, it was actually called the Monopolies and Restrictive Trade Practices Act. So, you had to, whatever you wanted to do, you had to seek a license or a permit from the government. So they just wanted to make sure that everything was very strictly regulated. This changed dramatically when they demolished the system where you had, there was globalization, there was liberalization, the economy really opened up, and the same system didn't stand, and it was rebranded, so to speak, as the Competition Act. So from prohibiting monopolies to promoting competition, that was the shift in terms of the
It was almost a paradigm shift from bigness to promoting competition. Absolutely. And this was in the 90s, no? If I remember correctly, it was a Raghavan Commission that injected economic analysis into the law?
Absolutely, yes. So there was a commission that was enacted to, that was commissioned to do a review of the kind of changes that were required, after which the Competition Act, as we know it today, was enacted. And it essentially came into force about 15 to 16 years ago. So that's our frame of reference in terms of jurisprudence.
And does this experience mirror Singapore's in any way?
I think we are quite different in that respect. So just to give some context, the Competition and Consumer Commission of Singapore, we are going to be 20 this year. And we have actually been evolving over the last couple of years. So in 2018, we were then given the consumer protection mandate as well. But before that, we were entirely a competition agency. Now, Singapore has brought economic strategy has always been open and pro-business environment. We've always strived to protect consumer interests, and as an organization, we work hard to ensure that our economy is a trusted and rule-based type of economy. So when we started in 2004, the Competition Act came into force, and we were born, as I mentioned just now. And it came about through a process of, most of the time in Singapore, we have lots of committees going on, and we had a committee called the Economic Review Committee, which from time to time we stand up and then we make sure that we look through the entire economy to make sure that we're still competitive in the global market. And at the time, they recommended a generic competition law to create a level playing field for businesses, big and small, to compete on equal footing. And that was a slew of measures to ensure that the continued growth and development of the Singapore economy. Thereafter, we took a little bit of time for the industries to get to know competition law. 2006, the anti-competitive agreements prohibition, as well as the abuse of dominance provisions came into force. And a year and a half later, in July 2007, mergers that substantially lessen competition was then prohibited. I should also mention that Ian was assistant chief executive at that point in time, so I think he's very, very well versed in what was happening in Singapore at that point in time. An interesting part about what we do is that we, unlike a lot of jurisdictions, we adopt the total welfare standard. And that's something that we wanted to focus on, to ensure that we don't just focus on consumers, we also focus on producers as well, right? To ensure that as a whole, the economy is efficient. Within the organization, we have also grown from strength to strength. We have since been part of the International Competition Network, the ICN, and we are very active in that space. We are actually the vice chair of the ICN. We take part in lots of activities in the region within ASEAN, and also in various other forums like the OECD, the East Asia Top Officials Meeting, and so on and so forth. So in that regard, we were talking about recent cases. I think we have also been taking a lot of attention to what's been going on in the digital space as well. I should say that Europe has really taken on a liking to digital markets, but unlike them, we haven't actually gone down that road. We have, from time to time, been looking at interventions within the digital market space. So I think one case that would probably resonate a lot with the Taiwanese audience here today would be the Delivery Hero matter, which we had a taste of it back in 2024. And Delivery Hero at the time was hoping to sell out. And they were hoping to sell out to one of the companies called Grab, and that would have resulted in market concentration of close to 90%. And whilst those discussions were going on, we decided that we would take on interim measures directions. We directed that two companies were to basically hold fast, not do anything that will influence any remedies that might come about later on in case we took an issue with the merger. And eventually they decided that they would not go ahead with that merger.
Just going back for a second, you mentioned that your law was pretty generic. But having a total welfare standard, I don't think it's that generic. I think most jurisdictions have a consumer welfare standard, especially the European Union and the US. So how did that come about? Really briefly, can you give us like a sort of a fly on the wall sort of overview of how that happened, how you decided to go for total welfare? And follow-up question, has there been a case in which total welfare marked the difference, sort of tipped a decision one way or the other? Perhaps a comparative case that was decided differently.
Well, I think I was going to return the favor to Ian just now for dragging me into the conversation just now. But anyway, I think that.
I'd just like to say that I've always been a total welfare guy because, and I appreciate that Singapore wanted a competition law that promoted Singapore's economic interests. I mean, the reality is all the distributional side is done quite separate from the wealth creating side. That's always been Lee Kuan Yew's sort of goal, as far as I can tell, after being there.
And I totally agree with that approach. They're very efficient at producing wealth for a small country. They have a very professional, and by international standards, I've worked in a number of international agencies. They're easily the best. Merit is paramount in Singapore.
Right.
And they do a very good job for welfare too. People at the bottom in Singapore are better off relatively than any other country I've ever worked in.
Thanks to the...
That includes Australia.
Wow, I think I need to buy him a drink after this.
Okay, great. I'm going to move on to Toshiaki, but we'll continue the conversation. Toshiaki, can you give me 3 landmark moments of Japanese antitrust law?
Thank you. Thanks for giving me this occasion. Actually, Japan presents a quite interesting case in this topic of commercial laws worldwide are converging or not. Because Japan inaugurated its commercial law called Anti-Monopoly Act. Anti-Monopoly Act after defeat of the World War II. So American occupation force kind of urged Japan to adopt antitrust law. So Japan adopted Anti-Monopoly Act, very under strong influence of American antitrust law. However, at the same time, Japan retained its unique unfair conduct regulation concept. This is not only unique to Japan, but it's kind of adopted several developing countries and even developed countries. South Korea also adopt unfair conduct. So for Japanese development in Japan of the Anti-Monopoly Act, one focal point is how to harmonize or reconcile this unfair conduct regulation idea to American origin antitrust law, consumer welfare. And in this, Japan has gradually kind of converged. In one sense, Japan has converged to American antitrust idea, so that even for JFCC apply unfair conduct regulation, if its target is the exclusionary act, Japanese competition scholars has urged JFCC to adopt the same theory of harm. Because Japan, as I said, Japan basically infiltrated American antitrust, so Japan has an equivalent of Sherman Act Section 2. That's called the monopolization clause. So that Japanese competition law scholars has for a long time urged the JFTC, even if they apply Unfair Conduct Act, theory of harm should be same as the application of the Monopolization Act. Only difference should be the lessening of proof of the market power. So evidently, if JFTC use Unfair Conduct Act, JFTC is the burden to prove market power is much lessened. However, for theory of harm, it should be same. However, this is only as the urge of Japan competition law associations, law association scholars. JFTC has retained its flexibility to adopt Unfair Conduct Act. However, JFTC has put more weight to Monopolization Act regulation rather than unfair conduct regulation for regulation by exclusionary act. So that we Japanese competition law scholars have understood that the JFTC has shifted its position to more prioritize monopolization regulation rather than unfair conduct regulation in the area of exclusionary act. However, there's two more important aspects of unfair conduct regulation. For unfair conduct regulation, the JFTC has classified this unfair conduct in the three parts. One is that Exclusion Act. Another is purely unfair conduct, which is called particularly called unfair interference into other business. It's a very ambiguous concept. And lastly, another very important aspect is abuse of superior bargaining position, exploitative act. So anyway, actually, Japan has recently has made more and more use of this third classification, superior abuse of superior bargaining position abuse. This has become kind of very controversial because JFTC has shifted its role from general competition law authority to enforcer of superior bargaining position. And the superior bargaining position abuse, JFTC has applied more and more broadly. So even to not only to business affair, but to consumer protection and even protection freelancers, etc. So anyway, I have to summarize my remarks. So
we'll get back to you. Don't worry. No, I appreciate. We'll get back to the. I really want to touch. I really want to touch on the superior bargaining position question. And
stop at this stage.
We'll come back to it. Don't worry. And also another topic that we'll get back to is sort of you mentioned that Japan introduced an antitrust law as a consequence of U.S. influence, and one potential question is what will happen to antitrust law if U.S. influence wanes in the world, right? But before we get to that, Thomas, can you tell us a little bit about the trajectory of Hong Kong? I know that you participated in the drafting of Hong Kong's first competition law. So can you give us 3 landmark moments of Hong Kong competition law?
Thank you. First of all, I'd like to thank the organizers, especially Andy Chen, the Vice Chairperson of the TFTC, for inviting me, for having me here. And I mean, Japan is probably the eldest statesman on this stage, but Hong Kong is definitely the youngest sibling. Our law was passed in 2012, so I guess if you ask me to name 3 dates, 2006, when the government finally decided to legislate. So for those of you who are not familiar, Hong Kong had been a vehement opponent to competition law legislation for a very long time. And there was a time when the WTO was pursuing the Singapore agenda, hoping to adopt some sort of competition law provisions in the WTO agreement, and Hong Kong was one of the most fervent opponents to that. And I spoke to Frederick Geny, whom a lot of you may know, of the OECD Competition Committee. He was involved in the WTO negotiation at the time, and he said, oh, the Hong Kong officials were so annoying because they were always saying we don't need competition law. We have a very free and open economy. And Todd mentioned Milton Friedman earlier. He loved Hong Kong. Hong Kong was his favorite economy in the world, and we had basically no trade barriers, complete free trade. And the government said, we have that, we don't need competition law. And of course, the government's completely neglected non-tradable services, and I think enforcement history in recent years has shown us exactly that's where the problems are. We have uncovered cartels in funeral services, cartels in elevator repair services, building maintenance services. None of this is traded, and obviously free and open trade is not going to help with any of that. And so I guess the second landmark date would be June 2012, when our law was finally passed. Our commission was established in May of 2013, and the law came into effect in December 2015, and the law has been enforced for about 10 years. And so we are still a very new jurisdiction, and there are some peculiarities in our law which I can explain in a little bit. But I think the Hong Kong experience is quite an interesting one from the perspective of legal transplant. And I think one thing I will say in the context of the global convergence debate is, I think economically, in terms of economic philosophy, Hong Kong is probably closer to the US than to the EU. It still takes pride in being a pretty free market economy. But our law is actually modeled after the EU law. I mean, our provisions object in effect, the language in Articles 101 and Article 101 of the TFEU is very much present in our law. And for those of you who are familiar, Article 113, the 4 conditions for an exemption under Article 101, that's also found in our legislation. So you have an interesting situation. I guess your political philosophy does not necessarily dictate the statutory language, if you will. But yeah, I'll
It's interesting. If the law is modeled after a European model, but you mentioned that it's more philosophically akin to the United States, how does that work?
Well, I think we haven't had a lot of test cases on this because, to be honest, so far, most of the enforcement action is in cartels. And I mean, the evidence in most of those cases was pretty overwhelming. So there wasn't really much room for debate as to what the correct outcome was, although I'm sure the defendants disagreed. But we do have a pending abuse of dominance case on unilateral refusal to deal. And our tribunal hasn't decided on that. So I guess that would be a good test case for whether the EU side or in terms of, I mean, our tribunal refers to EU cases. So it's, I mean, I guess because of the choice of statutory language, I think the judge takes it as a hint that the legislators want the tribunal to look at EU case law. And also because Hong Kong being an English common law jurisdiction, historically we've always looked to English cases and by extension prior to Brexit, to EU cases as well. So there is a historical lineage. There's a reason why we have looked at European cases more. But yeah, so I guess the abuse of dominance, unilateral refusal to deal case would be a first test case for how this potential conflict between legal lineage and economic philosophy plays out.
Is it, out of curiosity, is it a case in digital markets? Is there any chance that Android Auto from European Union will be imported into Hong Kong, or is it?
No, so we have had 2 cases involving the digital markets, and one of them is also involving Foodpanda, which is a subsidiary of Delivery Hero, and it's interesting how it's all the same cases everywhere in Asia, and what has happened in our market, I think it would be quite. I remember at the conference last year we talked about this, and I raised the point that the food delivery platform market is quite dynamic, and I think at the time the TFTC was deliberating on the merger of Foodpanda and Uber Eats, and at the time on the stage I said the market is surprisingly dynamic because Kita, which is a subsidiary of Meituan from the mainland, had just entered the Hong Kong market and apparently acquired more than 30% market share in the space of a few months. And at the time, I made a mistake of disclosing that because that piece of information was given to me by a former student who represented Kita. But as it turns out, none of this matters because actually Kita is now the dominant firm. And at the time when Kita entered the market, there were two firms, Foodpanda and Deliveroo, and Deliveroo has now exited the market. And so it's I guess the same markets, but I guess they play out quite differently in different jurisdictions. But yeah, but no, the abuse of the unilateral refusal to deal case is actually related to supply of medical gas. Yeah.
That's a great segue into the second bucket of questions, which is the current enforcement priorities and the theories of harm that your jurisdictions are looking at. I get a sense that there's not that much enforcement in digital markets in Hong Kong and Singapore. Is that right? Question to both of you. Alvin, do you want to speak?
Well, I think we are still back to basics in that sense. I think in the last couple of months, in fact, the last couple of years, our focus has entirely been on cartel enforcement. But I think what has been quite remarkable is that the financial penalties that we have been meting out has been quite substantial. But over the last 20 years, we started quite slowly, in fact. Our first case was about some 3 years after we were established. But shortly after that, within the last 17 years or so, we have meted out about $90 million of financial penalties over about 20 over cases. Mostly cartels. We had one abuse of dominance case. That is a case involving what we might sometimes call a state-owned enterprise. But I think you can imagine that it's quite a challenge to go after a state-owned enterprise in that sense. But we, as a matter of principle, we nevertheless went ahead. And that was abuse of dominance case. But as I mentioned, largely in the area of cartel enforcement. That said, we do keep a very close lead on the digital markets as well. And as I mentioned just now, there has been cases that we have taken some action on, including a merger enforcement matter, including involving two digital platforms, Grab and Uber. Uber decided to exit the Singapore market and they sold themselves out to Grab, who then proceeded to close the deal without notifying us. So in that case, we had to take a series of actions that resulted in financial penalty of about 13 million Singapore dollars.
Right.
Yeah.
Right. Thomas, why isn't Hong Kong focusing on digital markets like everybody else? What's your excuse?
Well, first of all, I don't purport to speak on behalf of the Commission. I stepped down from the Commission in 2018, so I'm no longer part of the Commission. But interesting. I mean, I guess like Singapore, the Hong Kong Competition Commission has chosen to focus on. Well, maybe I shouldn't say chosen. Has focused on cartel cases. I think. My sense is, and I mean, as I said, I'm no longer part of the Commission, so I don't really know this for a fact, but I think the general sense is that the case, the enforcement of competition law in Hong Kong is largely driven by complaints. And I think we have, my sense is there's not a lot of ex-official investigations. And the cartels have, the complaints have mostly focused on cartel cases. And I mean, to be honest, maybe not for a bad reason. I mean, for example, last year, the Hong Kong Competition Commission raided the fish market in Hong Kong. And I don't know if it's the same in Taiwan, but in Hong Kong, the supply of foodstuffs tend to be fairly traditional, archaic industries and apparently quite heavily cartelized. And that case was in the news everywhere. Evening news, apparently, the Commission went with the police and closed down the entire fish wholesale market and raided 40-something fish merchants, and the entire city took notice. So I guess in a sense, for a new authority, that may not be a bad idea. But in terms of digital markets, there have been two cases, and I guess in a way they're both interesting from a legal transparent perspective. The first one is on the hotel booking websites, Expedia.com, Booking.com, Trip.com, and the issue was price parity clauses, MFN clauses, and in that case, I think the Competition Commission in Hong Kong pretty much piggybacked on the enforcement activities in Europe. And my sense is they basically approached the website saying, okay, you have agreed to these commitments in Europe, give us the same. And they pretty much did. And so that was an interesting case of, I guess, piggybacking on the enforcement effort of other jurisdictions. And the second case is, as I said, Deliveroo and Foodpanda. And as it turns out, I guess these, I'm not sure if you have the same in Taiwan, but Foodpanda and Deliveroo apparently, I guess, enter into exclusive arrangements with restaurants, forcing some restaurants to only work with them. I guess for those of you who are familiar, that actually happened in mainland China as well. Meituan was fined billions of dollars for exactly doing that. And as it turns out, Foodpanda and Deliveroo did the same in Hong Kong, and they agreed with the commission to stop doing that. But yeah, I mean, I think so far, if you say, I mean, in the digital sector, it's mostly been a case of following the leads of other jurisdictions. I don't think there's a lot of, I guess, completely brand new investigations.
Yeah, that leads me to Shivangi. Shivangi, in India, is it also the case that there's this piggybacking phenomenon where the Indian Competition Commission looks at a company like Google and says, look, you've done this in Europe, or you're about to do it because of the DMA, just do it here? Because I know that there's an ongoing Google case, and if it was that simple, it probably would have ended already, but it hasn't. Can you give us a little bit of context on how this enforcement works?
Sure. Just one correction. There are multiple ongoing Google cases. That's, I think it's interesting because, you know, the CCR's interest in the digital sector really picked up in 2018 or 19, and it's continuing. And just as an addendum, I'd say, yes, there is.
Do you know?
It's just the increase. I mean, I would attribute it to the impact of, you know, entities in the digital market on other, let's say, brick and mortar retailers, and, you know, the way in which the various economy and market participants were functioning. But essentially we have some cases where there is some piggybacking, but we also interestingly have some cases that are unique to India. For example, you know, we hear about Deliveroo and Foodpanda, etc. In India, you also have quick commerce, which has really skyrocketed. So, you know, you have players who are kind of leveraging their existing logistics abilities to deliver, you know, groceries to your doorstep. And that has really disrupted the way in which business is done. And in the last year or so, that has really, really gathered a lot of, you know, attention. And this is something that the Commission is actively investigating. So I would actually frame it as a piggybacking plus. So yes, there is something you look at in terms of other jurisdictions, but you have some uniquely Indian issues as well that the CCR is very actively considering. I will say, though, that it's not the case that, you know, any issue that's brought before regulators elsewhere is taken, you know, is automatically sent for investigation in India. I think the Commission has been extremely discerning in determining which matters to send for investigation. There are a lot of issues being examined. Equally, there are a lot of issues being closed. So I think it is under the scanner, but it isn't always investigated, which is a great place to be.
Are complaints like Thomas suggested in Hong Kong, are they mostly initiated by third parties, or is it at the discretion of the ICC?
So complaints can come in one of three ways. When we're talking about the digital economy, we're really looking at vertical restraints and abuse of dominance cases. And this is usually because of complaints that have come in from aggrieved persons. Where you have cartel cases, it can be, you know, by reference from another statutory authority, or, you know, a suo motu case. So,
right?
Consumers, consumer organizations. I mean, it's because
not
you look
competitors.
at. You know, the unique aspect of this is that, and this kind of ties into the point you made earlier about the consumer welfare standard and the total welfare standard. And to repeat the plus point, I would actually imagine that in India, it's a consumer welfare plus. It's not really a total welfare. It's not really a consumer welfare. I think a total welfare standard you can't, really weigh only producer efficiencies versus consumer benefits, but at the same time, it's not consumer benefits alone. And this kind of ties into who brings the complaints. So you have consumers, you have consumer organizations, you have aggrieved competitors, and you have organizations of aggrieved competitors. So you really have a pretty wide spectrum of complainants. And I think that gives a really rich picture of the kinds of issues that the Commission looks at.
Right. Toshiaki, who brings the complaints mostly in Japan?
Complaints is basically brought by JFTC. We have okay. We don't have many cases brought by private company, but private suits actually has been increasing. So Japan maybe become more and more like United States, so that we are going to have more and more private suit. And as I mentioned, because of that Japanese unfair conduct regulation, it's easy for companies to bring suit to courts. So that anyway, this is an important development in Japan. Just like United States, Japan, aside from JFTC actions, we are going to have independent private suit and court decisions. So courts is becoming more and more important in Japan.
The European Union, I think the United States, there are a couple of trends, certain things that are weighing on antitrust enforcers' mind these days. One of them is vertical integration. There is a trend in thinking that vertical integration is more harmful than was thought hitherto. Of course, this is a function of the suspicion of platforms, whereby the fact that a company operates a platform and is also active on it leads to potential anti-competitive exclusion. There's other things also, if I had to point out 2 or 3 trends, which is AI partnerships. AI partnerships are another huge flashpoint in the European Union, I think in the US, and there is a fear that these partnerships, even if they don't qualify as a merger, might take out a potential competitor from the market at an early stage, or even prevent a European champion, I think, from emerging. I think that's another thing that's often not said out loud. There's also, of course, killer acquisitions, which I think somebody mentioned. Alvin, was the food delivery case a killer acquisition?
Unfortunately, not at all. It's nothing as exciting as that.
That's the problem with killer acquisition. It's too exciting. It sounds too exciting.
Well, I mean, there's a great deal of crystal balling as well that goes on for such cases. But unfortunately, in those cases, they were about companies that were hoping to exit the market. And I think that's also an issue that we as a small and open economy, which is very much like Hong Kong, we are quite also paying some attention to. Because when you talk about a small and open economy, you're talking about low entry barriers, and that's when you attract those companies to come in and invest in your economy. But having said that, when they come in and they try to make their money in your economy and they realize that, no, this is not turning out to be as good as it should be, then what? I mean, do we expect them to take the beating and then just leave with a great deal of losses? Or should we also provide some kind of mechanism or think through what is the philosophy about allowing some of these companies to exit, to sell out, and what conditions they should sell out under? Right. So I think these are issues that have no easy answers. But I thought that as a small and open economy, fundamentally, we need to think about such things and to see how we can provide for firms to enter and also to exit in a proper way.
So you're saying that incorporating this killer acquisition exciting theory that we've mentioned could foreclose some of those avenues of exit and thereby also, in a sense, sort of deflect entry into the market?
I mean, if you talk about letting people have free autonomy to decide what to do with their businesses, for example, I think we also have to provide for some of these mechanisms as well. And I don't think there's a one-size-fits-all issue, but I think if you want to have a very productive, very efficient kind of economy, exit as well as entry is actually very important.
Lazar, actually, if I can ask Alvin a question.
Yeah, totally.
So I remember when the Uber-Grab merger or Uber exiting the Southeast Asian market was going on. It wasn't just in Singapore. It happened in a lot of Southeast Asian jurisdictions. I think Philippines it dragged on for quite a few years. Do you think things would have happened differently if there was more of an ASEAN enforcement? I mean, the ASEAN countries were enforcing the law in a more collective way as opposed to, I guess, 10 different jurisdictions. I mean, Uber and Grab could basically just ignore you one by one. I mean, I'm not ignore you, but I mean, at the time, you kind of feel that they were. I mean, from an observer's perspective, I felt like would things have happened differently if enforcement were more. I mean, there was more of a collective effort in enforcement.
More coordinated.
Yeah.
Well, I think short of going down the road of the European Union, right, to have a supranational competition authority in a sense, I think that is going to be quite challenging. Simply because if you look at ASEAN as a group of countries, it is at different varying states of development. I think the practice and enforcement of competition law is also at differing levels as well. And I think in the last 10 years or so, many of these jurisdictions then started to enact and to start enforcing competition law. I'm not so sure that everybody would have come to the same conclusion that there was a requirement to intervene. And I think very much, as we talked about for competition enforcement, is largely to do about the state of the market in that particular jurisdictions. And I don't think that it's going to be such an easy answer. So I think the answer would have been largely the same as what would have happened. You need to take into consideration the particular context, the market, who else is which other players are in the market, what consumers are prepared or not prepared to pay, what other alternatives are there. And I think those things would have made for a different answer in some of these jurisdictions.
On the topic of killer acquisitions, I know that India recently introduced two mechanisms. One is threshold value thresholds rather, and the other one is settlement procedures. The former seems aimed at curbing these so-called killer acquisitions. Is this a response to a deal that has been waved through that has been proven to be harmful in hindsight? Or is this, let's say, an import from another place, another jurisdiction, let's say a European Union, for example? What is your take on this development? Where does it come from? Where does it stem from?
Just a quick point. I think it's really interesting that you're mentioning the devalue threshold and the settlements and commitments regime, because the first really increases the the administrative costs of the CCI, and the second really reduces it. So I think it's interesting that you mentioned both together. I think only it's early days, and the deal value thresholds have just been introduced, and it is speculation, of course. But my understanding is that it is the CCI is influenced by happenings in other jurisdictions. So I think they are trying to make sure that nothing kind of slips through the cracks. Right. But it's still early days, so it's a little difficult to ascertain any kind of trends over there. But I think in terms of settlements and commitments, we're already seeing the benefits of that. Quite recently, the CCI accepted settlements in relation to one of the cases involving Google. Mm-hmm. And this is definitely relief for all parties involved, because it really frees up a lot of resources. Right. And I think that part of these are two very important changes that have been introduced recently. You also have the leniency plus regime, which is increasing the number of carrots.
Is this a novelty too?
The leniency plus regime is a novelty
this
because it was enacted as part of the 2024 amendments, and it's basically increasing the carrots that are on offer if you were to disclose additional cartels that you're part of. I think taken together, all of these really equip the CCI to do a lot more and free up resources for investigating only those issues that really pose competition concerns.
Yeah. So do you think that these reforms could assuage or defray some of the pressure to adopt DMA-style regulation? Because sort of a big part of the argument is enforcement is too costly, it's too difficult. But now you have settlements, now you have all these other tools, leniency plus. Could this be a substitute, perhaps, for DCB, or are these things unrelated? Do you think it addresses sort of some of the main concerns that spur this ex-ante regime?
Absolutely, and I'd go a step further to say that even without this, I'd imagine that the existing Competition Act was enough. Because of the new amendments, the CCI can do a lot more, but even without that, there's a significant track record of the CCI in dealing with a variety of cases. And this is a tale as old as time in other jurisdictions as well, which is how do you interpret the law to govern new age solutions, but it's not something that hasn't been done before.
Right.
And I think what we're finding is that it's not the case that enacting a DMA style legislation will essentially resolve a lot of the problems that have been raised before the Commission. It could actually make things more confusing. And we're already seeing that. Last year we had the draft digital competition bill, which really muddied the waters in terms of A, who it would apply to, and B, what it would actually do. So I think there's still a lot of debate, and there are consultations that are ongoing. As recently as this morning, I think there are reports that maybe the Ministry of Corporate Affairs is thinking of doing a market study to ascertain the need for an ex-ante regulation, which I think would work very well, because the worst case scenario would be to enact this law that nobody is happy with, and that's something that
it seems like a revolutionary idea to conduct a market study before adopting such a far-reaching law, but it shouldn't be, right?
Absolutely, but I think learning from the past and learning from the experiences in other jurisdictions, I think it's a very prudent step to take, and I think making sure that all stakeholders are heard and not the loudest ones in the room is the best.
Who are the loudest ones?
These are questions that we can answer at length.
Sure.
But
right.
I think the loudest ones would be you'd have significant players in every sector. So for example, you would have people being affected and people whose conduct is being affected, but equally you would have federations of aggrieved parties. So you're not really looking out for entities on the fringes of each of these markets, so to speak.
Yeah. Well, now that we've opened Pandora's box of ex-ante, there's no going back.
Yeah.
So I know that Japan recently adopted the Smartphone Act. I know that you wrote an article published in the Antitrust Bulletin about it, and I also know that the guidelines have come out.
Yes. So that's interesting area. Okay. So Japan has recently come up with two important legislation and JFT case in the digital market field. One is just you mentioned that the Japanese Smartphone Act. Another name is Smartphone Software Competition Promotion Act. This is basically modeled from the EU Digital Markets Act. However, one interesting point is that Japan restricts this area only to the smartphone ecosystem. So before going into this legislation, I would like to cover another interesting digital market related case. That's JFTC's April this year cease and desist order against Google regarding Google search. This is really not well reported, but this is an interesting decision. And also, this follows my last remark on the Japanese importance of Japanese unfair conduct regulation. So as I mentioned, our Japanese competition law scholars understanding has been that the JFT has shifted its emphasis at least regarding the Exclusion Act from unfair conduct regulation to monopolization regulation. And actually, JFTC has come up with several exclusionary conduct regulation, in which JFTC applied monopolization case rather than unfair conduct regulation. However, in this JFTC's cease and desist order against Google search, JFTC is applied unfair conduct regulation instead of monopolizing regulation. It's on surface, it's puzzling because Google evidently has very strong market power, and it's already proven in the EU Android case and the famous United States Judge Meta's quite famous that Google search decision. Then why JFTC chose to apply this unfair conduct regulation rather than monopolize? It's a kind of a little bit puzzling. But at least JFTC has not been criticized so far from United States that why you use the unfair conduct regulation. It's quite kind of out of step with the international standard. But looking deeply into this JFTC decision, at least I can understand why JFTC uses unfair conduct regulation rather than this monopolization. One important reason is that if JFTC used the monopolization regulation, JFTC is obliged to impose fines. Fines become a gigantic amount considering Google's business scale, so that Google may appeal to JFTC court. So JFTC, by applying this unfair conduct regulation, JFTC did not impose any fines.
There's no fines?
No fines there. No fines. Huh. Only remedies. No fine at all.
So they feared that there would be an appeal that they would lose?
They would not lose, but it's kind of not lose, but JFTC is forced by, as I mentioned, Japanese competition scholars has criticized JFTC's unfair conduct regulation because its standard is so loose. Yeah. And the court has also come up with several decisions. So if it's appealed to courts, even if ultimately JFTC wins, courts will say to JFTC, your finding of unfair conduct regulation, which on the which JFTC only is required to prove lessening of competition. However, courts may urge JFTC to more approach monopolization regulation status. So anyway, it's very cumbersome for JFTC.
Right. And real quick, before I move on to Alvin and Thomas, the Smartphone Act, is it rooted more in monopolization logic or more in fairness logic?
Smartphone Act is actually it's more industry policy rather than extension of competition law.
Why do you say it's industrial policy?
Actually, you know, for instance, compared to South Korea, we already knew that the South Korean competition authority has been very positive, but took so much initiative to legislating DMA equivalent in South Korea. However, in Japan, the initiative for legislating this Japan Smartphone Act came from Japanese Ministry of Economy and Industry, and together with several influential politicians of the ruling Liberal Democratic Party. So JFTC is kind of forced to involve. Of course, JFTC was not against. JFTC officially said JFC is forward-looking to the legislation. But anyway, initial force to make legislation came from Minister of Economy and Industry. And yeah, so many scholars, including me, expected that this Smartphone Act may be enforced by Ministry of Economy and Industry. But ultimately, Japan, it's intransparent. It's transparent, but anyway, very intransparent way. Japanese government decided that the JFTC should enforce this act. So looking at the detail of this act, just like EU's Digital Markets Act, this is very contrary to antitrust and competition law principle. For the antitrust and competition law worldwide, at least mainstream consider that the exclusion act of the dominant company should be judged by rule of reason from the ultimately from the consumer interests. So this, so in this sense, this Japan Smartphone Act is basically same as EU DMA. This adopts passive legal approach for certain important conduct, just like self-preferencing and interconnection. So JFT, however, one hope is that as this act is now enforced by JFTC, and the JFTC has just several weeks ago has come up with a very detailed guideline, nearly 100 pages, quite detailed. So that in that final form of guidelines, this final form of guideline came after contemplation of the draft guideline. So draft guideline was put into the public comments. And not only Apple and Google, but several institutions, I guess, including ICLE, came up with comments. And JFC has reacted these comments, including ICLE one. So that, yeah, reacted. So for throughout the ICL comment, JFC replied that they would more take into consideration innovation incentives.
Okay, yeah, that's I remember.
So that my hope is that now that JFC has kind of shown some conciliatory approach, JFC will show more flexible approach than the EU Commission toward particularly Apple. Apple is basically the target.
It's a low bar though. Thomas, okay, so we broached the question of ex ante. To date, in fact, Japan is one of 3 countries, I think, that's passed ex ante rules, the others being the UK, the European Union, of course, and finally Japan's Smartphone Act. Is Hong Kong in any way considering ex ante as sort of the only viable solution to some of the theories of harm that we mentioned previously? Vertical integration, self-preferencing, tipping, network effects. These are the usual sort of theories that are put forward. Is this conversation, does it exist? Is it in an incipient phase in Hong Kong? Where are you right now?
I think the short answer is no. I don't think there's much discussion about that at all. Yeah, to be honest, I don't think there's enormous concern about the market power of the platforms, Google, Facebook, and the like, in Hong Kong. So no.
Because they're not as present?
No. They are very present.
Okay. So what changes? Why is?
I to be honest, I'm not sure. But
you had to guess.
If I had to guess, I mean, I guess we're not going to have a homegrown champion. And for some reason, one reason or another, the American tech giants are a lot more popular in Hong Kong than the mainland ones. I mean, you would think it would be Hong Kong would be a natural place for them to duke it out, but people, I mean, Google and Facebook and the likes are still more popular. So, I mean, I guess industrial policy, at least within Hong Kong, is not an issue, and I mean, I'm not sure if it's right for me to say, but I don't think the mainland tech giants are. I mean, until the last year or two, I don't think they've shown much interest in Hong Kong. Right. So there is no push to use competition law as an industrial policy tool, I guess, to assist the mainland tech giants to gain the foothold. None of that. So,
but we're assuming, it seems to be that at least this part of the panel assumes or is in agreement that ex-ante rules are sort of industrial policy to sort of bolster homegrown champions. Is that right?
Well, I mean, I actually don't think I would necessarily go that far to equate ex-ante regulation with industrial policy. But I mean, I think ultimately the more simplistic and probably accurate explanation is that, I mean, we are such a new jurisdiction. I mean, taking on digital economy issues is probably seen as a bit too much of a stretch for us. And so I think as of now, the Competition Commission probably feels the need to do something to be not seen as being completely left behind. But I feel like maybe they have picked some low-hanging fruits. I mean, Booking.com, Expedia.com, and then the food delivery platform cases. So, I mean, I think taking on the likes of Google and Meta is definitely seen as probably a step too far. So, yeah.
This is an interesting question, political as much as it's technical. You mentioned that the commission wants to be seen as doing something, and I wonder, seen by who? Is there this sense of sort of noblesse obligée or sort of technocratic pride where the commission looks at the European Union and says they're doing it, so we shouldn't be left behind, and we should do something, right?
Interesting question. I mean, I mean, as far as local public pressure, I honestly don't think the public is clamoring for the Competition Commission to act against Google or Facebook. And I don't think they were clamoring
for it in Europe either. At least if you mean citizens or consumers.
Right.
Some groups were interested, yeah.
Yes. I mean, I guess that goes to the question of to what extent the general public is ever really attuned to competition law issues. I think we tend to overestimate our importance. Yeah. But yes, no. I mean, at least as far as Hong Kong, I don't think the public is really interested in or putting pressure on the commission to do any of that. So. I mean, the Hong Kong Competition Commission is, I guess, part of the international fraternity of competition authorities. I mean, it goes to the ICN every year, and I'm sure they are aware that the digital sector is what everyone talks about all the time. So, so I'm sure they are aware of all the enforcement action in other jurisdictions. So, I mean, I don't know if they feel that they should also take part in get in on the action to be part of the community, but I'd imagine, I mean, there would be some pressure of some sort. But I mean, it is a very small commission, and I mean, I think taking on a case against Google would probably take up all the entire manpower of the commission. So they, I mean, I think rightly focus on fish and funeral services, and
which we forget that these markets exist and they're often anti-competitive, and the returns on investment.
Oh, funeral services is entirely cartelized. I mean, they are so expensive. For some reason. Yeah, I mean, from speaking from personal experience,
there's a lot of tying also.
Yes, I mean, it's a completely monopolized industry. It's they're right to go after them. So
so Alvin, tell us a little bit about where ex-ante is or isn't in Singapore.
Well, I start off with looking back at things were happening in 2018, 2019, 2020. We felt that there was quite a bit of interest in digital markets at that point in time, and the approach for the Commission has always been that we act on evidence, we act on when there's actually a need to, simply because if you intervene in the market, then obviously that causes a lot of distortions, and that's not something that we set out to do as a matter of principle.
Just to play devil's advocate, isn't the vast evidence accumulated by the European Union and their reports sufficient for you to take action and say, hey, if it works for them, let's pass the same laws?
Well, I don't think that that's how we operate. I think we decide that we need to get clear evidence, and as I mentioned, the market in Singapore could be very different from the market in Europe, for example. So we traditionally would want to see that there was actually clear evidence or consumer harm, for example. So in 2020, we then decided that we would look into this market a bit more, and we set out to do a market study into e-commerce platforms to see whether or not there are competition concerns in that area. That was actually part of our ongoing efforts to monitor the important digital economy. What we discovered was that there weren't any fundamental issues with competition in that market. And there was actually a number of players. In fact, there was actually quite a fair bit of rivalry amongst the different platforms in that market. So we decided that there was no need for us to intervene in that market. Fast forward to 5 years later, I mean, 5 years is a very long time in the digital market sphere. We have actually been focusing on that market in the meantime, and we have decided that ex-ante regulation at this point in time isn't required. I don't say that as a matter of principle, I say that as a matter of practice in a sense, because we have been working with the industry players in the meantime. In the last year or so, there's been quite a great deal of consultation, collaboration, ground-up efforts to ensure that there's some industry buy-in. And we've been working essentially on having a voluntary code of conduct, right? Covering competition issues. This voluntary industry benchmark for digital platforms is something that we want everyone to buy in, so that essentially there will be a great deal more redress for consumers if there's a need to. And that's been our approach. Thus far, the industry has been very cooperative, and they've understood why we are going down this road instead of having legislation. And I think that's so far been going quite well. We're hoping to have a positive announcement in the next couple of weeks, in fact.
Sure. Okay, so we've talked about the past, the present. Let's talk a little bit about the future, which is inherently speculative. I'm going to move to Shivangi. And Todd mentioned cycles, right? And the ground being ripe for certain ideas, the moment, no? We're seeing some change, arguably overstated, but maybe not, in sort of the paradigm shift from an economics-based antitrust law to something akin to fairness, right? Arguments of fairness and participation, maybe equity, seem to be gaining ground in some places. We've seen the neo-Brandeisian rise in the US. Arguably, the DMA is part of that same narrative. So now my provocative question to the panel, I'll start with you, is there a paradigm shift, or do you think that antitrust law will remain anchored in economics? And whatever change may come might be more piecemeal than sort of revolutionary.
I'll answer that first of all, that's a pretty, I'm going to be pretty ambitious in my answer, and I'm going to try and answer it in 2 points, although those are essentially bigger picture points that, we can unpack later on. But I think there's one issue in relation to the Indian legislative system that I'd like to highlight. It's an idiosyncrasy, which is that the jurisdiction of the CCI is something that's very unique to India. So you have a whole line of cases which determine the kinds of cases the CCI is going to look at. And I think this is a very important step to, chalk out what the courts should do and what the regulator should do. So in terms of a paradigm shift, I'd say not just yet. That's a second level discussion to be had. I think the first level discussion is who should decide what. And the reason that I mention this is because one very obvious conflict or reconciliation that's on the cusp of happening right now is data protection and competition law. And this is kind of brought into sharp focus because of the Meta decision that the CCI issued in relation to consent. And it's currently being heard by courts right now. So I'm not sure that there's going to be a paradigm shift in relation to certain things, for example, in relation to jurisdiction. However, I think there is a possibility of there being a paradigm shift in relation to how we look at markets more generally. And I'm very optimistic about the fact that any additional regulation will be balanced against the cons of those additional regulations. Just to go back to a point that we discussed earlier, it's great that the ministry is looking at doing a market study, and this is on the back of extensive consultations that they've had with various stakeholders. So they, when there was a push for ex-ante regulation, and you had the committee that was constituted to discuss the need for an ex-ante regulation, and they received feedback saying maybe this needs to undergo another iteration. I think it's a great sign that there's more deliberation before rushing to introduce any new laws. So if there is a paradigm shift, I feel cautiously optimistic that that will be backed by consensus, by economic evidence, especially on the back of the Supreme Court of India's recent judgment that effects should really guide the way in which competition law is enforced.
That's encouraging.
In India.
Yeah. Thank you, Shivangi. Alvin, same question, but I would like to add a spin. If there is a sort of deglobalization, decoupling, do you think there's going to be spheres of influence in antitrust law? If we accept that there's been some level of convergence towards total welfare, consumer welfare, efficiency-based conduct, do you think that if we roll back that globalization, that there might be more fragmentation in antitrust law?
Crystal balling, I think that you might actually have, broad bands in that sense, where depending on the economy, depending on the nature of the market in particular, depending on the attitudes of the decision makers, the policy makers in those sectors, you might have pretty much differing outcomes. But I don't think that it's going to be massive fragmentation. I think most jurisdictions still work on evidence. They still work on making sure that there's welfare benefits for the consumers. So I think that you wouldn't have, a total devastation in a sense.
Right. Thomas, what does your crystal ball say in this regard?
It's an interesting question. I guess I would say I'm not entirely sure the extent to which there is a consensus globally on a certain enforcement standard. I think if you look at the legislations of different jurisdictions, my impression is not a lot of them have one policy objective of competition law. A lot of them have many policy objectives, and consumer welfare is one of them, but many of them have development of national economy, national competitiveness, and all these other things. And so Does Hong
Kong have those things?
Hong Kong doesn't. Yeah, but I don't think that's a debate that we've had a lot. But I guess, I'm just looking at broader perspective globally. If you look at China's anti-monopoly law, the policy there are like 6-7 objectives, and I think consumer welfare is one of them, national competitiveness and all that. And I think from the enforcement record, it's pretty clear that national competitiveness is definitely a paramount consideration among many. And so, I guess. I guess my point is I'm not sure if there is as strong a consensus globally on this as we'd like to think, and so I'm not sure what does that mean in the future developments. And I think a lot of jurisdictions that the laws actually ascribe a number of objectives to the law, and so to the extent that courts and enforcers are faithful to the legislation, they are actually supposed to consider a range of objectives. I don't know about the law in Taiwan. Is it only consumer welfare? I'd imagine probably not, right? Right. Right.
It's in the statute? Okay. Yeah. And on that note, I'd like to open up the floor for questions and comments. Please don't be shy. This is your last opportunity today. So please raise your hand if you have any questions. Yes, Payal, please. Oh, can we get the mic?
Yeah. I think, could I ask you a question? Because I saw you. Because I heard you ask that question and there wasn't any consensus. Do you think that ex-ante regulations, wherever they are being considered in jurisdictions, are implicit in them is an industrial policy response? Because coming from India, I don't think so. It was the industrial policy which is guiding the deliberations on having an ex-ante law. It is much more to do with the limitations of competition law in dealing with, because it deals with competition. It does not actually deal with fairness, contestability, etc. So it is about fairness, which competition law does not, because it does not. It has very limited mandate for exploitative conduct. So do you think there is a presumption now that ex-ante laws, wherever they are being considered, are a response to industrial policy? Because we do not have national champions to defend through this law.
I do think that, at least in the European Union, it is an industrial policy legislation. I think that it may be the case that countries that are considering similar regulation are actually passing industrial policy with an EU flavor through the back door, right? But sort of a provocative opinion is that I don't think it's necessarily so focused on creating champions as it is on curbing or disciplining certain companies that are seen as being too powerful. And power there can be described not necessarily in the narrow market power sense, but more in an even political sort of lingo. But the industrial policy angle in the European Union arguably has to do with facilitating complementers and not so much with creating champions. I think the European Union's perspective is, at least with the DMA, listen, we are not going to catch up with Google right now, but at least let's regulate it so that our businesses, which are mostly sort of users of Google, complementers, let's say, and the same goes for app developers that are active in the iOS store and so on. Let's make it easier for them by diverting some of those rents towards them and lowering prices to them. Competition law has a problem from the perspective of the DMA, which is that it's too long and you can lose a case. So with the DMA, you really can't. So if you look at the DMA, it's all, I would say 99%, if not 100%, theories of harm from antitrust law that stem from antitrust cases, whether it's Google Shopping and self-preferencing, or Google Android and tying, or Amazon, the case that was settled, again, in MFNs, that the regulators said, okay, let's make it so that we don't have to litigate these cases and that we always get our preferred outcome, right? Since we can't justify it on the grounds of consumer welfare, let's do it on the grounds of fairness, right? So to answer your question, I think that in Europe, it is industrial policy. It is even technically not competition law. It was passed with Article 114, so supposedly harmonization of laws, but a harmonization of laws that didn't exist prior to the DMA. There was no laws to harmonize, right? Which makes it suspect. But of course, it was easier to push through Parliament because you didn't need a qualified majority, right? So my concern with other countries passing the DMA is exactly, goes to your question, that they might think that it's competition law. And it's not exactly competition law, it's something else. It's not entirely foreign to competition law because, as I mentioned, the theories of harm are familiar to competition law, but the outcomes and the reasoning behind them are arguably something that's grounded in fairness and equity, not necessarily efficiency. Right, great question. More questions from the audience or react? Yeah, please. Yeah.
I totally agree with you all the discussion. Yes, between you guys.
We can't hear you over here because that mic doesn't work. Can you try it? Can you just test it? Let's see.
Try this one.
Is it okay?
I totally agree with your discussion so far.
Put it close to your, very close to your mouth.
Okay.
Right.
Is it okay now?
I think he's not holding it close enough. Let's try that mic. But it's working for me, no? This one works.
I hope it works now. Okay, perfect. Okay. I totally agree with all the discussions you guys made so far. And when I asked the EC officials about the natures of the DMA, at the first stage when they talked about the new competition tools to develop the DMA legislation, at first they didn't deny it has a certain intention to grow the local national enterprises to compete with monopolistic American big techs. And as time goes by, and they developed to make it as a part of the competition law instead of the industrial policy. And my observation is that increasing numbers of European scholars tend to be agreeing with the European Commission officials on the nature of the Commission law. But in my view, as many people describe, there is a certain limitation about the Commission law, because if you strictly apply a strong ex-ante rules in the Industry Regulation Act, it tends to deny all the benefits of the effect-based approach.
Well, that's what they want. They don't want the effects-based approach
and
because it bogs down their enforcement.
Right.
Which they are sure is correct.
Right. As Professor Takigawa correctly described, in Japan, it looks like they consider the Smartphone Act as part of the industrial policy rather than a part of the Commission laws.
And it was spurred by METI.
Yes.
Yeah.
So I believe it is very important to make a correct demarcation between the Commission law and industrial policy. If you want to enforce the industrial policy, it does not have to do anything with the sense of the neutrality, because you're going to advantage your own industry rather than the foreign industries.
Right.
But Commission law does not differentiate according to its nationality.
Yeah.
So I think it is a very important difference.
Yeah,
between
yeah.
the two.
Competition law is secular, and going back to the Smartphone Act in Japan, you know, it doesn't cover Yahoo. There could be economic reasons for that, but Yahoo is still very much popular, but it's a Japanese company, right? And yet it's not covered. We have time for one more question, probably, so please don't be shy. Does anybody have another question? If not, maybe the other members of the panel want to answer what Payal asked previously. Thomas, would you like to? No obligation.
No, actually, I have a question about India. So I was thinking, okay, I mean, industrial policy or not, but I guess a justification for ex-ante regulation is that exposed enforcement is too slow. And I think India probably would be open to that criticism. I mean, from my understanding, the enforcement process is rather slow, and I think even whether CCI opens an investigation is subject to judicial review. Am I right?
Yeah.
Yeah.
And
So, I mean, do you think that in the context of India, at least, at least as far as that justification goes, there is a stronger justification than perhaps elsewhere on adopting an ex-ante regulation?
Thank you for that. I think that's a very valid point, but one person's slow is the other person's evidence-based. So, I think the speed of resolution is only one factor that I think should determine whether or not you introduce new laws. And we've had this draft, at least in the format that it exists. It's actually going to muddy the waters and create more confusion, because I just want to take one example because I think it's helpful, not only from the perspective of the kind of obligations, but also on the impact that it has on the cost of compliance and for consumers. One of the obligations that's been introduced right now is that a systemically significant digital enterprise, an SSD, should not cross-use data. The implication being you're trying to prevent leveraging. But there are at least 3 questions that I think we need to figure out how to answer. One is, we've all learned from the EU experience about cookie fatigue. And do we really want that in India? The second is, there's a reference to, and this goes back to the point I made earlier about the potential interplay between the Competition Act and other legislations. Now there's a reference to the the DPDP Act, which is the Digital Personal Data Protection Act, which only refers to natural persons, but the ex-ante law also refers to business users. So you don't really know what consent means in that way. And we have to look at what are the justifications for this. What if there is, there is consent for this kind of data to be used? Is there a problem over there? So I think there are multiple questions for which we don't really have the answers just yet. So if we're trying to create something which will resolve things in a faster way, I wonder if we'll then have to unscramble these things in the future, if we're just setting ourselves up. Yeah, and that's another question. So I think it could create more problems than it solves. And absolutely true that the speed of resolution is suboptimal because of the particularities of the Indian legal system. But I'm just not sure that this is the answer to that problem.
Well, thank you to my esteemed panelists, and please join me in giving them a round of applause.
Good afternoon, everyone. It is really a pleasure to introduce our next keynote speaker. It is Dr. Yijing Lin from our sister agency, the Ministry of Digital Affairs, MODA for short. Dr. Lin is currently the Deputy Minister of MODA. MODA is a very young agency within our government, but it is also a very important agency. It was launched in 2022 and is responsible for leading the country's digital transformation by overseeing IT, cybersecurity, and internet governance. And under Deputy Minister Lin's leadership, MODA is promoting secure infrastructure, digital innovation, and public engagement. And for those of you who have noticed, we have adjusted the time slot for keynote speak a little bit. It is because Dr. Lin is busy fighting for the future of AI in Taiwan this morning in our Congress. Dr. Lin has a BS degree in computer science and information engineering from the National Taiwan University. Actually, Dr. Lin and me, we went to the same university at the same year. And because he is truly a person with a vision, so he is so far-sighted enough to decide to go to the Department of Information Engineering. And I was so myopic enough to decide to be trained as a lawyer. So as you can see, that has made all the differences. Of course, I mean financially, yeah. So Dr. Lin continued to pursue a PhD degree from Brown University in the United States. And before joining the government service, he has over 30 years of experience in the software industry. He worked for IBM Watson Research Center in the United States, and also Compaq Manufacturing Company in Taiwan, and the Trend Micro, Taiwan and Japan. He was also the founder of the CEO of the L Labs in company. So truly a very successful entrepreneur. Without further ado, please join me to welcome our Deputy Minister Lin.
Thank you. Good afternoon. My apology that I'm late. My speech was scheduled at 2 o'clock this afternoon, and as said by Andy, that I had to go to the legislature's yuan, that's the Congress of Taiwan. And the good news is that we pushed the Taiwan AI Basic Law through the committee, and we'll send it to the floor, and hopefully very soon we are going to have an AI Basic Law. And that is highly related to my talk today. Today I'm going to talk about fair trade in the age of AI. Okay, so sorry, let me introduce myself again. I got my PhD in computer science from university, and I work for IBM and Compaq, and I made a small fortune during the internet bubble. So I started my own company, and my company used the artificial intelligence technology to teach people to speak English, Japanese, and Chinese. And then last year I got a phone call, and suddenly I became the Deputy Minister of Digital Affairs. That's not on my career plan. So, and sorry, I'm not, as you can see, I'm a computer scientist. I was trained as an engineer, and I was an entrepreneur, but I'm not a lawyer. And I'm not so familiar with the issues about fair trade. So when I got an invitation from Andy, I said, oh, gosh, this is a big challenge, but I'll do my best. The good news is that I'm quite familiar with AI, and I know that fair trade is something to do about monopoly. So today we're going to talk about, first, what is AI? And the second issue is that will AI threaten the survival of human beings? And then will AI superpowers turn into an AI monopoly? Okay, first, what is AI? Actually, the modern AI system is a simulation of our human brains. Okay, on the left-hand side, this is the neuron, or we call it brain cell. A brain cell has a big head. We call it and there's a nucleus, and there are small antenna called dendrites, or synapse. And it has a long tail called axon. And the synapse will connect to the axon of other neurons, other brain cells. And the brain cell will do a very simple, say, computation. You will sense how, what's the status of the other neurons, and if the other neuron, whether the other neurons are electrically charged or not. It will decide whether it will discharge electrically and send a message to other neurons. So the computer science simulate the human neurons using an artificial neuron. And the blue part is an artificial neuron, and the neurons will connect to other neurons. And you will get inputs from the output of other neurons, and it will do some very simple computation. Basically, it's a weighted sum, and decide whether it will, what the result it will send as an output. So the individual neuron is quite stupid. It is not intelligent. And the individual artificial neuron is also very stupid, quite dumb. It is not intelligent. But if we connect the neurons or artificial neurons together, it becomes very smart, just like you. Every one of you have neurons inside your brain, right? And you can think, you can learn. And the diagram above here is actually a drawing by a Spanish scientist, a doctor, actually a medical doctor in 1906. And because this work, he won the Nobel Prize in 1906. And on the bottom side is the structure of the artificial neural network. Okay, and when we listen, when we read, when we watch TV, the connection between our neurons will change. That is the process of learning. Actually, when I'm talking to you, the connections between your neurons, the brain cells inside the brain, will change their connection. That's the process of learning, human learning. And the artificial learning or machine learning is that the scientists, computer science, figure out a way to change the connection, actually the weights before the connections. When we send the artificial neural net, the input and output. If the output is correct, it will enhance, strengthen the existing link. If the output is not correct, it will try to weaken the links. Okay, this is the machine learning. Okay, and the funny thing is that in Taiwan we call computer 电脑, that's in Chinese. 电脑 actually means electronic brains. Okay, we have been calling computers 电脑 for like 50 years. But actually the traditional computers are not artificial brains, because the traditional computers or the traditional software is based on CPU, right? A central processing unit. But our brain do not have a CPU. Our brains have a lot of neurons. They are interconnected neurons. And now, for the first time in a scientific history, that we have the real 电脑, the electronic brain. The modern AI systems are actually the electronic brain. And the larger brain is, the smarter an animal is. We human beings are smarter than the monkeys. Why? Because we have larger brains. We have more connection in our brains. And monkeys are smarter than the mice because monkeys have more connection inside their brain. And a human being, each one of you have about 100 trillion connections in your brain. 100 trillion, okay? And the modern AI system, the LLM, like ChatGPT, has about 1 trillion connection, 1 trillion parameters. So we say, okay, we have 100 trillion connections, and the ChatGPT has only 1 trillion connection. So we are 100 times smarter than the AI system, right? Yes, that's true for the moment. But the problem is that we are human beings. Our ancestors 10,000 years ago have 100 trillion connections in their brain. And now we still have 100 trillion connections in our brain. And 10,000 years later, our descendants will still have 100 trillion connections in their brain. But a modern AI system, they grow at a rate of 10 times or 100 times per year. So if the modern AI system grows at 100 times per year, how many years does it require to catch up with a human? 1 year, right? And if it does not develop so quickly, let's say grows 10 times a year, how many years does it require to catch up with the human being? Well, just 2 years, because 10 times 10 is 100. So all the scientists believe that it will happen very soon that the artificial intelligence, the AI, will be smarter than we human beings. And actually, this is a diagram showing that ChatGPT-4 taking the exams. For example, the computer scientist asked ChatGPT-4 to take the uniform bar exam. That's the test for lawyers in the USA, right? And ChatGPT got the score of 298 out of 400 points. And as I know that in the United States, if you get more than 270 or 280 points, you can become a lawyer in each state. So ChatGPT-4 is smart enough to pass the bar exam and become a lawyer in the USA. And scientists also sent the ChatGPT-4 to take the SAT evidence-based reading and writing test, and got 710 points out of 800. And then the SAT math, it got 700 points out of 800. And then scientists sent ChatGPT-4 to take the SAT AP exam. I'm not sure if you're familiar with the AP exam. AP exam is basically a test for elite high school students. If a high school student can say pass the AP art history and get 4 or 5 points out of 5, then it shows that a student is as good as a freshman or sophomore in college in the field of art history. So the student does not have to take the course when he got into the college. And then ChatGPT-4 passed the art, history, biology, calculus, chemistry, all these topics. It always got 4 or 5 points. That means it is equivalent to a freshman or sophomore college student in most of these topics. And I know that most of you can pass several, like 4 or 5 topics and get 4 or 5 points. But I don't think anyone can get 4 or 5 points in all this exam. So in some sense, the ChatGPT-4 is smarter than human beings already, most of the human beings. Okay, and this is 2 years ago. The results come out 2 years ago. Sorry, I cannot find the most up-to-date documents, but if you are familiar with ChatGPT or Gemini or Cloud or Truck, you know that actually those modern AI systems are smarter than most college students, especially if you're a professor, right? Okay, so the question is, will AI threaten the survival of human beings? Okay, we know that AI won Nobel Prizes last year. Okay, on the left-hand side, this is Geoffrey Hinton. People call him the godfather of AI. He basically established the foundation of the modern AI systems. Okay, and for the last 5-10 years, Geoffrey Hinton kept saying that he felt like Robert Oppenheimer. Why? Because in the 1940s, Robert Oppenheimer led a group of top scientists to create an atomic bomb, right? And if you saw the movie, then you know that when the first atomic bomb exploded, all the scientists were so excited. That's a great achievement in science, right? And then suddenly Oppenheimer realized that he might create a monster, and the monster might destroy the human civilization. So for the next 5-10 years, he worked very hard trying to persuade the American government to postpone or stop the development of hydrogen bomb. But he failed. Why? Because that was during the first Cold War. And if the Americans did not develop the hydrogen bomb, who would do it? The USSR would definitely do that. So the American government did not have a choice, actually. They had to do it. Okay, similarly, Geoffrey Hinton led a group of top scientists in the 21st century to create a modern AI. And at first, all the scientists were so excited, including me. We were so excited, we created marvelous systems that's as smart as human being. And then suddenly, Geoffrey Hinton realized that he might create a monster that will destroy the human civilization. So for the next 5-10 years, he worked very hard, tried to persuade the American government and the EU to pause, just have a temporary pause of the AI development. He said they think that we need some time to think about that. The whole human race, we have to spend 6 months to think about whether this is the right thing to do. And this is Sam Altman. He's the founder of OpenAI. That's the creator of ChatGPT. A lot of scientists joined signed the petition. But again, Geoffrey Hinton and all these scientists failed because now we are getting into the so-called second Cold War. And if the USA do not work on the modern AI, who is going to do that? China. China is definitely going to do that. So there is no way that the USA will stop the development of AI. And we know that the one who controls AI will control the future, right? We know there is a kind of a trade war, a technology war between China and the USA. And the main battlefield is technology, the AI. And Mr. Donald Trump and Xi Jinping knows it very well that they cannot lose. So, okay, and then we know that AI believes in what it is trained with. You know, the traditional AI program, like 20 or 30 years ago when I wrote an AI system, the AI system got their knowledge from the program, the coding, and now the new AI system, because they work just like our human brain, they got their knowledge through training. We just send a lot of text, a lot of information to the artificial brain. That's the modern AI system, and it will learn, right? And so the modern AI system works just like a human student. Say, in the 1960s, we know that Chinese students joined how should I call it? Parade in Tiananmen Square. They chanted with a small red book in their hand, and they are, they want to support. They shouted the slogan to support Chairman Mao, and they believe in communism. They are true believers, and why? Because they were educated in a communist system, so they believe in a communism. And at the same time, in the 1960s, because the American students were educated in a democratic system, so they believe in freedom, they believe in equality, they believe in all the values of democracy. So the American students joined the what's the name of it? Civil rights. Yes, civil rights movement. Sorry, civil rights movement. So in the future, say, in the year 2040, the students are the artificial intelligence students. If we train the future AI students with the communism, then they will believe in communism. And if we train the AI system with the values of democracy, with freedom of speech, with rule of law, etc., then they will believe in what we believe. So, how can we win? Okay, the very simple answer is that the USA and Taiwan should work together, because the USA is an AI software superpower, and Taiwan is an AI hardware superpower. And actually, when about 10 months ago, I went to EU and I joined a conference, and I had some private conversation with top diplomats from EU and the USA, and also some top members of think tanks. And after I said that, an American friend said, jokingly said that, oh, okay, and there's EU. EU is the regulatory superpower. And at first I thought that European friends will be very upset, but actually they're not so upset, because they believe that, because nowadays the Americans and the Chinese are developing the AI system, recklessly. So there should be someone to regulate all this development. Otherwise, we're heading to a disaster. So the European friends think that that's their responsibility to regulate the development and safety of AI. And actually, that's highly related to our topic today. Should we regulate AI or not? Okay. Okay, so the third part of my talk is where AI superpowers turn into an AI monopoly. Okay. Do you know, are you familiar with a term called probability of doom? Okay. Because, when we join some Western-style banquet, we usually hold a glass of wine and we walk around and we will meet some new friend, right? And when we meet some new friend, we need to say something that's called icebreaker. And traditionally, the icebreaker is mostly about the weather. What do you think about the weather of Taiwan? It's hot and humid, right? That's an icebreaker, right? And now in Silicon Valley, if you join a party of the nerds, the computer science, the icebreaker is what is your probability of doom? That means what do you think the probability that AI will destroy the human civilization? If your probability of doom is the P of doom number is 100, that means you're 100% sure that AI will destroy our civilization. And if your P of doom is 0, that means you don't believe that will happen, right? And on average, actually some magazine, some computer scientist magazine made a survey, and most of the average in Silicon Valley is between 20 and 40, as I remember, and it all depends on the mood, because that's just, kind of just a guess. But it means that the computer scientists were so worried about these issues. Actually, here we can see a lot of movies, right? And these movies are all about a future war where the AI, dominate the world and threaten the survival of human beings. Okay, and I remember that about 30, or actually, 40 years ago when I was in college. Actually, that is already 40 years ago. Sometimes my friend will watch some, will see some of this movie, and like a Space Odyssey 2001, and they will come to me and say, Yijing, we are doomed, we are doomed. The AI system is going to take over the world, we are doomed. I say, oh, nonsense, that's nonsense. Because the AI system, or those AI systems are written by software engineers just like me. So we know every line of code in the AI system. So there is no way that the AI system will one day become smarter than we are. But nowadays, it is quite the opposite. Computer scientists like me, go around and I told my friend that, oh my God, there's a great danger that AI will threaten the human civilization. And my friends say, oh, Yijing, you must be drunken, They don't believe that. So that's quite the opposite. But what I want to say is that actually this is a very serious problem. And this is Eric Schmidt, the former CEO of Google. Recently, he joined an interview by TED, and he said, we might have to consider the time to unplug AI. There are 3 conditions. The first condition is that if the AI has direct access to weapons, if the AI, like a Terminator, right? The AI system got direct access to weapons. And the second condition is when the AI systems can reproduce themselves without our permission. They're reproducing their other AI system. Oh my God. Definitely we have to unplug the AI unplug, right? And third condition is the so-called recursive self-improvement. And what is recursive self-improvement? That means that AI will train AI, another next generation AI. Nowadays, say the ChatGPT 3.5 or ChatGPT 4.0, it was trained by computer scientists, right? And actually, ChatGPT 4 is trained by partly trained by ChatGPT 3.5. The earlier generation was Chen and next generation. And so the rumor had it that Chinese people developed Dae-Sik very quickly because they used ChatGPT to train Dae-Sik. But during this process, humans were involved. So that's not so-called recursive self-learning. The so-called recursive self-learning is that AI system will train their next generation, train their descendant automatically. So according to Eric Schmidt, at some point when the recursive learning becomes true, the AI system will become smarter and smarter very, very quickly. And suddenly, it is out of control. And of course, it is monopoly. Because whoever can develop this kind of system will dominate the world. So that's the first part. Okay. And as you might remember earlier, I showed this slide. And we said that Jerry Hinton, he won the Nobel Prize in Physics in 2024. And on the right-hand side, actually, this group of scientists won the Nobel Prize in Chemistry. And why? Actually, this is Mr. Hassabis. He's the founder of DeepMind. And he created a new system called AlphaFold. And what does AlphaFold do? It can decode the 3D structure of protein molecules. We know our body are made mostly by proteins, right? And the scientists now already know the sequence of each proteins. You know, the ATGC, yes, ATGC, okay. You know, the chromosome, we know the sequence, but we don't know the 3D structure. And this is a 3D structure of a protein molecule. And before AlphaFold, if you are a graduate student in the field of biology, if you can decode the 3D structure of one protein molecule, then you can get your PhD degree. So we say that one protein molecule per PhD thesis. Okay. And after AlphaFold, the AlphaFold decoded 200 million protein molecules in 1 year. Wow. That's wonderful news and terrible news. It's terrible news for the PhD students in that field, right? You might have been working for 4 years trying to decode the 3D structure of a protein molecule, and you're so close to it. And the next day, you wake up and found that AlphaFold already decoded 200 million protein molecules. Basically, that's all the protein molecules in the world. Okay, so AlphaFold can actually turn into a super monopoly if they choose to. Fortunately, Mr. Hassabis and their group are very kind people. They opened the AlphaFold to the whole industry. So my daughter is now in college doing some biology research, and she is now using the AlphaFold. And why the AlphaFold is so important? Because the protein molecule is quite huge, but there are only a few so-called active sites. The active site is a part of the molecule that can interact with the drugs. And traditional pharmaceutical companies will do trial and error. They try different kinds of chemicals on the proteins and see what kind of chemical will interact with the molecule. And nowadays, with the AlphaFold, they can predict the active sites, and they can predict the reaction of an active site with the chemicals. So that means, I think within a few years, the scientists may be able to develop new drugs 1,000 times faster or even 1 million times faster because, as we can see, this is 200 million times faster. Actually, no, actually, it takes 5 years to get a PhD, right? On average. So that's, 1 billion times faster. So the question, okay, should we regulate? Okay. As we said, that Europeans think that we have to regulate the use of artificial intelligence because there's a risk that artificial intelligence may threaten the human civilization. But the Americans take a different view. They feel that they always, traditionally, Americans think that regulation hinders innovation. So the American government under President Biden just issued some guidelines on how to use the AI system and a guideline to assess the risk of AI system. And after Mr. Donald Trump became the American president again in this year, he actually loosened the regulation again. So now, even the guidelines, some of the guidelines are scratched. So the big question is, for you all, or the people who are familiar with the regulation, the legal issues, is that to regulate or not to regulate? How should we regulate? That's a big challenge. Okay, thank you. Sorry, I'm kind of pessimistic. Okay, thank you. Any questions?
I think the Deputy Minister is generous enough to accommodate one or two questions. So suppose there is any question from the audience, it's time to raise your hand. Hi, Jeff.
Well, it may be a big question, but how do you think we should regulate? I mean, is it really possible if your objective is to stave off the end of humanity? Is there really any amount of regulation that's actually going to accomplish that?
Actually, the answer is very simple and straightforward. Yes, we have to regulate. Actually, that's the reason I went to the Congress this morning, right? We just passed, we just pushed the Taiwan AI Basic Law through the committee, and we hope we can send it to the floor next month. And our strategy in Taiwan is somewhere between the USA and the EU. The Ministry of Digital Affairs, that's our ministry, will publish some guideline, and we will try to pass the AI Basic Law, and the law will outline the basic principle about how should we use the AI and how should we estimate and control the risk of AI. But we will delegate the obligation to individual ministry to decide how to use AI. For example, for automatic car driving, we'll delegate the obligation to the Ministry of Transportation. They should pass some law to regulate the use of AI. Say if the AI car got into an accident, who should take the responsibility? Is that the driver or is that the car company? And similarly, if some doctor used the AI system to do the diagnosis, and if something happened and unfortunately the patient died, who should take the responsibility? Is that the doctor or the pharmaceutical company developing the AI system? So that's our basic strategy. Thank you.
Okay, by the way, if these competition issues, they will be our job. Okay.
Oh, yes.
Okay. So I just want to make a comment on that. Okay. Okay. Okay, Kevin.
Thanks for the excellent keynote. My question will be that how Taiwanese regulation will be effective on a more macro level, right? So the thing you just discussed is more detail, right? But on a high level, when U.S. is relaxing its regulation, how can Taiwanese regulation be effective at all? Because this is a global thing. If we are talking about the doom of human.
Okay. Yes. What is your probability of doom?
I guess I'm optimistic.
Okay.
Yeah. And by the time the AI take over, I probably already die. So.
Okay. Actually, that's a very difficult question because, as we said, that the dilemma of Oppenheimer and dilemma of Geoffrey Hinton. If we do not develop an AI system, then somebody else will do that. And if China win the AI battle, AI war, what will happen to the liberty, the liberty values we believe in? That's a big challenge, right? But if we keep working on the developing new AI system at this kind of pace, then we are in great danger. So our general, sorry, I'm learning to become a politician. So I have to say that we will strike a balance.
Thank you very much, Minister, for your great keynote. This is a bit of a geeky comment. The pictures that you showed on the slide when you talked about the end of the world from sci-fi, these were all instances in which AI became autonomous and enslaved or harvested humans, right? So in the case of Terminator, it was Skynet that became autonomous and self-conscious and then eradicated humanity.
Right.
In the case of Matrix, of course, it was machines that harvested humans. In the case of 2001, Space Odyssey, it was HAL, right? That also became self-conscious. So every time in sci-fi, the threat seems to come from self-consciousness, right? So I think that the way that you think about that also affects your probability of doom. I think it's more likely that we destroy our, if the world is going to come to an end, it's probably because humans use AI against each other.
Right.
That's a higher probability,
right.
I think, than that AI just becomes self-conscious and sort of eradicates us. So maybe how you conceptualize that also affects how you want to go about regulation, or maybe it's just me being geeky about those things. I had to react.
Okay. We can put the question of whether the modern AI system has self-conscious. Okay, I'm not so important, but Geoffrey Hinton is the godfather of AI. He said he believes that the modern AI already have self-conscious. When actually I think that's during his interview with the New York Times, and he said, he does not have any proof. It's very difficult to prove that the AI system have self-conscious, but Geoffrey Hinton, he's kind of pessimistic, just like me. And he said the modern AI already have a self-conscious. And when we try to unplug them, they will try to deceive us and try to say, oh, we are so nice, don't worry about it. That's what Geoffrey Hinton is thinking.
Thank you so much, Deputy Minister, for your very insightful and out-of-the-box observation of our competition policy. So please join me to thank Deputy Minister for his very excellent comments. Thank you. 谢谢, 谢谢. Now we are coming to the end of this event. I was told by Jeff to make the concluding remarks without any warning. But yeah, I know. So it's quite a challenge as all these very distinguished panelists comment on this very important issue. So I really do not have anything to say other than thank you all for participating in this event. Without you, this couldn't be possible. And I'm the acting chairperson right now for the Taiwan Fair Trade Commission. And the most important job for me right now is to moderate commissioner meeting every week. And as we are the collegiate system, so we have 5 commissioners right now. So all the cases, all the policy decisions need to be made at the least by the majority voting. And I believe I'm a very open-minded person. Of course, sometimes I could be stubborn and hard-headed to be convinced. But in general, I'm very open-minded to all the different opinions that will be raised in the commissioners' meeting. But there are two things that I emphasize most during our discussion. First, what is your analytical framework for a case, for your support or disagreement of a policy? You need to be clear about the framework that you use to analyze the issues. Second, we are an enforcement agency. We need a benchmark to make the final decision. You cannot just say, oh, okay, theoretically speaking, there are consumer welfare standard and there's a competitive price standard, so let's talk about that, and without coming to the conclusion. And in order to make the conclusion, you need a benchmark. Whether you like it or not, whether you are a proponent of the consumer welfare standard or the competitive process, you need to propose your reason why you support that or disagree with that. And I'm open to all kinds of conclusions they could make, but this is the two things I think is important. And that's the reason why I think this kind of conference, this kind of event is so important and vital and useful for any competition agency during their daily operation. So I would like to thank ICLOE again for your kind and generous support of this event. And especially I would like to thank Emily at the Rebecca of the Stadium. Thank you for your coordination effort and all the hard work you devoted to this event. Okay, I think the debates regarding today's theme, be it dynamic competition or industry policy or competition or even the reviewing standard will continue. But I think open-minded is very important, and we are open to all kinds of opinion debates. So we look forward to the future events like this in Taiwan, maybe. Okay, see you next year, okay. Thank you so much. And we have this champagne reception, okay? Thank you so much. Thank you for your participation.